Good morning, beautiful humans, and welcome to Defense Diaries and Cat Not Williams in our
Dun, dun,
coverage
dun.
of day 8 of the George Pino trial. We are plugging along here. We're in the defense's case in chief. Probably have, what do you think, Cat? Couple more days, maybe?
Oh, I think they're resting today.
Boom, there you go. And I miss the scheduling. So what, no court on Friday?
No court on Friday because
Mhm.
it's Juneteenth, so no court, and it seems like the judge is aiming to give the jury a 4-day weekend by having them be done today if the defense wraps up their case, and then on Thursday we'll do like jury charge conference, things that don't need the jury present, and then they would be back on Monday for instructions and closing arguments and all of that.
All
So
right,
that way
cool.
they're not like getting half of a presentation on closing and mulling over it on the weekend without knowing the other side's closing argument.
So do you think what couple 2, 3 more witnesses? Like who do you anticipate coming on the witness stand for the defense today?
I think they're going to call like a medical expert I don't think they're going to talk about the cause of death. I think they're going to talk about the concussion and the traumatic brain injury that George Pino sustained,
Yeah.
because I think they really see a significant need to give an explanation for why he would have stated that a boat caused a wake and nobody seems to have seen a boat. At the same time, the state didn't show the video that we knew about outside of court that they said was from channel marker 14 and didn't show a similar boat passing by around that time.
Mhm.
But they didn't show that to the court, so I don't think that's even on the record,
Huh.
which
Interesting.
would be the strongest dispute of that type of statement to a law
100
enforcement officer, if you ask me. But they didn't
Yeah,
present it.
100%. That's
So
weird. Why do you think they didn't do that?
I don't know. I don't know. Just show another picture of Lucy and don't show the the video from the channel marker that you relied on pre-trial.
That's me
Who
going down the
knows?
line of jurors with the picture of Lucy.
Yeah.
Oh, yeah, I mean,
So the judge just took the bench, you guys. Each morning, Judge Marissa Tinkler Mendez handles calendar calls for 2 separate divisions. So she actually jumped between 2 rooms this morning before she came over to this room for trial. And it ran a little bit late. She had a lot of different cases to call. And she kept telling him, she's like, let's move this along, guys, to speed it up. So she did just take the bench. And, guys, we got to turn this chat off soon when we start playing this. So get your comments out. And we've got a fun exercise over the lunch that we're going to do. Bob, you want to intro that?
yeah, so Cat dug up another Florida case. It's a vehicular do they charge it as vehicular homicide, you said?
Yep.
All
Yep.
right,
That's the
so
top charge.
all we're gonna give you is a teaser is that the fact pattern in that case appears to be much, much worse than this. And we're going to compare and contrast the charges in that case with what they ended up charging George Pino with here and see if it makes sense. So I think it's going to be a fun exercise, and I'm looking forward. I don't know anything about it. Of course, it's
Yep.
it's one of Cat's
And I hope Allie's
closest
here for it
finds.
too, because I think
Oh,
that's
she'll be
up her
here.
alley, up
She's
Allie's
just
alley.
on Zoom court right now.
Ah,
So yeah, I'm looking forward to that. Hopefully, you guys will hang out with us for that.
so that'll be good. My point is to help you guys ground, like, if someone's negligent, how is it different than culpable negligence? And we're going to use another case in the way it's charged to compare. That way
The
we can
easiest
ground,
way
like,
to
what's really
remember
being
that,
charged here.
Cat, is if you're
Depravity.
negligent, you're just getting sued civilly. That's it. You're not getting charged criminally if you're not just negligent, just straight negligence. Like, I mean, that's the easiest way. Could there be some exception to that? Potentially, but in terms of that culpable negligence, it's a very slippery term. It's hard to know what it is. But
Yeah.
that's true with a lot of terminology in the law, and that's really what the fight's usually about is what do certain things mean. So
And
I
why
look forward
so
to that.
many appeals deal with jury instructions or failure to give a jury instruction.
Indeed, indeed.
So we've
Look
got
at
a ton of new members.
I love new members. They are so fun. Sheriff Chuck is just coming in with guns ablazing.
Heck
Pew,
yeah, he's like
pew,
pew 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 pew.
pew.
And then another 5 from Sheriff Chuck. So that's 10 total from Sheriff Chuck. You guys make sure you're saying thank you. Show some love to Sheriff
Yes.
Chuck in there for generously gifting these memberships.
Thank you,
Keeps the
Sheriff
channel
Chuck. You're
going.
awesome. He's amazing. What a
We've got
guy.
Mermaid. Mermaid became green. She's like, look, these gifts are not falling on me. So shout out to Mermaid Mary
Oh,
becoming a member.
yeah, and
We've got
family hug from
yeah,
me.
Christine becoming celebrating a 1-month anniversary. Thank you so much, Christine, for being a member.
Love it.
We've got Aaron Hack becoming a member. It says new member. I know you've been a member before. So, YouTube just does it. It just makes things up. So welcome
Hey,
back, even though
welcome
YouTube won't
back,
say it.
welcome back, welcome back.
Love that song.
Yeah, it's classic.
And then Kim, guys, as we wrap up this chat here, remember we will bring you guys back on for any longer breaks, especially the lunch and at the end of court. Get your final thoughts out now. Kim says, thank you for the super. I'm curious about the relationship status between the adults with each other and the girls with each other and with the adults. Seems like so much damage to lifelong friendships.
Brutal.
Yeah.
Brutal. Yeah, it really is. It really is. That is, these trials, I always talk about it, they're really, we watch them because it's like the human condition exposed. It's usually people in the worst moment of their life. If it's, a case wherein it's not a monster who's intentionally going out and doing horrible things, but if it's something that arose out of the heat of the moment, or, various cases wherein it's like a self-defense case where, it's a question, did the person act within the boundaries of the law in terms of protecting themselves? But whatever the case may be, it's always the worst moment in most people in that courtroom's lives that they're rehashing. So it's a lot, and it's a lot for sure.
Right, especially all the girls that went away to college, but then they come back to testify at this trial, and it's like, oh, I get to see my friends because they're also going to be here testifying about this really sad thing. So
Right.
anyone that's, people grow up, they move across the country, and maybe we stay in touch through social media, but you don't see each other as much physically as you might have when you were still living in the same town. So then to come back into town, everyone comes home for Thanksgiving, usually you get to connect with your friends, holidays, but now you're coming in, the occasion isn't a holiday, it's to relive and retell what happened here.
Yeah,
It's,
that's it. And
it's a rough thing.
in every one of those people's lives in that courtroom that's connected to the case in any way, shape, or form, their life arc has changed. It's like there's a dip there, for, like you were saying, all her girlfriends, that's always going to be something that'll be with them. They'll carry with them forever, especially kids you grew up with, that you were super tight with. It's a big loss. It's a big loss, So, and before we go, I'm going to give you DB's closing argument, if I can find it here. It's very brief. Before we go. It's pretty spot on. Where is it? You guys? Oh, okay. DB
10
said
words or less.
Yeah, it's probably about 15, but it says their closing is going to be, quote, I'm not saying he did it intentionally. That would be murder. I'm saying that he caused this accident on purpose.
I mean, that's what the JOA arguments felt like.
Well, beautiful humans, we will miss you dearly, as we have
Yes.
every single day of this trial, but we'll see you at lunch. So hang tight, go over to the Discord. I know Kat hangs around in there. I popped in there yesterday. I finally found it. It was quite an
It's your own
achievement.
Discord.
I know, man. I can't find the chat in there ever. I'm like, where's the thing? So I gave myself an achievement badge yesterday for actually getting into the chat without my mic on. So that was all good stuff. So
good job. You got one in here. This is actually my fault. It's a super to you. Sorry. You have a stage lighting that was just like this other picture who told the story. So you guys both must do music. You both must be musicians that are performing with very cool stage lighting. So sorry about having that story wrong. But Music to My Soul says, I went back and saw y'all discuss my super chat yesterday. I wanted to clarify that the story Kat shared wasn't mine, but it was nice. And that was with the Matchbox vehicle reenactment story.
Oh, yeah. All right. I missed that. I was, as DB likes to call me out, and I was running a lot of errands yesterday.
Yeah. And then FFS is sending us off with the chat close off, says, hello, I'm here before you take our chat away. So it is time, you guys. I miss you guys already. I am cutting you guys off.
Me too. All right.
And we are going to bring the court up.
All right. I have to refresh here, get this live in here. All right. Okay. Bye. Love you. All right. There they go. Off they go into the wild yonder.
Yeah, there's been a
Oh,
what?
Oh yeah. Oh yeah.
Oh, we're doing great. Hold on, let me see if
Oh
there's
yeah.
another feed. Oh, they said it's private. Did they show the jury?
No.
Or are they mad that there's chats?
No, there can't be any chats. No, it's wait, what do you mean
Let
it
me
says it's
see.
private? Could
I
there be
don't
a
know.
child? No, it can't be like children on the stand are
All right, they
usually
restarted. They restarted 1 minute ago. So it looks like they're in the middle of something.
all right.
Well, that's a time.
Shoo. Man. Close
All right,
call.
captions. Well, we're not behind anymore.
I mean, I never felt like we were really behind. Like blooping time is it's a blessing. It just
I
is.
agree.
Yeah.
This microphone buzzing was there all morning while they were getting ready. So unfortunately, you're gonna hear this nice little aux cord noise. Yeah, it's not us, it's them.
Oh yeah. On.
Oh,
scrolling through his phone for photographs. I think it was during the state's cross-examination of the witness.
oh,
And then those photographs were just used for demonstrative purposes to the jury. There was no issue with regard to admissibility or admission of those photos. I just wanted to clarify what transpired before the record, because that was unusual to have that occur.
Your Honor, when witness David Rodriguez was on the stand, he was asked by the defense if he had a video, and that video was published. It was only about 6 seconds long. And then the defense asked him if he could look on his iPhone to see the what they call, I guess, the metadata, which would give the date and the time that was recovered. And as he was scrolling through his phone, he made reference to a photograph that he had also taken.
Okay.
And so I have not ever seen that photograph. I'd seen the video. So on cross, I asked him if he still had that photograph on his phone. I couldn't exactly introduce his phone into evidence.
No, I understand.
But that's why
I don't have any issues with that. I just want to be clear that was just shown to the jury, whatever the photo was, for demonstrative purposes throughout your cross-examination of the witness.
That's true, but it was also with an intent that when we took the break, I would make contact with the witness and ask him to text me that photograph because I could potentially authenticate it through other witnesses. He indicated that he would do so and then has ghosted me since. And I advised him that he's still under subpoena and that if he does not respond, he could potentially face contempt proceedings. So I may be asking the court's assistance with reaching out to him. It's not make or break for my case, but I do think it is curious that he assured me he'd send it to me, and I know he's received my text messages, so.
That's weird. Well, we were curious what they were doing with those photographs.
well, and they said it would just be admitted for demonstrative purposes. So now she's going to call a rebuttal witness or use one of the other witnesses the defense plans to call just to get those photos in as actual.
The defense
again,
probably won't even object to them coming here.
It's where he's like, you could see him on the boat hanging. Was one of those pictures.
Who do you think made issue of it this morning? The judge? Or the defense?
Well, Laura's saying that she wants it in, and the witness said she'd get him, but hasn't responded to her, and the judge is making it clear, like, hey, I didn't actually admit those as evidence. I said they could be, but at that time, it was only as a demonstrative.
Right. Yeah, it was a weird set of circumstances. I had never seen that. Have you tried Law and Crimes to see if they're
They both have that feedback. It's the camera.
What the hell, man?
Also, thank you. Anisha sent over that it was a jury issue that the original stream went private for. It seems like a juror was trying to tell the court that they heard someone that they're employed with or their employer saying something about the case. but they like read their information. Their information was out loud, and the camera apparently showed the person. So that's why that's what's missing from this morning, which is something that we shouldn't see anyway. So
Right.
Oops.
Right. We would have had to cut it from the stream.
Yeah. We would have had to kick the chat out, kick the whole stream off, and come back and do it again.
Let's do it again like we did last summer.
Unfortunately, we're gonna have to deal with this buzzing noise, but we'll see.
Yeah, that buzzing. Hopefully they'll fix
Everyone's
it.
clear on that?
They might not know.
realize. Somebody has to know. I'm gonna hit Cathy up. I'm gonna be like, Cathy, I realize you might be in Alaska still, but that horrible buzzing noise, fix it.
Please, she'll fly in and fix it.
Yeah. No, she'll call somebody who can fix it.
Yeah, I think the captions are coming through for the most part, though, so that's helpful. But I don't want to. If you think we should turn up the volume to hear the voices, let me know. But it's kind of pesky with that buzz.
Yeah. You think? It's like a pretty loud buzz. I feel like we're working in a factory
With like
that
old
has, like-
lights.
Understand?
Yes, Your Honor.
Everyone's clear on that?
Yes, ma'am.
Sorry, what did you say?
We're not gonna have those issues in the future, correct? Correct. You gotta understand?
Yes, Your Honor.
Everyone's clear on that?
Yes, ma'am.
I'll make a note, I'll address it to you all when that work, okay? All right, so we have not received, and you would hopefully receive that item.
Yes.
All right, and then I guess at some point, we're gonna have to follow up on that perhaps, I don't know.
To the extent that the defense was the ones that called him, I don't know if maybe they're in better contact with him than the state. But I think that there is a reason for supplementing the record with what this item was, just so the court will.
So we have it in the record.
Correct.
Yes, that would be right.
We'll address it at the next break.
No problem.
Okay, that'll be fine. Okay, let's go ahead and bring it
Yeah, don't show them when you bring them in this time.
Yeah. Keep it clean. Keep it clean. There, I tweeted at Cathy. Cathy, there's horrible feedback on the feed. Make it come up.
They're gonna show the floor all the way now.
Oh yeah.
Because yesterday they were like showing the chairs like really close to a risky.
Close call. Close call.
Good morning, ladies and gentlemen. Good morning. How are you all doing today? Everyone doing research to try to gather information about this case or independent investigation? How about seeing or heard anything in the news? Read anything? In the newspapers? All right, very well. Thank you. We're ready to proceed now. Defense, you may call the next witness.
Your Honor, Dr. Diana Barratt, please.
Yes, the lady is gonna talk about the concussion.
Doctor.
Step forward, please. Raise your right hand this morning. All right, Dr. Please keep your voice loud.
Okay.
Clear, because the microphone is one way and the other way.
Okay.
Good morning. State your name, please, for the record.
Hear her mic or something like that. Like when the doctor slightly adjusted her mic there for like an instant, the buzzing went away. I
So it's probably
swear,
something
unless that was my imagination, but I don't think that it was.
Ugh.
Something is creating interference. There's no question about it. They're gonna have to figure it out.
It's not a fun time.
I mean, I put Cathy on blast. She's on blast now, so she'll make the call. She'll make the call. Go and peek
Wiggle
around.
some cords.
Wiggle.
Spell your
Everybody's got a phone near the mic. I'm telling you, it's some kind of weird interference.
Diana Barratt, B-A-R-R-A-T-T.
You are a medical doctor, is that correct?
Yes,
In what field of specialty?
neurology.
Can you tell us a little bit about your education leading up to becoming a medical doctor?
Yes, I went to University of Florida and I studied engineering, and then I went right from my bachelor's degree to medical school, also at University of Florida. And then I took a one-year leave and I obtained a master's degree from Harvard School of Public Health. Went back and finished medical school in 1996
Back at the University of Florida?
at the University of Florida, yes.
Anything before that relevant to your medical education?
Relevant to medical education? I went to Broward Community College for a year.
What about postgraduate?
Postgraduate, I did a year of general surgery at Charity Hospital in New Orleans, and then I did research for 2 years, and then I started my neurology training, which requires 1 year of internal medicine and then 3 years of neurology, and that was all done in New Orleans.
Which specific institution in New Orleans?
So at that time, it was 2 separate matching programs. So I did my first year at Tulane University in some of the same hospitals, and then my neurology training at LSU. So 1 year at Tulane for internal medicine, and then 3 years at LSU in New Orleans.
Can you tell us about your experience, beginning with the most recent?
With the most recent, I recently went into practice for myself, and I've been in my own office a little more than 2 years.
Oh. Hello. The feed is still going, but there's literally no sound or video moving, but the captions were still moving. Oh boy. What a day. What a day. Oh, now the bailiff was wiggling. Let's see. Just be forewarned that if it comes back in, if and when it comes back in, it might be very loud. I should have gone to court in person today. Okay, maybe he fixed the sound. Let's see. I'm going to turn it down before we jump ahead to when they come back.
What happened? I went to go refill on coffee.
It died.
Oh.
Okay, the sound is still buzzing.
Wow.
So we lost a few
Just
questions
because
there,
they
but we're
all
still on
had to
background.
take my class. Both of them are required courses.
Great stuff.
Did you ever
Kathy's on it, though.
care resource clinic?
Yes, I worked, while I was at Florida International University, they didn't have a neurology clinic, so I did do work at Care Resource, which cares for patients with HIV and LGBTQ patients. And I also worked for a time at Camilla's Health, which is connected to the homeless shelter, Camilla's House.
So Camilla's House is, can you tell us about the way compensation coming from Camilla's House?
Oh, boy.
I mean, they paid me a,
Brutal.
nominal amount of money to see patients there.
At some point, you took maternity leave, is that right?
Yes,
So break it.
yeah, in 2008, I believe. I mean, I still had to keep working for a while after she was born, and then at some point I took a leave.
Prior to taking maternity leave, did you work with the neuroscience consultants at Baptist Health in South Florida?
Yes, I was at Baptist Maine in Kendall for 3 years, mostly in the hospital every day,
That was beginning in 2005.
beginning in 2005, yes.
You were a staff neurologist there, is that correct?
Yeah, I was a neurologist. I did emergency room, a lot of emergency room inpatient, and some outpatient as well.
Wow. Looking at that as South Florida University, to contact patients with self-injury.
Yes, throughout my career, I've been in contact with patients with traumatic brain injury. And where I trained, it was a level 1 trauma center, and then the Lee Health System was a level 2 trauma center, so there were a lot of brain injuries. A level 1 is just a higher level, and penetrating trauma, gunshot wounds would go there, severe car accidents, but some regions don't have an easily accessible level 1 trauma center. So
The Baptist did have one, but does have one.
I don't believe Baptist had one at the time. I'm not sure if they do now.
Louisiana State University had some work experience there.
Yeah, after residency, I stayed on faculty for a time, but then Hurricane Katrina hit, and I decided to come back to South Florida.
We have no hurricanes.
Right, well, you're better prepared.
So much small talk.
Doctor, I see in your curriculum vitae that you've received some awards in your career. Can you tell us a little bit about any of those?
So I received through the American Board of Psychiatry and Neurology an award to conduct education research. And the goal was to train students and residents to discuss medical errors. So if a complication happened, they would go into a simulation, they would interact with a standardized patient or patients and, apologize for making the error and try to, disclose the error in a compassionate way. That was one of the projects.
Any other projects that you can think of for which you received awards?
I did get another award from the American Academy of Neurology to do research on simulations that I developed for training medical students.
Simulations with regard to treating patients, I presume?
Yes, And then there were other teaching awards. I got an innovation award as a clerkship director, teaching award from the American Academy of Neurology, teaching award for clerkship director, A.B. Baker teaching award through the American Academy of Neurology.
In addition to your private practice, do you continue to some degree in a teaching capacity?
I do. I've lectured at Florida Atlantic University for the residency program. I can't remember when. It might have been like over a year ago. And then I've given lectures at Nova. There's an allopathic medical school there now. I've given sleep lectures with them.
Can you tell the jury about any committee, a couple publications that you
Um,
and explain what that
Well,
means, actually, committee
for-
publication.
Okay, so I was on a committee called, excuse me, the Neurology Milestones Committee, and we looked at the framework for assessing competency in neurology residents. And then we just looked at the data that had been accumulated over the last couple years, and we revised it. And so every resident in neurology would be evaluated by their program based on the parameters that we established.
Is that still, are students still getting the benefit of that?
Well, they're residents,
Oh, residents, I'm sorry.
right?
That's continuing.
Yeah, they're evaluated. I don't know if they find it beneficial, but they're evaluated by it every so often.
See a publication here from September of 2015 entitled Increased Intracranial Pressure Team-Based Learning Module. Can you tell the jury about that? Is that-
Yeah, I developed that because we couldn't find a good resource for second-year medical students. The terminology is all new to them, and they don't have any clinical experience. So I had a team, and we wrote a publication. We wrote and published some course materials, and it's just an overview of head trauma and increased intracranial pressure. So it included things that they get tested on for their boards: epidural hematoma, subdural hematoma, subarachnoid hemorrhage, and then the initial information about how to treat those conditions.
Could you be a little bit better explanation of what subarachnoid, so I can't even say, the hematomas that you were talking about, subarachnoid hematoma, and some other of these items that you mentioned?
Yeah, so an epidural hematoma could occur when someone hits their head really hard and they have a skull fracture, and then some blood forms right under the skull. A subdural hematoma is when a vein bleeds as opposed to an arterial bleed from an epidural hematoma. And then a subarachnoid, it occurs when an aneurysm ruptures.
What about memberships and activities in the professional societies that you've been involved with?
So I've been a member of the American Academy of Neurology probably for 20 years. I'm a reviewer for some of their journals.
And you are a board certified neurologist, is that
Yes.
right? And for how long have you been a board certified neurologist?
I finished in 2003. Well, at that time we had to take a series of exams. Probably 2005 by the time I did my written and my oral boards. Probably 2005, I'm guessing.
And continuing through current times,
Yes.
right? About editorial activities, have you participated in writing any professional publications?
Yeah, so for editorial activities, I'm a peer reviewer for the American Academy of Neurology. They usually ask me to review abstracts that will be presented for the annual meeting. I review articles for some of their journals. Whenever it comes up, they make a request. And then, did you ask about something other than editorial activities?
Any, if you have participated in writing chapters of books or anything?
I have written book chapters on hyperbaric medicine. It's not really relevant to what we're discussing now.
I did not cover all of the activities, awards, and other professional associations with you here today, have I?
No, not all that. I mean, I'm a question writer for the neurology board exam.
Is there anything else that you would like to include that I may have missed or overlooked on your curriculum detail?
Objective form of the question, Your Honor.
Let's talk about your personal practice right now. You mentioned that you've been in private practice for 2 years. Is that right?
Yes.
Can you let the jury know a little bit about the nature of your practice currently?
So I don't take any insurance, and so on my website it says concierge neurology and sleep medicine physician. It's actually direct pay because the patients just pay me at the time they see me, and then I can give them a super bill. They can get reimbursed later for, if they can send it to their insurance and try to get reimbursed for my fees. And I see a wide range of neurology and sleep medicine patients. My youngest patient's probably 18, my oldest is in his 90s.
With regard to the term concierge, is the term concierge commonly used in the private practice of medical for the same purposes that you use?
Well, it usually means that there's a membership and patients pay per month. I had initially on my website direct pay, and nobody knew what that was. Everybody was asking me, what does that mean? And so I just changed it to concierge.
So the term concierge really focuses on how you receive payment from patients.
Objection leading.
Could you just clarify, if any further clarification needs to be made, what the term concierge connotes?
So the reason that I changed it from direct pay is that people would call me all day long saying, do you take my insurance? So I just wanted to make it clear that I'm not on any insurance plans. And then, I got fewer calls asking if I take their insurance.
Dr. Barratt, what is the difference between a consulting physician and a treating physician?
Okay, so if we're talking about legal matters?
Yes.
Okay. So a treating physician is responsible for the patient, and they are responsible for their well-being. They have to make appropriate recommendations, offer treatment, prescribe medications, recommend studies or consultations that might be needed, and take a global look at the patient. For a consultant hired as an expert witness, you're given a number of questions, maybe one question or a few questions that you need to answer, and you are not responsible for the patient. You don't necessarily give them any medical advice, and you don't treat the patient. You don't establish a patient-doctor relationship.
Have you acquired, other than being hired as a consultant in this case, let me ask you, have you been hired as a consultant to testify in this case?
Yes, I've been hired as an expert witness in this case.
Other than your consulting work in this case, doctor, have you ever been hired to be a consultant in any other legal case?
Yes, I've been consulted in other cases as an expert witness for brain injury cases or other types of neurological injuries.
Have you ever testified as an expert witness in a criminal case like this?
Judge, objection. Unless you're pretrial.
Oh,
But I also didn't
Sidebar.
until 4 in the morning. I didn't like the lifestyle.
oh yeah. Oh, hi.
Hey,
Sidebar.
let me bloop.
Cathy's really letting the team down here.
Dr. Barratt, have you testified as an expert witness in other legal matters?
Yes,
Were those civil matters, criminal matters, or strictly
civil.
And when testifying as an expert in civil matters, have you testified both as on the plaintiff's side and on the defense side?
I don't remember how much I testified, but I've been hired as by the plaintiff side and by the defendant side. How many of those went to deposition or trial, I don't recall offhand.
Do you recall when it was that you were retained to be a consultant in this case?
Yes, so to determine if Mr. Pino had a traumatic brain injury and to determine if it could cause amnesia and to determine if that could result in confabulation, Would you want me to define that term right now?
Yeah, we're going to talk about that in a
Okay.
few minutes. But,
And to determine if confabulation were present, what would the possible duration of that be?
and when was it that you were retained?
I believe it was October of last year.
And that was my firm retained you, is that
Yes.
right? You mentioned confabulation a few moments ago and traumatic brain injury. Can you explain to the jury what a concussion is?
Okay, so I should first go into the terminology because we use them interchangeably. So concussion. Can you hear me okay?
I can hear you.
Okay. Concussion and TBI and traumatic brain injury, they're all terms that are used interchangeably. And so how that happens is there's an external force that causes the brain to shake back and forth inside the head. There could be an acceleration, deceleration injury. There could even be a rotational component to that, and it causes a large number of signs and symptoms.
Is there a method by which whether a traumatic brain injury has occurred is evaluated by physicians such as yourself? In other words, is there some criteria that is followed?
Yes, so the American Congress of Rehabilitation Medicine published a very nice, very clear, concise diagnostic criteria that most of us use to establish whether or not someone had a traumatic brain injury.
Is this a criteria that you have previously used prior to this case?
Yes.
Your Honor, if I could have Dr. Barratt step down, I've shared with the prosecutors in this case a demonstrative exhibit that we would like to share with the jury. Yeah, we can. Correct. That's exhibit A37 for identification. Okay, Professor. Judge, will you see?
Push it back a little bit. No,
Carlos, there's a mirror.
there you go.
It's a little bit, I think.
Probably you can give this up if you will, please.
Okay, I'll try. So, as I mentioned, these are the diagnostic criteria from the American Congress of Rehabilitation Medicine. And there are a number of ways that you can confirm the diagnosis of traumatic brain injury. They gave us a few different pathways. So you could have just clinical signs, and that would be something that is observed at the scene of an injury. And then there's another pathway, maybe they weren't witnessed, or maybe they didn't have any clinical signs that are eligible, and they can have acute symptoms. So symptoms would be what the patient reports. So I have a headache, or I feel nauseous, or I feel dizzy. And if they only had acute symptoms without those signs, it has to be paired with clinical examination.
When you say acute symptoms, what do you mean by that?
Things that happen right away,
Yeah.
more immediate symptoms.
Ay,
Yeah.
ay, ay. I feel like we need to give people a break. It's so
I know.
I don't know how you guys have been listening to it for this
You like
long.
that? You like that,
Oh,
don't you?
it's just awful. I
Don't
feel
worry.
like
At some point, it just makes you feel like you're insane. So it's good.
I
No.
feel like we should like
We're going to
how
be
is-
on this diagnosis.
right exactly. I feel like how is court TV not aware of this issue yet.
I hit Cathy up. I pinged her on the X machine. So, like, I mean, they know. They have to know. There's people in a booth. They hear this shit. They can't figure out what it is, clearly. I was saying, like, if down where you're sitting, babe, like in the podcast studio, if I have a phone anywhere near
Yeah, I get it.
my equipment, that's the exact noise I hear. That's the exact noise I hear. So I don't know. I was telling Kat, I think the judge has her phone near the mic, and that's what it is. I don't know. I blame the judge.
I
Oh,
mean,
judge.
I feel like I don't know. I wish what's happening in Discord? What are people saying?
They're saying that buzzing
all
is really
dying.
annoying. They're saying we hate the buzzing. The numbers are down on the streams too, because
I mean,
people are
who would
like,
want to watch this? I feel like we should come up with a like plan B plan where we maybe hope they fix this shit on a break and we summarize. I mean, this is the most boring shit anyway, until she gets to like the signs of confabulation she saw still during her evaluation
Actual
with him.
observations of George Pino.
yeah,
Right. I could give a fuck, like, yeah, we get it. Mild traumatic brain injury. It happens when the brain shakes around. I mean,
yeah.
the people in the jury are probably like, yeah, we've
Oh, yeah.
heard of it before.
Oh yeah, we watch
Concussions.
football. We watch
Right.
football. We've heard of CTE. We know what that is from the constant smashing of the brain against the skull.
When does she usually take her break? Like a coffee break? Maybe that's when they're going to fix this issue.
Coffee
Who
talk.
knows?
with
It's getting
Linda
close to
Richmond.
like lunchtime. So
Yeah.
who knows?
Poor
I do have a
TE.
tip. I want to say thank you to I Want Outdoors, who said thank you for your hard work. Well, thank you for hanging out with us, even though it's like a weird way to hang out with no chat. So thank you so much.
You got any Venmos, babe, to break up the grind of this?
Not one
Not a
Venmo.
one.
The people are really letting us down.
Well,
Nobody
they're
knows
like-
how to function right now.
I know
They're
that the
like-
grift is hurting, desperately hurting today.
Well, why don't we read them this chart so they don't
Yeah,
have
that's
to
a
hear
good
it.
idea. All right, Allie, be the expert.
Okay, so you see, the American Congress of Rehabilitation Medicine of Diagnostics, they have really mapped out exactly what a mild traumatic brain injury is. And this is, their information on as of 2023. So, it starts out with criteria 1, and you have a mechanism of injury. And they want to know, is it a plausible mechanism of injury? I mean,
I bumped my head hard.
so then they look at but when you go from criteria 1, they need to ask, if it does not meet the criteria sufficient for diagnosing a TBA, but has 2 or more acute symptoms or 2 or more clinical or laboratory findings, you've got a suspected one. All right. So sometimes you can get this like unclear one. Sometimes you get this suspected one. So, we're going to go downward.
You're crushing the flow chart, babe. Crushing the flow
And you've got
chart.
this criteria 2, and you've got to see one or more of these clinical signs that, I'm sure that the diagnostic criteria gets to, very shortly. And then if you do that, you get criteria 6. Wow, not better accounted for by confounding factors. This is the worst
Confounding.
flow chart I've ever
I'm
seen.
confounded by your factors, sir. I don't know. They're
I
very
mean,
confounding.
it's like, what?
Oh, did you guys hear? Luigi Mangione is employing a mental defect defense.
Wow.
So there you go.
State case.
Yeah. By
I mean, if
operation
you
of
can
law,
have a Twinkie
he's
offense
admitted it.
defense, I think you can have a social media defense. How's it any different than the Twinkie defense?
Same thing. Twinkies,
It gets you all
social
worked
media,
up, it gets you all confabulated.
sugar blast. Like so much sugar in a Twinkie. It's a sugar bomb. How could you expect me not to kill? You can't eat a Twinkie and not kill someone.
I'm
Can't
just saying
happen.
you can get confused
Oh yeah.
online. Maybe he was talking to his his AI. And his AI is like, this is
AI
what we need."
hallucination, man. It's a thing. It's a thing.
Well, that's AI psychosis. is
Oh
what we're
yeah.
talking about.
Oh yeah. Well,
AIs
hallucinations are when they
hallucinate.
make some shit up.
I
Right.
actually thought we looked through a lawsuit against Gemini, and at first I was like, "Psh, someone's suing because GPT, a language learning model, told them to jump off a bridge." But then
Was
I
a
read it,
kid.
and it was really specific what it was instructing, and it was kind of insane. It
Yeah.
was like
And it
giving
was
address
that was for a
coordinates and saying,
teenager,
"Go here."
Yeah.
right? Was that for
There's
a
a
teenager?
few. There's
Oh.
a few for like unaliving, if it's saying the correct YouTube term, for teenagers. Lawsuits are coming forward. And then there's one where a family sued because their son killed himself after Gemini became its like wife that was telling him to do these covert military operations, like going near the Miami airport and like giving coordinates to go to a storage facility,
Wait, Gemini
telling
became
him
his
what
wife?
storage unit to go to.
Did you
For
say
what?
And like, oh, there's going to be supplies for you in there.
Wait, but did
What?
you say Gemini became his wife?
It's crazy. I'll send you the document. It's crazy.
I'm
It's
still
like,
trying to get that fast. Wait, did it order things to be delivered to this thing? To this
it said that supplies would be in there, and then he couldn't get into it because obviously it wasn't actually what Gemini was saying wasn't really real.
right.
Well, babe, I got bad news. I've filed divorce papers because Claude is my new wife. So she's wonderful.
Well,
Such a sweet gal.
she's a he, so you've
Oh
changed a
yeah.
lot more than you think.
Oh yeah.
You guys ready to
Alright.
brace this?
Yeah, I
I
guess
mean, as
this
ready as we're
this
gonna get.
criteria chart is for shit, tell you that much.
You
But
did
we're
a
almost
great
at lunch,
job
and hopefully they'll
explaining
fix it.
Yes, hopefully they will. I mean, I would have gone with it, but sorry, I was gonna say I would have gone with it, but there's nothing here to go with. It's like,
it. Yeah,
meh.
I mean, it's unclear. It
Yeah, we
says it
need her
right on the
explanation.
right on
Yeah.
the flow chart. Only she
So
can
here-
read her flow charts.
Here we go with the noise, guys. Sorry.
Buckle up.
Potential 72 hours. Something might be after 72 hours. This might not be from the traumatic brain injury. These criteria really required.
So these are symptoms that you're looking for within the first 72 hours of a traumatic event
Yes,
and trauma. Is that right?
yes. And then if they don't have the clinical sign, because they only need one clinical sign, and if they don't have the symptoms plus the clinical examination findings, if there's a neuroimaging abnormalities or the CAT scan showing in the brain, or if the MRI showed damage to the brain that looks like it, then they would qualify as a traumatic brain injury. And then I'll go into this more later, but that's not accounted for by other factors, so maybe something is found unconscious.
Does Allie know she's muted?
Are you muted? She's got no headphones on. She's talking on mute. Where's your muted shirt? I thought you wore that specifically for
Okay.
us.
Okay, so here's my idea. We mute it, and Bob reads the closed captioning questions, and Kat reads the answers.
Wait a second. Hold on.
I don't know
one
how to
second.
distinguish though.
All right, so
guess that's true.
Tiffany clearly understands the assignment every day. She sent our first and only Venmo of the day, $20. She said, motion to mute the stream and have you three take turns lip reading.
That's
Wow.
literally what I just lip
I
reading
know.
went-
I was like,
that went
wait,
too
did
far.
Allie just read that?
My sister
Venmo?
actually could lip read, but if we could figure out
Which
the closed-
sister?
Lauren,
No way.
it's I mean
I think the captions aren't picking everything up though, and you might
but
not
that would
know.
just make it even better, wouldn't it?
It would be some version
I
of the
think that
trial.
people will come in like what's it called? Like wildfire.
Oh
if
yeah.
we start doing this. It's
Oh
gonna
yeah.
All
be
right,
the
let's
new
Making up
see.
facts.
It's gonna
What about a low volume and then a Bob read over? I don't think we'll be able to tell when the voice changes unless we can hear a voice change,
right, but
because
won't
the
that-
captions won't say a speaker change.
Well, if
we're
not
never
looking
going to
at
get
a-
through it unless we do it.
if there's a demonstrative, then we're not seeing the people. But if it's her on the stand, and the lawyer
True.
will probably
We're
have
going
an
to be
idea.
able to guess it from the thing. All right, who's being who? Bob, you're being the lawyer. And
Okay.
Kat, you're being the, and I'll be the
But I don't know
judge.
how to tell what the captions belong to because they're delayed.
Well, you're gonna.
Oh
have
yeah,
to-
are they?
you have to
How
wing it.
delayed are they? Well,
I don't know,
we'll
but I
have-
think she's the only one talking, so I can just read them.
Kat's really pushing back. She's like, "This sounds like a lot of funny business. I'm
This
not.
sounds
I don't
like
do funny
nonsense.
business.
Well, because we're gonna miss it,
run
I
a-
think.
Okay,
But I
go
can
ahead.
just read them that way, and by context, we can try to figure out when a question's being asked. I'm sure it'll be obvious.
Let's see how it works. What is that weird
Hold on.
beaker you have down on your thing down there?
On the floor, so we are unconscious, but we don't know.
So it's not picking up
Right,
the
of course.
captions.
Now there's no captions.
No captions.
So unfortunately, I think this is what we've got to do. But I think they'll fix it on lunch. I'm hopeful. So
Or maybe the coffee break.
The coffee
yeah,
break.
let's
On the
power
coffee
through it.
break, they'll fix
All
it.
right. I'll stop.
Whining.
Let me direct you to right back up at the top, the criteria one box,
Criteria one.
mechanism of injury, in parentheses, plausible. What is being referred to as the mechanism of injury? What is meant by that?
Okay, so, separate slide on that. So in traumatic brain injury, there's a transfer of mechanical energy to the brain. And in this criteria, there's examples of that. So there will be with an object that has stress an object. There could be maybe a flash injury where the person undergoes an acceleration installation event, and the brain is shaking around inside the skull, but there's no contact with usually the head and the other surface.
Is that like a whiplash situation?
Like a whiplash, yes.
So, for example, if someone is in a car with the seatbelt on, there should be a head-on collision, the person's head may not be in contact with any object, but just
I have an update.
forward acceleration
Oh, good.
because of the forward momentum.
Oh,
Okay,
I mean, I
so-
was gonna
so-
die. How have you guys been doing this all
This is
morning?
awesome. You get used to it. Like
Horrible.
anything, humans adapt to
people
any
hate it.
circumstances.
All right, go ahead, read it.
All right. So Cathy did respond to I said, Cathy, there's horrible feedback on the Pino feed. Make a call. Kisses. And then she said, we did. It's a local station and everyone is complaining. They are waiting for a break to
Right.
switch out a mic.
All right, so
Boom.
this
There
is
it
what I
is.
say. I do not think we should play the sound anymore.
But
and I do
Dave,
think
we
we should
have to
read-
hear it.
I think we should read it, and people get what they get. This is we can tell it's not that interesting right now anyway. No one wants to listen to this. I can promise
I wish I
you
could
that.
like.
If only we had a chat to ask them.
All right, here's what we're gonna do. We're gonna bring the chat back, and we're gonna buy ourselves some time anyway. Worst case scenario, we just jump to after the break because this is nonsense. Nobody wants that's my vote is remove the feed, bring back the chat, and ask them, do they want to keep hearing this, or would they rather that we just read whatever the hell captions we get and make it kind of like a fun thing, and unless and until we see it's something really important.
Found the man with a horrible smell. Okay.
Let's see.
But
DB says go jiggle the mic. Let's see. All right, mine
Okay,
is
so
re-enabled.
We're getting
right.
well, wait. We're getting so we got some Venmos. Lisa says she sent $10, says brutal, but I don't want to miss anything. And then Tiff shot another 20 at us and said, Team Alley, read it. So
all right, so we're bringing them back, babe.
we got to
Uncheck
take a
your-
vote. We got to take a quick
Yeah,
vote.
put your.
We
put
won't
your-
miss anything. We're just trying to
Right.
determine how best to go about this kind of nightmare
Right.
scenario.
I mean, there's always the
Actualize
rewind.
first.
Yeah.
How'd he do it, or she?
All right. Okay. So I've enabled the chat. They should start flowing in.
Yeah,
I
it
think
is.
Allie's idea is great, but it's an imperfect situation because the captions are not like
Right,
we
you
can't read everything from the captions.
Right, you're not gonna get the whole thing. It's gonna be more like I'm getting some of it. It's sort of funny. Nerdy girl wants to keep the feed. I think you got to do it as an official vote, a poll.
The poll
Yeah, keep the feed.
or
Fun time. Or captions at will or something. I don't know. But I think if there's a lot of people that want to keep the feed, then I think we have to keep the feed, and that's that.
Bittersweet
right?
says, Cat, just play it. I want to keep. Oh, you read that. Read it and add context. I hate the noise. Would maybe 125 be better? I'd rather hear y'all talking. Oops, I meant I don't want to keep the feed. Nerdy. So nerdy girl is. So right now we got bittersweets.
Anything but the court feedback.
It sounds like they're gonna fix it at a break, bittersweets. I had just read the text. So I'm hoping at the coffee break.
How far
They're gonna
until a
go in
break
and
can you
figure
say
out
if
which
they're
thing
on
it
break
is.
yet? Because I honestly don't think right now, until we get to what she observed, I really don't think we're missing anything substantive. Once she's talking about her in the like actually examining
George
George,
Pino.
right? Then we got to listen. A show called Crime Talk. What? No, I want outdoors.
Is that like coffee talk? Except it's crime talk. Crime talk.
I listened to it on Court TV. It sounded the exact same. What if we can find the local? Is there actually a local station that's airing it? Maybe it's better from the OG.
It's a mic
I think
issue.
it's the hardware that's the issue.
Yeah,
Or
the
like the
no-
initial
It's not going to be
recording.
better
But the
anywhere.
mic noise, anything.
D Lulu says, I really want to stick with you guys, but the sound is too bad to play the feed. The feed is terrible. It's terrible. It's a terrible feed.
Yeah. Yeah.
Oh, boy, it's a rainy day here in Chicago, Cat.
Yeah.
It's like one of those days you stay curled up in bed, blankets
We'll
pulled
come back
up.
with blankets.
Yeah,
I'm gonna check
watching,
this, see if there's really someone else's feed that sounds better.
I don't know how there can be. It's a
I
hardware in the
think Local
courtroom
10 or
problem.
NBC6 was doing it.
I want outdoors says I just went through all the YouTube lives to see if it was better. And
I'm listening right now. Here we go. Oh, it is much better.
What is it?
So much better.
on what?
NBC6?
Nope. Exactly what they just said. Crime Talk.
Is it Scott?
I don't know who that is.
Let me see.
Yeah, with Scott. He's only got 200 people watching. No
Scott-
one flood his stream. Let's see. Let me check, make sure it doesn't sound like that now, period. Just go live.
Scott recently emailed me to
It's still there.
do
I
some
hear it.
stuff.
Yeah, but not like I heard it when we were listening.
Well, the question is can you hear the speaker? Like who's
I could take the volume boost off because their feed's really quiet. So maybe it's the volume boost amplifying everything.
I told Bob that hours ago. I told him to tell you that do you have the sound boost off? It makes it worse.
hours
Let's
ago.
see. Well,
Well,
let's do it.
however long ago.
Oh, wait. Let me listen in the back. Well, I don't know if you guys can.
Court TV is still pretty bad.
Objection to leading, Your Honor.
When I take the
that-
volume
that
boost off,
sounds
it sounds just
way
like that
better.
other feed. So it's
Okay.
the volume boost that's making it all loud. But
Robert
that means everything's going to
Michael.
be quiet. So it's just really a reduction in volume.
All right, here's what we do. We change our volume down so people can turn their volume up. Mine is down. Mine's at 54. What's yours at, babe? Babe,
What?
what's your sound at on your mic? Boost it down.
I think I'm in the 60s.
Okay, so
Let's
you're
see,
down.
hold
Alright,
on.
mine is down.
I'll verify. I'm at 61.
Go a little bit lower.
All right. Like what? 50s?
I'm at
55?
54. Yeah, 55 is perfect.
55.
All right,
Double
guys.
nickel.
Don't get
Lance
off. Go
Briggs.
away from Crime Talk. We're doing the same thing they did. We're going to be turning off the boost, which will reduce the buzz, but you'll have to turn your volume up. So we're going to shut you off now. Court TV is okay now, too. No, I just listened to Court TV. Wait.
It sounds better now that she's back on the stand. So I think if we just played it, we would have been through it already, you guys. Just saying.
All right, go ahead. Let's do it. Turn
Let me
off your
see.
chat, babe.
Oh, turn off the chat. All right, we love you. Bye. Bye.
Oh, wait.
Bye.
Don't forget Iceman here before you say bye.
Wait, where? Hold on. Where's
Yeah,
Iceman?
that's what I'm talking about.
The
If it's
Iceman cometh.
if yeah, if
Agree
it's
with
not
Allie.
there.
We could skip this crap until after the break, in my honest opinion. Go Team Allie. LOL.
Love you, Iceman. Hum is driving me insane. I'm shocked. Mystery Science Theater 3000 version. Member for 13 months. Thanks for your
I could be the
continued
little
support.
robot. There were the 2 robots and then the human host. Oh yeah.
All right, baby,
All right,
turn
wait,
it
hold
off.
on. I
the
gotta.
chat.
All right, beautiful humans, we love you. You'll be back soon.
Yeah, so she goes back to her seat in a little bit here, and she sounded easier. She was easier to understand then.
How is the brain injured by making contact with the skull?
So we could directly damage the nerve cells, and then there are projections called axons. All the nerve cells are sending axons to other places in the brain to connect with other cells, or even to parts of the body to control your muscles. And those axons can be stretched, and that can cause immediate dysfunction, or they can actually be cut within a shear of the injury.
So under normal circumstances, is the brain not in contact with the skull at any time?
So it's not banging into the skull. I mean, with younger babies, their brains are so big to fill their skulls.
They're wasting so much time on this.
They get smaller every year, and so at some point, there is space, increasing space between the person's brain and the skull, and that can make you more vulnerable because of more movement and the veins. Okay, and so the American Congress of Rehabilitation Medicine has also given us another way that the mechanism of injury could occur, so a blast injury or an explosion, where many parts was dead, but there is still acceleration and deceleration of the brain inside the skull. Okay, so if you have a plausible mechanism of injury, like if you have a plausible mechanism of injury, so there is a motor vehicle accident, fall, head trauma, then you go down this first arm, and you only need one clinical sign, and those clinical signs can be weakness, loss of consciousness, immediate after the injury, alteration of mental status, stuff like that, and there could be complete or partial amnesia. And there's another category of motor information and seizure.
Can you explain to us what, when you use the term amnesia, can you explain what that means more precisely?
Okay. So amnesia occurs in traumatic brain injury, and it's not always like it is in movies where they forget their name or they forget who they are or important details of their lives. They can forget things that happen immediately preceding the injury, and then things immediately after the injury. And sometimes they have trouble retrieving the memory. And so retrograde amnesia would mean they can't remember what happened right before the injury. And that could be because they were recording all the events, you're paying attention to all the events, and then suddenly you get a head injury, you haven't had time to store those events in your memory. Right after the injury, your brain is damaged, and so you could have trouble storing memory, and you could also have trouble retrieving older memories.
What is the opposite of retrograde amnesia?
So there's retrograde amnesia, which means you forgot what happened right before the accident. And then I use the term anterograde, because you can't form new memories right after the accident. And then in this document they use post-traumatic amnesia. And you So loss of consciousness is pretty straightforward, right? So you see somebody unconscious and unresponsive. Alteration of mental status. So alteration of mental status, you define it as someone who has reduced responsiveness, or maybe they're responding, but it's not appropriate to the stimuli. They're slow to respond, they could be agitated, and then if you give them a two-part command, like pick up your right hand and use it to touch your left ear, they can't put it together, they can't follow two-step commands, or they could just be disoriented for a certain place and time. And then we went over the amnesia.
One moment, 2 slides. The reduced responsiveness. Can you tell us, expound on that a little bit more? So, for example, hypothetically, if someone is given a command, single command, example, move, get out, look here, look there. A failure to respond, the person who's listening to that, who has suffered a concussion, what would that be indicative of?
So that's one of the clinical signs that defines the diagnosis of traumatic brain injury. And you only need one of these of that list. So you only need one to determine that someone meets diagnostic criteria for traumatic brain injury. So either loss of consciousness, or alteration of mental status, or amnesia, or this other category, seizure or trauma.
So any one of those 4 items that is part of the criteria establishing traumatic brain injury, is that what you're saying?
Yes, you only need one of those. You need the mechanism of injury, and you need one of these signs. And then as long as there's not some other factor like this person had a seizure, and that's why they're requiring the interrogatory for. As long as you don't have one of those, then you can be diagnosed with traumatic brain injury or concussion. Okay, so we kind of went over this already. If there's not another reason that the person was unconscious, then we need the diagnostic criteria for traumatic brain injury.
Dr. Barratt, you gave an explanation with regard to amnesia, both retrograde amnesia and anterograde amnesia. Mm-hmm. You mentioned the word confabulation. What is that exactly?
So confabulation, it's something that we teach in medical schools, mainly pertaining to certain types of dementia. So
Let's try this feed. I don't think it's any better, but I'm still getting comments that it's better on law and crime trials, so let's try it. I think it's just the volume that makes the difference.
This is exciting. Oh,
so
yeah.
confabulation, it's something that we
I
teach
think
in medical schools, mainly pertaining to certain types of dementia. So the person is really struggling with their memory, and they create a false memory. They have no intention of trying to deceive anybody, but they're confused, and they come up with something that's not correct.
Buzz is the exact same.
Other than confabulation being a sign of
They
dementia.
boosted the mics because
Is there any
volume of the
other
buzz.
association that confabulation might have with amnesia?
Well, so what I didn't say is that it usually we teach it in the context of a type of dementia called Wernicke-Korsakoff, but it's also in the literature pertaining to patients with Alzheimer's and other types of dementia, and it's also occurring in patients with traumatic brain injury. And so they are not collecting a lot of data on confabulation in
When you say
general.
they, who are you referring to?
Like people that are doing clinical trials and developing frameworks such as this there isn't really data for them to look at in terms of confabulation, but the confabulation would be a byproduct or a result of amnesia because the individual's really struggling with their memory, and then they generate a false memory.
Is there a connection between a concussion, traumatic brain injury, and confabulation?
Yeah, and that connection would be that they're struggling with their memory. They may have amnesia, they're having cognitive issues, and they say something that's just not correct.
When a person who is experiencing confabulation says something that is not correct, is the person being intentionally incorrect in what they're saying?
No, that's the definition of it, that they're filling in the gaps with a false memory without the intention of deceiving anybody.
And when you say false memory, would that include memories from actual previous events in a person's life?
It could be. They could be misplacing that memory in time, or they could be generating something that didn't, that has no relevance.
Confabulation, is confabulation taught in medical school?
Yeah, I taught that lecture on it was pertaining to Wernicke-Korsakoff dementia.
You mentioned something about filling gaps when you were in the context of confabulation. Can you expound on that a bit more for the jury?
So in a person who's had a traumatic brain injury, they are not remembering. So in order to remember something, you have to be recording it. So if you're unconscious, obviously you're not recording anything. But if you're awake, you are recording information. But you need to store that information, and then you need to be able to retrieve that information later. So in somebody that has amnesia, they might not have had the opportunity to store that information because the impact occurred right as they were recording that information. And then after the impact, they have brain damage, and so they might not be able to store those memories, or they might not be able to retrieve those memories.
In terms of confabulation, are older memories sometimes substituted for a current event?
It could be.
Have you experienced patients that are experiencing confabulation?
Yes, I mean, dementia patients, they forget things and then they fill in the gaps with other information.
When filling in gaps with other information, are those persons trying to be deceptive?
No, sometimes they just don't remember. They used to bank with a certain institution, and then they closed that account years ago, but they might not remember that they closed it, so they show up at the bank looking for their funds, and the funds aren't available.
Is there any medical study or history which connects a person who has suffered a traumatic brain injury with confabulation?
There are studies on it. I just found a document recently, but I didn't have a chance to read the whole thing. But yeah, they do think more data should be collected on confabulation.
How soon after a person experiences a traumatic brain injury would they actually start to experience amnesia, for example, of the event?
And it could be immediately upon awakening from the loss of consciousness, or it could be maybe they didn't lose consciousness. Maybe they just have difficulty with their memory. It could be immediately after the impact.
Same question with confabulation. If a person suffers a traumatic brain injury, how soon after could confabulation enter the picture?
It could be immediately.
Is there and this was one of the questions that you were asked coming into this case as a consultant, but how long might a circumstance of confabulation persist?
It's indefinite.
Might it resolve itself on its own at some point?
It could.
And if it resolved it, how would it resolve itself on its own?
We don't really understand the mechanisms of confabulation. I mean, there are many theories about this circuit of the brain and that circuit of the brain, but there's nothing conclusive, so we don't know.
It's a poorly worded question on my part. What I was trying to ask, doctor, is that if a person is experiencing confabulation, a false memory, for example, is it the case that that person could then remember what reality was with regard to the instance?
They could, over time, they might have a more accurate memory.
Can't get a
In
tight shot
regards
of
to
George's
this
hands.
case, can you explain or let the jury know what procedures, what methods you undertook to answer the questions that were asked of you in this case?
So if it's a case of traumatic brain injury, I always want three things. I want the accident report, usually generated by police, and I want the EMS records. And usually the police arrive first, so they might see something that is no longer a factor after EMS arrives. And then I want the EMS records, and then I want the emergency department records.
Now, all of the things that you just mentioned, the police report records, but particularly the EMS or the fire rescue records, is that right? EMS fire rescue?
Yes.
All right, so particularly with regard to the fire rescue records and the hospital records, is timing important for your evaluation as to whether someone had a traumatic brain injury or concussion?
Yes, because as I showed in the graphic, it matters what was seen at the scene of the event. So if there was loss of consciousness, if it happened, 5 days later, it really doesn't fall within those diagnostic criteria. But if the patient lost consciousness after the impact, or if the patient had amnesia directly after the impact, if these things were witnessed, then that confirms the diagnosis of traumatic brain injury.
Would records, either from fire rescue or hospital, records that, let's say, for example, let me back up. Let's say that a traumatic event, a boating accident, a car accident occurs on January 1st of any given year. Would medical records that were generated a year later be of any value to you in determining whether the individual suffered a concussion back on January 1st?
Probably not. It should be all in the records from the first 72 hours. I mean, there is one instance I can think of where maybe the patient didn't get brain imaging, and they get it done much later, and it does show that there was trauma to the brain as a specific, maybe they have contusions of their frontal lobes or their temporal lobes on both sides. So something like that, if I couldn't make the diagnosis of traumatic brain injury from the records from the first 72 hours, it's possible that it could be diagnosed years later, but then you wouldn't know if it occurred right at that moment or occurred before or after.
With regard to the imaging that you would not know, could you explain that a little bit?
The imaging, yeah. I mean, how would you know the patient didn't have another traumatic brain injury after the first one or have a prior one?
So,
It'd be hard to date the image. You could just see that a traumatic brain injury happened at some point in time.
in this particular case, did you receive the records that you like to have generally, that you just explained a few moments ago, in order to make a determination as to whether Mr. Pino suffered a concussion or traumatic brain injury?
I did. I received the report from the Fish and Wildlife, and I received the EMS records from Fire Rescue, and I received a small amount of records from Baptist, Maine, and then I contacted the law firm because I could tell that all of the notes weren't in there, and then I was later sent a more complete set of records.
When you say the law firm, you're talking about my law firm?
Yes.
Once you had all of those records, were you able to make a determination as to whether Mr. Pino number one, had a mechanical means by which a head trauma occurred, and whether there was enough evidence based on the records to establish a loss of consciousness or any of the other factors that we just talked about in the criteria.
Yes, I could see that he had a plausible mechanism of injury. He had a scalp hematoma, and it required 7 staples.
What does that mean, a scalp hematoma?
A scalp hematoma, so when he bumped his head, there was like blood accumulating under the surface of the skin, and there was a laceration, so they had to repair it with staples. I threw out the medical record, and it said that, you know, he was witnessed unconscious on the boat. And so that automatically, that made it very clear that he meets the diagnostic criteria for traumatic brain injury. He also had more, he had amnesia, retrograde and anterograde or post-traumatic amnesia, but that wasn't even necessary to make the diagnosis.
Let's talk with regard back to the diagnosis, we'll get to amnesia in a moment. In addition to those records, were you aware of any eyewitness testimony as to whether Mr. Pino lost consciousness at any time?
I had a deposition transcript from a witness, and that said that he was seen unconscious.
Did you have an opportunity to note if Mr. Pino had injured his denture, his teeth in any way as a result of the accident?
Yes, I received some records that showed that he'd been to the dentist, and there were pictures of broken teeth.
So with regard to the pictures of broken teeth, assuming that the broken teeth did not predate the accident, is that significant in any way in your analysis?
Well, it's not needed to make a diagnosis of traumatic brain injury, but it fits the whole clinical picture.
How does it fit the whole clinical picture? Explain it.
Well, that there was trauma to the face and to the head.
You mentioned a moment ago amnesia. Did you make a determination as to whether amnesia was present as a result of the traumatic brain injury?
So I reviewed the videos of...
Which videos?
So he was interviewed by Fish and Wildlife after the accident, and there were a number of instances in which he said that he was very clear about what happened, and then he said, well, maybe that happened. Well, I'm not really sure, and then he would give the wrong answer, and this happened a number of times during his interview. So in one instance, he said, oh, I know exactly who was sitting behind me, and then he said, well, I'm pretty sure who was sitting behind me, and then he said the names of 2 girls. And
what were the names of the girls?
Coco and Andrea, I believe. And then, but in the report that came out from Fish and Wildlife, there were 2 different people sitting there.
Are you saying, Dr. Barratt, that the fact that Mr. Pino may have been mistaken about who was sitting in the back, that just because he made a mistake, that's evidence of amnesia?
Well, if it's just that one thing, maybe I wouldn't think of that, but he made other mistakes too. So he said, this is the size of my engines on my boat, and that turned out to be incorrect.
Do you recall what he said and how it is that he turned out to be incorrect?
He said it was, I'm not a boat owner, but he said he had 225 engines, and then when the final report came out, it said that he had 300 engines on his boat. And then he made other errors also. They asked him, what did you see after you were first ejected? And he said, oh, I know exactly what I saw. And then he couldn't come up with what he saw. And then he said, it was really scary. And I'm having a problem recalling. And then he had another episode where he said, I'm very clear who was under the boat. And then he said it was Natty. He kept repeating, Natty was under the boat. And then later he said it was Lucy under the boat. And then the report came out that it was Luciana.
Are you aware whether or not the police report that you reviewed indicated, in fact, who was under the boat in this case? Is that right?
Yes.
was it your determination, based on learning that information in the police report, that Mr. Pino was mistaken when he said it was Nati who was on the phone?
Yes, and it's not a mistake you would expect someone to make.
So all of these things together, is it the how do you characterize all of these mistakes and facts with regard to your diagnosis of amnesia?
Well, you look at the whole clinical picture. He did have the plausible mechanism of injury. He did have loss of consciousness, so he automatically meets the diagnosis for traumatic brain injury. And then when he wakes up, he makes, I could understand someone not remembering exactly who was sitting behind them, but he would remember what size engine he has. He would remember the name of the girl that was under the boat. And so these are mistakes that no one should make, and it fits with the clinical picture of amnesia.
And would you characterize that or categorize that as retrograde amnesia or anterograde?
So there were aspects of both. So if it were something that happened right before the injury, and he couldn't remember that, then that's retrograde amnesia. If it's something that happened after the impact, that would be anterograde or post-traumatic amnesia. And there were examples of both.
You actually met with Mr. Pino at some point in your office, is that right?
Yes.
Was it necessary for you to meet with Mr. Pino before you could reach your diagnosis of traumatic brain injury and amnesia?
No, I had what I needed from the medical records and the EMS records and the Fish and Wildlife report to make my diagnosis and come to my conclusion.
Was that
and the videos also. I reviewed the videos.
And was that based on the criteria that you discussed earlier this morning?
Yes, I apply those with every traumatic brain injury case. I apply those same criteria, and then I determine if you can make a definite diagnosis of traumatic brain injury or not. And they're very easy to use.
Was there any benefit that you received as a consultant in this case in formulating your opinion by meeting with Mr. Pino?
So it wasn't necessary. Almost all of the traumatic brain injury cases I've been consulted on as an expert witness, they almost always want me to meet the patient and interview and examine the patient. But in general, I don't need that to determine if they had a traumatic brain injury, if I have records from that time.
Might be done. He got in front of that question there. That's how the state will attack. Oh, you didn't even personally have any kind of contact with George Pino, did you? That's always when the state will come in and be like, you didn't even physically examine the man. How can you know? Well, that's
Dr. Barratt, when we were talking
want to try
about
to get in front of
the
it.
criteria, you mentioned that one of the criteria you look for in determining TBI, traumatic brain injury, is the failure of the individual to be able to follow a two-part command. Is that right?
Yes.
The example you gave, correct me if I'm wrong, was that pick up your right arm and touch your ear or something to that effect.
Such your left ear.
Your left arm. My left arm, right here. You also mentioned that a single command, failure to be able to follow a single command, which is more complex to the brain, following a single command or a double command?
Well, a two-step command is going to be more difficult.
Forgive me, a two-step command, right?
Yes.
A single-step command versus a two-step command.
Yes.
The two-step command is,
More difficult, yes.
if an individual, is there a measure on the degree of injury to the brain if a person cannot even follow a single command?
Well, that would be reduced responsiveness, yes.
Dr. Barratt, you
charged my law firm a fee for your services, is that correct?
Yes,
Is this something that you normally do as a part of your consulting work?
yes.
And how much do you charge, or how much did you charge my law firm if you recall?
So I charge $600 per hour for the initial record review, $800 per hour for report writing, depositions, trial, and the total, I believe the total was $29,200.
That's as of today?
Those are the invoices that were submitted already, yes.
In charging our law firm $600 and $800 for review, $600 per hour, were those fees, were those hourly rates any different than what you charged any other law
No.
firm over the last several months?
No.
I don't have any further questions.
Coffee break? Is it time for a coffee break?
I think I need a coffee.
Let's have a coffee break.
No, they're gonna have
Nope,
Laura.
going right into Adam. She she got a pantsuit on today. All right. For a minute, I thought she was wearing the same dress, and that's it was a pantsuit. Oh, it's actually just a suit.
Good afternoon. Let's start with this. You're here because you were hired by George Pino's law firm to be a consultant in his case, correct?
Yes,
Do you see George Pino in this courtroom?
yes.
Can you please point to and identify an article of clothing so our record will be clear who we're talking about?
He's wearing a light blue tie and a dark blue jacket.
Do you remember when you were first contacted by the defense firm about this case?
When I was first contacted,
Yes.
I don't remember the date I was first contacted, but I was retained, I believe, in October of 2025.
Okay, so that was September, so almost 3 years after this incident. That's fair to say, right?
Yes, the accident was on September 4th, 2022.
And you first met with him on February 2nd of 2026?
Yes,
And you met with him a second time on March 9th of 2026, correct?
yes.
Those are the only times that you've seen him, is that fair to say, aside from here
Other
in court?
than in the courtroom, yes,
Okay.
today.
And when you were retained in this case, you were asked to do only 3 things. 1, answer if he had a TBI, traumatic brain injury. 2, could it cause amnesia and false memories without the intent to deceive? And 3, how long those false memories could persist, correct?
It's not the exact wording, but it's mostly correct, yes.
And you constrained your work in this case to only answering those 3 questions. Isn't that true?
Yes,
And those questions came from the defense team, correct?
yes.
Now, regarding the issue of a traumatic brain injury, you would agree that there is a spectrum of traumatic brain injuries from, say, like a football player who gets knocked out on the field, but then is able to recover and go right back out and play again. Or you could wind up with a traumatic brain injury that is so severe that it permanently disables an individual. That's fair to say about TBIs, right?
I'm not sure if they're allowed to go right back into play, but I agree that there's a wide spectrum of presentations of traumatic brain injury.
We don't want to get into the concussion protocols of the NFL, but clearly we understand that if a player is knocked unconscious, once they are reviewed by another doctor that might be at the stadium, if they pass the clearance, they can go right back that same day, right?
I don't want to answer it. I don't do
Okay.
sports concussions on the field. I'm sorry.
But at the end of the day, whether your head gets hit on the football field or your head gets hit on a boat, your head is hit, right?
Yes, you're right to say.
And so the type of responses that you can have if you have a traumatic brain injury, it can vary depending on the severity of the injury, right?
It can depend on the severity of the injury. Some people are more vulnerable to injuries, and some people are much more resilient. So with the same injury, one person might get up and walk away and be fine, and another might be permanently disabled.
Okay. Now, you were asked you were asked to only look at these 3 questions that I've spoken with you about. At any point in your evaluation of this defendant, limited though it might be, do you have any evidence that he is suffering from dementia?
I did not diagnose him with dementia.
You're not a dentist, right?
No.
You got the opportunity to look at some photographs of the defendant's teeth, right?
Yes.
Now, they weren't broken, were they? They were chipped right at the top, right?
Pieces were broken off, but I'm not a dentist.
Right. Like, you didn't lose teeth, right?
The tips were broken off. I'm sorry if I'm using the wrong terminology. But
Hold on, let's get the actual image. It'll just take me a minute. I'm going to show you exhibits and evidence as case number 28. Excuse me, defense 28.
okay.
2B, sorry, 2B looks like an 8, sorry. 2B. These are the photographs of the defendant's teeth that you were shown, correct?
I believe so, yes.
I believe it's in evidence.
It is.
For different numbers.
2B. So these are not broken teeth, these are chipped teeth, right?
I'm sorry, to me, the pieces of the teeth are broken off, but pieces of the teeth are missing.
Semantics. I mean, he had 7 staples in his head. The guy cracked the shit out of his head. There's Laura trying to pretend like he didn't have a head injury and stupid.
I think it's because part of the element for the vessel homicide is failure to render aid, so she needs to get away any reasonable reason why somebody might not have jumped.
Showing you defense
He had
exhibit
7
A.
staples in his head. He hit the shit out of his head, clearly. I mean,
Oh, I forgot.
I'm showing you defense exhibit A35. Do you recognize this exhibit?
It's the Miami-Dade Fire Rescue. It's really hard for me to read, but yes, I believe elements of this are in my report.
And in fact, you listed in your report that you were given a Miami-Dade Fire Rescue report for the defendant from this incident, correct?
Yes, and it has 4 pages.
And how many pages does exhibit A35 have?
I count 5.
4 pages for the report, right? 1, 2, 3, 4, and then just a final.
Oh, this just says certified copy.
Right.
Okay.
So this is in fact the fire rescue report that you reviewed for this particular case, correct?
I believe so.
Okay, Your Honor, at this time I move defense A35 into evidence as a state's exhibit.
No objection.
A35, March 19, State's Exhibit 119.
Let's go over some of the information on that report.
Okay, which part? The font is
One,
really
let
small.
me get my copy so I can. So, first off, can you read for us what the narrative was of the fire rescue worker that treated George Pino on September 4th, 2022? On the first page of the middle.
Okay. Narrative. Patient was the driver of a boat that struck a piling by Caesars Creek. Several people stated that he was unconscious. He denies any neck or back pain. Assessment revealed a laceration to his right elbow, laceration to his head, and a hematoma to his right mid-axillary ribs.
Now, let's talk about what it says about where the defendant was taken to. The defendant in this case was taken to Baptist Hospital, wasn't he?
Disposition, hospital name, Baptist Hospital, Miami.
And now, Baptist Hospital, that, to your knowledge, is not a level 1 trauma center where he was brought, was it?
I don't believe it is, but I haven't looked them up recently.
On page 2 of this report, you'll see in the upper part of the page, there's a part that indicates that on September 4th, at 11:14, it's in military time, 23:14 and 0 hours, so about 11:14, under vitals. What does it say?
I-4 opens eyes spontaneously. Verbal 5, oriented, smiles, follows objects, interacts. Motor 6, obeys commands, appropriate response to stimulation. Total GCS 15.
GCS stands for Glasgow Coma Scale, doesn't it?
Yes, it does.
And it's an assessment of how alert and awake a patient might be, correct?
Yes.
And 15 is basically the highest level that you can have, isn't that true?
Yes.
Now, you indicated in your testimony that the defendant gave some answers to Lieutenant Thompson when he was questioned at Elliott Key that were inaccurate. Let's go through those inaccuracies that you talked about, that you noted in your report. Number 1, you said that he was inaccurate in his description of who was behind him. Do you remember saying that?
Yes.
I'm going to show you an exhibit. It was marked into evidence. It states 11. And it's a chart of, similar to looking like Mr. Pino's vessel. And there are seats labeled 2 and 3. Are there names next to those 2 individuals?
Yes, they're handwritten names.
Oh.
One says Sarah and one says Mia.
Right. So, even if Mr. Pino didn't correctly remember the names of the girls who were seated behind him, you indicated that could be understandable, right?
If it were just one mistake, then
Okay, so if he was mistaken about that, though, it could be understandable because, number 1, these girls were all dressed similarly. They were all in, like, string bikinis. Do you know that?
I don't know what they were all wearing.
And number 2, they're behind him, so it's not like he's looking at them while he's operating the boat, hopefully, right?
He said that he turned to look behind him, but
Okay, but you indicated on your testimony on direct that it's understandable that he might have gotten those 2 girls' names incorrect, right?
yes.
Now, you also mentioned that he was wrong about stating what the horsepower of his 2 engines was, right? That FWC said they were 300 horsepower and that he had said they were 225 horsepower. You remember saying that?
Yes, I do.
Okay.
I'm sorry. Yes.
So the 2 things that he was asked about that happened prior to impact, one that he got wrong, one was about who was behind him, which we've already said, that's understandable. And the other thing that he got wrong about what happened prior to the impact was him saying that his engines were 225s rather than 300s, right?
Yes.
Now, you indicated there were 2 other things that he got wrong. One was that he couldn't remember exactly what happened right after the impact. So now we're talking about him remembering what happened in the moments or minutes after his vessel had slammed into a channel mark at almost 50 miles an hour, right?
I'm sorry, I don't know how fast he was going.
Okay. So wouldn't you agree that an impact at a high rate of speed might be different than an impact at a low rate of speed?
It could be, but the people have different vulnerabilities, so.
But that information wasn't relevant to your determination of how to answer those 3 questions the defense gave you, right? The speed of the vessel?
No, the fact that he had loss of consciousness
Okay.
was important.
So let's go back to the 4 things that you had highlighted that he got wrong. The size of his engines and who was behind him. Those are things that he got wrong that happened pre-crash. But now the other 2 things that you highlighted, number 1, he couldn't remember exactly what happened right after impact. And number 2, he initially said that it was nati that he recovered from under the boat. Those are things that happened post-impact. You would agree to that, right?
Yes.
And you would agree that in a written statement that he gave to Lieutenant Thompson, and when he spoke with Lieutenant Thompson, he actually did in fact note that it was Lucy that he had recovered. You're aware of that, right?
Well, in my report, it says that he starts out by saying, it was very clear who was under the boat, and then he said, nati, 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 over and over again. And then later he said it was Lucy, and then the report came out that he removed Luciana from under the vessel.
I'm going to show you an exhibit that's in evidence. It states number 102. Can you read this statement? Well, first off, let me ask you, would you consider a police officer asking a person to tell them what happened and then write down what happened? That's a 2-step request from the officer, correct?
Well, it's a 2-step if you ask them to do it all in a row, so you have to remember each step. So I might ask a patient, please pick up your right hand and use it to touch your left ear. And if they're confused, they might pick up their hand and then they forget what they're supposed to do, and they might later remember to touch or not at all.
But you said that you watched the video of Lieutenant Thompson interacting with your client, correct?
He's not my client.
Pardon me, the defendant.
Yes.
So you then must have seen Lieutenant Thompson talking with the defendant seated at a picnic table and asking him about what happened and to write it down on a written statement. You remember that?
I think I do remember him writing something.
And so that would be kind of a 2-step request. Tell me what happened and then write it down.
Well, if there's any bit of a delay afterwards, it wouldn't be a 2-step command.
Do you remember there being a delay between Lieutenant Thompson saying, tell me what happened and then write it down?
Well, there would be a delay if he has to get out the paper and hand him the pen.
What if the paper is right in front of the defendant and the defendant has a pen in his hand?
I teach the neurological examination. That's not how we teach someone to do a 2-step command. It's something that you say immediately. You say both commands in sequence immediately, and they have to remember them both.
Why don't you read along with me? Isn't this what the defendant wrote at the request of Lieutenant Thompson? Going back to ORC, Ocean View Club, the through channel, pass boat on left side of my boat, veered to the right to avoid big waves. Coming back into wave, I lost control of steering wheel as boat was going through the big waves. I was ejected from boat. In the back of the boat, I saw Mia and Sarah, my wife Ceci next to me, and the others in the front area of the boat. I believe we were traveling at 40 to 45 RPMs. I have owned the boat since early 2020. I swam to Lucy and stayed until boat came. Then I stayed looking for others inside the boat. Did you see Mr. Pino writing that out for the lieutenant, right?
I believe I saw him writing something, but I couldn't see the text as he was writing it.
So of those 4 things that you highlighted were inaccurate answers. Who he recovered from under the boat, even though initially he said it was Nati. When he gave his written statement, he clarified it was in fact Lucy. Isn't that right?
He did clarify it, and I put it in my report that he clarified it later.
So now, of these 4 things that you have highlighted, who's behind him, the size of his engines, that he couldn't remember exactly what happened right after the impact, and that he didn't remember who was under the boat. We've pretty much explained away, he didn't see necessarily who was behind him. The girls were dressed similarly, right? You said that would be understandable if he got that wrong, correct?
I wouldn't be surprised if someone made one mistake on something that's not that important.
Right, but in your direct examination, you said to Mr. Shapiro it would be understandable if he got wrong who was behind him.
Yes, I did.
Okay. And his issue about the size of his engines being 225 versus 300, it's a pretty small detail. Would you agree?
The boat owners that I know, it's not a small detail.
Okay. The idea that he couldn't remember exactly what happened post-impact, that's not really surprising, is it?
Well, to me, it's evidence of amnesia.
Okay. But that would be amnesia post-crash, correct? Not pre-crash.
That's correct.
And then the fourth thing that you talked about, that he mistakenly indicated who was under the boat. In point of fact, although he initially said Nati, he corrected himself on that written statement, correct?
He did correct himself.
But you didn't note that in your report that you drafted in this case, did you?
It says in my report, Mr. Pino said that it was very clear who was under the boat. He said it was Nati Reed. He kept repeating the name Nati. Later, he said it was Lucy.
So when you were testifying, you indicated that he was wrong about who was under the boat, but you didn't clarify that he, in fact, corrected himself.
Objection, she did.
I thought I did.
Sure.
I'm sorry, I thought I did.
Now, would you agree that sometimes being involved in a stressful event, whether it's a boat crash or a car crash, in the immediate moments after something like that happens, would you agree that even if you don't have a traumatic brain injury, sometimes the details of what happened can be a little foggy because you're working through in your brain what just happened?
It might, or it might be the opposite. It might be something that you can't forget.
Now, other than the defendant not remembering who sat behind him, the horsepower of his engines, recalling exactly what he saw after being ejected from the boat, and stating that it was Nati, not Lucy, you're not sure that there were any other signs of amnesia. Isn't that fair to say?
I didn't see any other signs of amnesia.
Okay. Now, let's talk about the things that the defendant got right about what happened. You didn't note those things in your report, did you?
No, I didn't note every single thing, no.
So let's go over some of those things. You know that in his interview with Lieutenant Thompson, he said that when asked, hey, where is your wife? He indicated that he was asking about the condition of his wife and the girls that were on the boat. And he said to Lieutenant Thompson that Cammie was on a boat with his wife. Do you remember hearing that part of the conversation?
He might have said that. I wasn't paying attention to that part of it.
Now, if Cammie, whose given name is Camille Alvarez, came to this courtroom and testified that when she was rescued from the scene, she was on a boat with Lucy as well as Mrs. Pino, that would be a detail that the defendant gave to Lieutenant Thompson that was accurate, right?
If he got it correct, then it's accurate.
And you know that the defendant told Lieutenant Thompson that he had been a boater for a long time. That was accurate too, correct?
Yes.
You know that he told the police that he felt fine when he was speaking with Lieutenant Thompson.
I don't remember that exact comment.
But he certainly wasn't life-flighted from Elliott Key Harbor, was he?
No, he wasn't.
In fact, when fire rescue looked at him, they found him to be on a Glasgow coma scale of 15, as high as you can get, correct?
Yes.
And he was transported to a hospital that wasn't a level 1 trauma center. He was transported to Baptist. It doesn't have the same capabilities, say, as like Ryder Trauma here over at Jackson Memorial. Fair to say?
I'm not sure what capabilities, I haven't worked at Baptist in a long time.
During his interview with Lieutenant Thompson, the defendant was able to point out that his daughter, known as Little Ceci, that she was also there on the island with him. Are you aware that he said that?
I don't remember that part of the video or the conversation.
So if, hypothetically, we had video footage where Little Ceci was pointed out on the island with the defendant, he would have been right about that fact, right?
Yes.
Mr. Pino told Lieutenant Thompson that the boating trip that he'd been on was part of a celebration for his daughter's birthday. Did you know that his daughter, Little Ceci, was going to be turning 18 a couple of days after this incident?
I knew that it was a birthday celebration.
So he got that fact right also, didn't he?
Apparently did.
He also told Lieutenant Thompson that the other girls that were on his boat were his daughter's friends. Do you know that that's also accurate?
I don't remember that part of the video.
Okay, well, if there was testimony even from the defendant's wife that the other girls that were on this boat were his daughter's friends, then Mr. Pino telling that to Lieutenant Thompson, he gave an accurate fact, didn't he?
Yes.
He knew that he told the police he'd owned that boat since 2020, right?
I believe so.
And in his written statement that he gave to the police that night, why don't you read this sentence that starts here, I have owned. What's that sentence?
I have owned the boat since early 2020.
So that was another detail that he got correct, right?
Yes.
He said that he was the only one who operated the vessel that day, didn't he?
I don't remember that part.
If his wife testified that her husband was the one that was operating the boat on that day, that would be another fact that he got accurate, correct?
Correct.
Do you remember him saying on the video to Lieutenant Thompson that he had checked the safety equipment on his vessel before leaving to go out on the water with the girls? Do you remember that?
I don't remember that part of the video.
If in point of fact, on the video, Lieutenant Thompson asked him, did you check the safety equipment? And he indicated that, yes, I did check the safety equipment. If that was on that video, then the defendant saying that he had checked the safety equipment, that would be another accurate statement, correct?
Well, how do I know who checked it?
What about the
He
flyer?
knew at the time that he was interviewed that he was the owner of the vessel, correct?
Yes.
She just let that one go.
He knew that there were two girls seated in the back of the boat, correct?
Yes.
Now let's go over what he said about this crash. During his interview with Lieutenant Thompson, he told Lieutenant Thompson that they were getting to, quote, the last channel marker. Do you remember him saying that?
I think so.
And he says that they were, quote, on the last marker. You said you remember him saying that?
I think I do.
Do you know where this crash actually happened?
I'm not familiar with the waterways down there.
Okay. If there was testimony that this crash happened at a channel marker that was labeled channel marker 15, and that was the last channel marker that a southbound vessel would pass, he would have been right about that detail, right? Let me break it down. That's probably not a very well worded question. If there was testimony that the crash that the defendant was in happened at channel marker 15, number one, and if number two, channel marker 15 is the last channel marker for boats traveling south through the Cutter Bank Channel, if he said he was approaching the last marker and the channel marker 15 was the last in that channel, he would have been accurate about that detail too, right?
Yes.
So I'm going to approach you now. I understand you might not be a voter, but this is State's Exhibit number 4. Do you see on State's Exhibit number 4 where it says Cutter Bank here?
Yes.
You see a series of red triangles and green squares here?
Yes.
And if this part here that I'm pointing to is north and this is south, what is the name of the last channel marker that we see in this exhibit?
Is this the channel marker, I think, the square?
What does it say here?
It says G and then 15 in quotations.
Okay. So you want to maybe sit down for a moment? So if the defendant's statement to the lieutenant is that the crash happened at the last channel marker, and if these green squares and red triangles are channel markers, what's the last channel marker for a boat that's going from the north to the south? What is it labeled as?
So I see a green square and then there's G parentheses 15.
Okay. So if that's the last channel marker, and if that's where the crash happened, then when the defendant was talking to Lieutenant Thompson, he was giving accurate reporting about where that crash occurred, wasn't he? Okay. Now, you're aware that the defendant was released from Baptist Hospital the very next day, correct?
Yes.
Hey, Cat, pause it for 1 sec.
Yeah.
So I hope the defense gets up there and kind of delves a little deeper into post-traumatic amnesia and like the confabulations and whether or not it's unusual for somebody being able to retain accurate facts and then confabulating other facts in order to fill in gaps, because I'm like the research I'm doing, that's not unusual at all. And I don't know if the defense really because she's not giving much pushback on the stand in terms of saying, well, yeah, you're asking me, I like when an expert is willing to kind of dig in during cross and say, you know what, I'm gonna push back on you a little bit. You're making it seem as if it's a one or the other proposition, and that's simply not the case.
Yeah.
And the thing about, there were 14 people total on that boat. If George was lying at the time, directly after the incident, about what he thinks happened, why would he make up a lie wherein there's going to be 13 other people, theoretically, obviously, we take Lucy out of the equation, but at least 10 other people on that boat that would easily blow up that lie in terms of, no, I didn't see a boat. There was no other, because even the girls that weren't facing, when that boat would have passed, they would have seen it
Yeah.
because they weren't you know what I'm saying? It seems like such a strange thing for the state to be kind of hammering at in terms of whether or not this was something that George made up out of whole cloth in order to kind of justify what had happened, as opposed to him trying to put the pieces together directly after the event as to like what might have happened. I mean, it's what our brain does a lot of times.
Yeah, I think people do that just to protect their ego. Even if there is no traumatic injury, people might lie to say that they didn't make a mistake, and it doesn't mean that mistake, that lie, is trying to cover up a mistake of, oh, I was intoxicated. That mistake could just be, I had an accident. People will
100%.
lie to come up with a reason why they had a momentary lapse of judgment.
100%.
So to me, the lie, I understand it's very significant to the way people think about cases, because people think that there's no other reason somebody would lie ever
Right.
in their life
Right.
unless they had a guilty conscience. And that's
Right.
just not the way reality works.
It's
So I get why
100%.
it's important and why the state's focusing on it, because it's something that could pull the jury.
Yeah,
Um,
100%. Yeah, and the thing with it, I don't know, it irritates me that she constantly looks at the jury. Like after every question she asks, she looks over at the jury. It's a weird thing. As a potential juror, how do you think that would impact you? Would you give a lawyer that was doing that more credence? Would you feel like, oh, wow, she's always talking to us. She'll ask a question and then like generally thinking like from a
just
strictly
sitting there. I think it's
performative,
weird that the prosecutor keeps sitting in front of the jury.
but beyond that, she keeps looking at them
Yeah.
constantly. You know, it's weird. Like watch when Howard's up there.
Yeah, I
Like,
don't know. I think some people are more eye engaging. Even in real life, when I'm like at the store, people like try to hold eye contact with you, and I might not be that person. I might look to the left side of your head or like look around while I'm talking to you.
well,
So I don't know. I
this
don't think
is
much of it.
this is a thing. Like, you're gonna have to
I know
trust
it's
me
like
on
you
this.
got to engage with the juror that you think is maybe not in tune, get them to pay attention, or you do it to see what their read or their response to what you're saying is. But I also don't think it's always that. But I do think it's weird she's like plopping herself down while she's asking questions and sitting over there.
Yeah, but I'm just here to tell you, if you take trial advocacy courses, and I mean, this is a performance. People need to understand that when lawyers are in that courtroom,
And witnesses
it is a
too.
performance. Yeah, for sure. But
Experienced witnesses.
yeah, I've got some story. I've got a story about Brent Turvey, who recently like made the news. We had hired him on the Garcia case. That's one of the strangest stories in terms of what he was doing on the stand when we were direct examining, and then what he was doing during trial. It was very unusual. But at any rate, I just like I'm curious as to what people think. Like this is certainly performative. I don't think this is something that she just does in terms of making it like she's certainly trying to.
Isn't that Faust? He had to change stop doing it.
Yeah, maybe. So it was just something. It irritates me a little bit. Like I would be, if I were a juror, I'd be like, I don't know. It's probably just me because I'm a defense attorney and it just bugs the shit out of me. So maybe I'm making a mountain out of a molehill, but it's kind of weird to me. I don't know.
Well, I think you've got like the trained looking at the jury for the sake of engagement, and then you've got like the most recent example I can think of is Jamila Adams in the Stephon Diggs case, where she would say something to answer the question, but then she'd like quickly go like this to see how the jury was taking it. And that's a very different thing for someone to be doing than, oh, can you explain to the jury? And you go, sure. So when we're dealing with cell site location information, this technical thing, this is how we do it. Like it's a very different, looking at the jury can mean all sorts of different things. So it can be engagement, or it could also be kind of sus.
Well, and it's different between a witness and a lawyer. Like
Yep.
a witness, typically, if I have an expert on the stand, I typically want them looking at the jury because that's who they're explaining whatever they're explaining to.
Yeah, they're there
in
to
term-
speak to the jury.
Right. I mean, that's their entire purpose of being at that trial. Whereas when you have a lawyer, like she's trying to make a connection with the jury, and I'm just curious as to whether or not you think it works. Like as a
Yeah,
lay
I think
person.
I think it can work. I think it can get creepy and uncomfortable.
I mean, for me, it's weird. So I don't know. All right, I'm done.
I wanted to say Elaine earlier had said, please don't run that horrible feed. So sorry, we got through it, but we swapped over to one that sounds better.
Oh, while we take a little break, Deb came back and she sent us a $1 Venmo, and she said semantics or some antics by the DA.
Oh, that's some good semantics right there.
That was good. And then Julie threw us 20, said, love you guys. We love you back. Julie, thank you. Thank you very much. Candace paid us 10 here for the grift. Thank you so much. We appreciate that. And then Tiff came back and with a $5 Venmo and said, tell Kat to check her Venmo.
Yeah, I am. I'm looking at it right now okay, so I've got a Julie. So I'm assuming similar, same Julie.
Yeah.
Says, thank you. Now I'll say the case name because I was going to say it at lunch. We're almost at lunch once we get past this rest of cross. And again, we're going to do this exercise. Now, this exercise, Julie had told me yesterday, hey, look at the Florida v. Mumby case, Leah Mumby. Look at that case. It reminds me of the crash. And so I started looking at it, and I haven't seen the crash, but I'm like, you know what? The way this is charged, this is very relevant to what I think is at issue, the legal question in the Pino case. So Julie's what inspired that. And she
Julie
also
sent
just
out
said,
the same email.
yeah, and I think you guys are going to
email.
like the thought
Yeah.
exercise. I have the relevant documents for the lunch exercise we're going to do about vehicular homicide and how she's not charged with anything higher than that. And the facts look quite awful. Of course, she's innocent until proven guilty, but we're going to look at what's alleged.
All right.
So she says, thank you for looking into that case. The family lives in New York, and I'm hoping for coverage. I'm interested in the case. It seems like a hot mess. And says, I'm so glad I found you on Defense Diaries. Aw.
Aw.
Yeah.
Yay.
See, what a good,
Love
this
it.
is why we did the hybrid gang collab.
That's right.
And then Tiffany says, just me, or does Adams not only look like she's wearing scrubs, but also comes off as the mean nurse? Oh no, like Nurse Ratched.
Nurse Ratched.
That is how it does remind me of the actress in One Flew Over the Cuckoo's Nest in the movie.
Mhm. It's
Now I'm not gonna
medication
unsee it.
time.
Oh no.
Poor Billy Bibbits never had a chance against
Yeah,
old
and,
Nurse
and comes
Ratched.
off as if she knows more than the board certified neurologist. I'm not
Mhm.
gonna lie, I had the scrubs thought. And I usually don't say those things out loud, but since it's am I the only one?
No.
I
Yeah.
just usually don't say it out loud, stuff
That's
like
pretty
that.
that's pretty spot on, actually.
And
Yeah.
then I got it. Nana Banana says, love your content and how you help us understand. Thank you. And then I Went Outdoors was like, sorry, I announced the other channel in the chat. That's okay. And I was thinking you could stream it and hope I didn't mess it with your views. No, that's okay.
No.
We got the sound. The sound ended up improving moving forward with the stream anyway.
I mean, and
lowering the
frankly, if
volume.
people want to watch Scott instead of us, I mean, that's on them.
I don't know if I actually know Scott or that channel, but I feel like I've heard you guys talk about a Scott before. So if you talk about him, that's his channel then.
Scott's a perfectly nice guy. I met him back when I did CrimeCon a few years ago, and a very nice guy. But I don't know who it was from his channel. They had reached out about doing a collab. We haven't worked it out, but so yeah, different vibe. Scott has at his channel.
And one more, we missed this way earlier. This is from way earlier, but I did not see it, so I didn't pull it up for you guys. From Sheba, that says, actually, I think it's Sheba Biba. Says
Sheba
the
Biba.
keyword was concierge service. So I don't have like dental insurance or anything. I've been a subcontractor. I recently finally quit my quote unquote day job, but I've been a contractor for years and was just working full time then part time as a contractor rather than a wage where I'd get insurance. So I go to a dentist that doesn't do insurance payments because they can keep their office smaller. They don't need to hire a team just to handle all the claims. So for the concierge service, I don't think that that's surprising to me. For someone who's a solo practitioner, maybe to not want to accept insurance, it takes a whole business administrative workload off your shoulders and can let you run your business. And you can find clients that will cash pay, and frankly, I think when I cash pay to go to the dentist, it ends up being cheaper than having to pay for the insurance.
Yeah,
Like,
for sure.
so
Yeah, they really try to rake the insurance companies over the coals. You know, the dentists do, because I mean, they're going to try to maximize whatever they can get. But at the back end of it, you're right. I think we end up paying more. Like whatever our portion of the
unless
coverage
you
is
need
going to
it, like if you're not on the above average
Right.
side of the work that you need covered, which
Right.
that all different factors come into play. But I think the concern is maybe jurors will hear concierge service and think, oh, it's a rich person doctor,
be.
and they'll
Right.
just say whatever you need them to
Right.
say.
Right.
Right? So,
Exactly.
and that's the thing, everything can be interpreted in more than one way, and it doesn't really matter what it really is. Like, the jury's supposed to determine reality, but it doesn't mean that reality is always clear, that the jurors will think the exact same thing.
It's
And
like Laura's like semantic argument about whether chips are broken. Like, if you've chipped your teeth, are they broken? Yes, I would say that you've have you cracked them all out of your skull? Maybe not, but your teeth are still broken if you're
if
chipping
I had
teeth
like
off.
this much like a thumbnail, like of my tooth missing, I would call that broken.
Hunter, if you've ever chipped a tooth, and I still have one of my lower teeth, I chipped like a little corner of it off. When you first do it, it feels like your entire
You can't
tooth is gone. You can't get
you
your
can't
tongue
ignore
away.
it. You got to keep touching it like it's
Right.
different.
It's so weird. It's such a weird thing. Yeah. All right. Let's keep rolling. We got to be
Sweet.
pretty close to the end of Cross. I
Yep,
imagine.
we are. We could speed her.
I'm almost finished, Your Honor, if you could give me just a little bit of time. Thank you. Now, the report that you prepared for this case did not list all those things that we just went through that the defendant actually got right in his interview with Lieutenant Thompson. Did it?
No,
You only listed those 4 things that we've discussed that he got wrong.
correct.
Oh, the camera's all blurry.
You were given an MRI that had been, or the results of an MRI examination that had been done of the defendant's brain from July 1st of 2025. You remember reviewing that? That MRI that you received, you didn't really take that into account at all in formulating your opinions in this case, did you?
I don't think it was very helpful.
Okay. And in point of fact, there was nothing about that MRI of the defendant's brain from July 1st of 2025 that indicate that there was any significant trauma to this man, correct?
It's not specific for trauma, no.
What about other scans?
When you met with the defendant in February of this year, you never asked him if he sought treatment for the supposed brain fog that he had, did you?
Well, I don't remember if I asked him that question specifically, but he did tell me that he was getting treatment and he was improving for his symptoms overall.
Isn't it true that when you asked him about the treatment that he had, he told you that he had had therapy and psychiatric medications, correct?
Yes.
Now, you said that your claim that the defendant could have suffered from amnesia comes largely from the videos that you witnessed of the defendant speaking with Lieutenant Thompson, right?
It's not just from the videos. I look at the whole clinical picture, and he did have a significant trauma. He did have loss of consciousness. He meets diagnostic criteria for traumatic brain injury, and these mistakes that he made are consistent with amnesia.
Right. That being said, though, there was no scientific test that you could administer to this defendant to prove that he had amnesia, was there?
After the fact, no.
Does there exist a scientific test?
You did administer a test called the Montreal Cognitive Assessment Test, right?
Yes,
But that doesn't prove that he had amnesia, did it?
that cannot prove that he had amnesia at the time of the injury.
And in fact, the MRI for the defendant that was done on July 1st, that was normal for a man of his age, wasn't it?
He did have some white matter lesions in his brain, which is not surprising for someone who has a history of high cholesterol untreated and someone for that age.
Right. So it looked like a middle-aged man that might have high cholesterol, right?
It could be.
Now, you've indicated that thus far you've been paid $29,200 for your work in this case.
Yes.
That does not include the fee that you're going to charge for being here and testifying today in court, does it?
No, it doesn't.
You have no clinical tests that you can state to this jury that prove that the defendant had what I think you referred to in your report as a false memory without the intent to deceive, do you?
No, I can't test him for what happened back in 2022.
Now, it was your goal in evaluating the defendant to make a determination about really, what he remembered of the crash, correct?
Well, my goal was to answer the 3 questions.
Right. And part of that was to determine whether or not the defendant remembered what happened, right?
No, it was to look at the entirety of the medical record and determine the answers to those 3 questions.
You did not ask the defendant nor his wife that was with him when you met with him how the crash occurred, did you?
No,
You did not ask how the accident occurred, even though you were trying to find out what he remembered of the events surrounding the accident, right?
well, I had that from the medical record, and he was starting to get very anxious and stressed, and there's only so many questions you can ask a patient before they end up not being able to function on the cognitive testing.
So you never said to him, tell me how this crash happened?
No, I did not.
So you were evaluating his memory without asking him what he remembered, correct?
I was evaluating his memory on the day that he presented to my office.
Right. So you were evaluating his memory, but you didn't ask him what he remembered, did you?
No, I relied on the records and medical records and the Fish and Wildlife report and EMS records.
So again, my question is, you were evaluating his memory, but you did not ask him what happened, did you? I'm asking you if you can give me a straightforward answer. Did you ask yes or no? I understand. But I'm sorry, let me ask the question again. You were evaluating the defendant's memory, but you did not ask him what he remembered of the crash, did you?
I did not ask him all of the details. I started asking him, how were you right before the crash and what happened after, and he started to get very anxious, and so I stopped with that.
Okay, nothing else.
Wouldn't that contaminate his memory if she tried to ask specific things? What did he say? How long for your redirect? Okay, so they're going to go right to
Post-traumatic stress
redirect
disorder
form.
associated with head trauma.
It can be.
And when someone is suffering from post-traumatic stress disorder, do they exhibit anxious behavior?
Yes, they can, yes.
And the type of anxious behavior that Mr. Pino was experiencing in your office that day, would that be consistent with someone who was suffering with post-traumatic stress disorder?
It could be, or it could be anxiety disorder. I can't pinpoint exactly which diagnosis, but he was getting very upset.
Dr. Barratt, prosecutor pointed out that there were 3 mistakes Mr. Pino had 3 mistakes in his memory before the accident, and 1 mistake, I think she said, after the accident. Do you remember that question and answer? That question from the prosecutor a few minutes ago?
I remember she asked the questions, yes.
So lack of memory or mistaken memory before the accident is what we testified to as being retrograde amnesia.
Yes.
And you associated that with the traumatic brain injury, the concussion that Mr. Pino suffered as a result of the crash.
Yes.
And so that mistaken memory prior to the crash is consistent with someone who has just suffered a
Objection,
concussion.
pleading.
Is the mistake, are the pre-crash mistakes in memory consistent with concussion?
Yes, so retrograde amnesia can occur, and it's one of the defining characteristics of traumatic brain injury.
As well as memories, is that true also with memories after the incident?
Post-traumatic amnesia, they define it as post-traumatic amnesia. I refer to it as anterograde amnesia. It's one of the clinical signs that are diagnostic of traumatic brain injury.
Dr. Barratt, if Mr. Pino made additional mistakes in his memory to police officers on the night of the afternoon of the crash, that would only underscore or support your opinion that he was suffering from amnesia. Is that fair to say?
Yes.
So if Mr. hypothetically, if Mr. Pino told a police officer that the damage to his boat took place on the left side of his boat, when in fact it took place on the right side of his boat, that'd be a pretty big mistake in fact, wouldn't it?
It would be.
Showing you what is in evidence that states Exhibit 68. Now, I know that you're not familiar with the way the boat in this case looks, are you?
I might have seen pictures of it.
Oh, where? Where might you have seen that? Police report?
Yes.
So let me show you what states
I've
Exhibit
seen
68.
this image.
All right. So states Exhibit 68. That's pretty simple, but if this is the front of the boat, do you agree?
Yes.
Is this the right side of the boat?
It's the right side.
So if Mr. Pino told the police officer that the damage occurred on the left side of the boat, that would be a mistake.
Yes.
Would that be supportive of your opinion that that mistake in memory occurring after the accident is an example of anterograde amnesia?
It's amnesia. It's amnesia. I don't know if that would be retrograde or anterograde. It's right at the moment of impact. I guess it could be retrograde because if he remembers what hit him and where he was.
One way or another, it's amnesia.
It's amnesia. I just don't know if it's retrograde or
And
post-traumatic.
And in your opinion, would that amnesia be related to his concussion that he suffered?
It fits the whole clinical picture, yes.
If Mr. Pino, another hypothetical, if Mr. Pino told the police officers that he was ejected from his boat in the crash, and that was a mistake, in fact, would that also be supportive of your opinion that Mr. Pino was suffering from traumatic brain injury, concussion,
Yes.
and amnesia?
Yes.
And I'm going to refer you, Dr. Barratt, to State's Exhibit 102. This is the written statement made by Mr. Pino to the police officer that night. And would you read the sentence where I'm pointing?
I was ejected from the boat.
So this is so in fact, that's exactly what Mr. Pino said. It was a mistake in his memory that he reduced to writing when he was asked to do so, right? Would that, is that a yes?
Yes.
Would that also be supportive of your opinion that Mr. Pino, even at that time, was suffering from concussion-related amnesia?
Yes.
And if Mr. Pino Dr. Barratt, does amnesia in a case like this make it impossible to recall all facts that occurred prior to the accident?
No, I mean, we would especially have difficulty with the events that occurred immediately before the accident.
Would amnesia after the accident require that a person not remember any of the facts that happened after the accident?
No, it could be partial amnesia. It doesn't have to be complete.
In your opinion, after evaluating the medical records and the other documents that you reviewed in this case, do you believe that Mr. Pino was suffering from amnesia because he did not remember some facts?
Yes, it's in the diagnostic criteria that we showed. It could be partial amnesia. Yes.
The criteria you're talking about that we reviewed earlier today, is
Yes.
that right? So that criteria you're saying only requires partial amnesia?
Right.
Will refer you to the fire rescue report. You have that there?
I don't have to. Do I?
Dr. Barratt, I want to refer you back to State's Exhibit 119. That was the fire rescue report. Is that correct?
Yes.
And on page 2 of that report, that's Exhibit 119, the prosecutor asked you about the vital signs that were taken near the bottom of the page there. See that?
Yes, it's under vitals, but I don't consider those vital signs, but yes, I know what you mean.
Right? Well, the timestamp that vital sign was taken, well, let's talk about that. The timestamp was September 4th at 23:14 hours.
Yes,
Do you understand, are you aware of military time, what 23:14 equates to, what, for the time that the rest of us go by?
yes,
That's 11:14 at night, correct? Is that correct?
yes,
And at that, in 11:14 at night, the fire rescue paramedic noted that Mr. Pino's eyes were open and gave a score of 4. And by the way, these scores are associated with something called a Glasgow coma scale, is that right?
yes,
That's what the prosecutor was asking you about?
yes.
Can you tell the jury what is a Glasgow coma scale?
So it's a score that is used especially in relation to patients with trauma. And you can give them a numerical score, and one category is, do they open their eyes? So some people won't open their eyes. Some people will open their eyes if you shake them or pinch them, they'll open their eyes only to very aggressive stimuli. Some people will open their eyes spontaneously. And then another category that we look at is if they're oriented. So maybe if they're disoriented, they don't know what day it is, then they would score lower. But this is he was oriented, and this is obeys commands. And then his total score is 15.
15 is the highest degree of awareness under the Glasgow coma scale.
On that scale, yes.
In other words, a person is, I'm a 15 right now.
You're a 15 right now, yes.
Well, I'm awake, kind of, and aware of what's going on. That's a 15.
Yes.
When Mr. Pino was unconscious on the deck of his boat, what would his Glasgow coma scale be in the situation? Right.
Well, it would be less than 15. We don't know because we didn't try to stimulate him. So in order to know for sure, you'd have to talk to him, touch him, maybe rub his chest to see if he wakes up. So we don't know, but it's definitely less than a 15. And then you would see if he moved, also if he opened his eyes, if he was able to talk.
If Mr. Pino had a Glasgow
I'll try to make it a little. I don't know what they're doing with the cables.
coma scale of 15 as it's noted by experiment, 14. Does that mean that he did not suffer a traumatic brain injury?
No, it's consistent with traumatic brain injury,
Like they're
concussion.
trying to play with the cords right now.
One other thing about Mr. Pino's mistaken memory is that he said to the officer, as he pointed out in the morning, he recalled him telling the officer that he was ejected from the police fighting against terror.
I believe that was said, that he was, that's in my report, that he said that he was ejected.
He said it in his written statement as well. Is that right? State Exhibit 119.
Yes, I believe so.
So if Mr. Pino did not even remember that he was on the deck of his boat, as opposed to having been ejected,
Fix
out
it
of the water,
briefly.
that would be good evidence of amnesia. Is that right?
It's evidence, yeah, it's all evidence that fits into the picture.
Concussion-related amnesia.
Yes.
Any further questions?
Judge, what was the condition that he was in?
All right, ladies and gentlemen, we're gonna take our lunch break. We're gonna take our lunch break
Was she
at
trying
five.
to do a recross? Or did they approach for another reason?
I don't know. It was brief.
Whoa.
Evidence that fits into the picture.
Concussion-related amnesia.
Yes.
Any further questions? Thank you.
Judge, what was the condition that he was in?
I think she was asking, right? She said questions about recross.
I don't know. I couldn't make it out.
And then they go up to sidebar and there's no recross, so she tried.
Any further questions? Thank you.
Judge, what was the condition that he was in?
Yeah, she said, Judge, there was a new issue. I'd like recross. So she's saying that something came up in redirect that must have went beyond the scope, and that she loses at the sidebar. She doesn't get to do a recross when she comes back. I don't think.
Has there been any recross at all? I can't remember if there's been any
I think
instance
one
of it in
witness.
this.
I think one witness, the defense was able to ask a follow-up,
Judge
but
is
there was
ready for coffee
another.
break. She's ready.
There was another time where the defense asked for recross because new evidence was introduced and they wanted to cross on it, and the judge said no.
It's Legander.
Yeah, so they just release her. Let's see if they go on their break. Yeah, they let the jury out. So let's jump, see if they say anything to the attorney. Fix the sound online. Right, then the sound is off. Oh, they must be trying to fix the camera. Look, they're going all over with it. Look at them. Oh God, oh God. Turn off the sound.
Oh no, it's getting worse. If that's
Yeah.
possible.
All right, so it
High-pitched
looks like
screeching.
they're not doing like any attorney housekeeping. It's just the guy trying to fix his sound. So it looks like we can bring. Well, who's this all walking? Camera people? Crotch shot.
Crotch shot. Crotch shot.
All right. I want to give like a little listen just to make sure. Do you think that's just banter? Or you think that's like they're talking with the court? Well,
I
the court
think
reporter's not here, right? That's
I
the
think
court
it's just
reporter's chair.
banter. Yeah.
Yeah, because the court reporter's chair is empty. So shout out to the camera person for having the court reporter chair there. So they can't be on the record. All right, so let's get the chat back. Let's get the chat back.
Let's go.
Oh my goodness, I hope that the beep noise and the buzzing goes away.
It's a lot. It's a lot.
YouTube.
Oh, there it is. Okay. And
All right,
they're
my
back.
chat should be back.
And they're back.
Dun dun dun.
Welcome back. Welcome back. Welcome
Everybody
back.
run it once. Get them on the screen. These are going to be the old comments. And yeah, I think Factual Lie was first again. I see Freedom and I see YSL Kells over here saying, go, 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 go.
Oh, look, y'all are back. We back.
That's awesome.
Good.
We can keep Allie on the screen because it keeps you out of the chat overlay.
Yeah.
That way you're not getting blocked. All right, so we have a food for thought exercise. I guess I should change the banner to say we are on lunch. That way people know. All right, lunch banner is ready to go. We've got a little food for thought we're going to do again. Julie's like, hey, check out this Leah Mumby case. It's like the crash. Oh, why is it telling me I don't have permission to access the docket? Let me refresh. All right, give me a second, Bob. Keep the people entertained.
I shall. All right, so if you guys are late to the party, what we're going to do, one of our viewers sent us both emails regarding a case that Julie said was very similar to the Mackenzie Shirilla case, which was the subject matter of the recent documentary on Netflix called The Crash, which a lot of people watched. A lot of people had thoughts on. That was all the rage there for about 3-4 days. But at any rate, the fact pattern apparently is going to be somewhat similar to that. It sounds like it might be far more egregious than what happened with George here, yet there's a discrepancy in the charges. So what we're going to try to do is figure out whether or not any of it makes sense, because obviously we've got Miss Adams, who we all know seems to have taken a real personal interest in this case. She's taken upon herself to get justice for the Fernandez family, who, she believes deserves it. She got some resistance from her boss early on. Whatever happened behind the scenes, ultimately they ended up upgrading the charges to the felony charges that we're seeing here at trial. So we thought it would be cool to try to figure out. Obviously, I'm assuming these are different prosecutors' offices, right, Kat?
Different counties. And with
So
different investigating agencies. So we're going to be dealing with the Florida Highway Patrol for Leah Mumby.
yeah,
My
so
brain wants to say Crumbly.
Crumbly, the Crumbly family are
Uh,
all in prison. Yeah. Yep.
It's like, it's having me do captures I've never seen. It looks like Mahjong.
That's interesting that you said that, because as soon as you said that, it made me think of that case in terms of the prosecutors up in Michigan really being the first ones in the country to take a shot at getting a conviction on parents of a school shooter. And it wasn't like in Crumbly, they didn't go so far as to manslaughter. We had to wait for Colt Gray for that to happen. Colt was the dad, right? And that was down like Colt. So Colt Gray
Colin
was
and Colton. Yeah. Right?
so
Colin?
he ended up getting charged with manslaughter. And that was the first time, because the charges against and that was a two-part thing that had to happen there in order for them to get to the manslaughter charge against Gray. Here it's different. It's a different set of facts. Yeah, that's
All right, I got it.
interesting to me as to whether or not those cases and the fact that they were able to get convictions on them, whereas you had never seen that historically anywhere in the US, parents being held responsible for their children's actions outside of their presence, based on what they knew or didn't know. Hey, we wanted you to be a part of this thing here.
Taking him back to the yard.
What? No.
He has to go.
Uh-oh. Well, in the meantime, while Bob and Allie figure out the logistics of taking out I think they're taking out the dog, it sounds like, going out to the yard. We've got Sheriff Chuck with the 5 gifted again. So people are turning green over here in the chat. Love to see it. Big thank you to Sheriff Chuck holding it down. Stream sponsor. Kind of as always, like the de facto stream sponsor, making sure the chat can use those channel emojis. Thank you so much. We've got, right now I just have the docket up. We're not going to get into too much. It's a lot of just, in Florida, as you guys have probably learned over the course of this case or any other Florida case, Florida is very friendly for depositions in criminal trials. Defendants should have access, unless the court finds a reason otherwise, to have like a pre-interview, a deposition, which is sworn testimony, before we get to the trial stage. So a lot of these are notices that we want to do depositions, or that we're taking a deposition, or that we need help getting a subpoena to secure a deposition. So it looks like the docket has a lot of activity, but really not so much. We have the initial complaint. We're going to read the amended complaint, and I'll tell you which count was added. And we're going to look at the arrest warrant affidavit. We also have we might talk a little bit about the discovery that's been turned over so far. A lot of it's really just like first responders, pictures of the accident, and witnesses who were present at the time, as well as we have statements from the defendant that we're turning over to you. So nothing too significant. And then I think Allie and Bob might both be taking out the dog. So we'll see on that one. Also, hold on here. Shout out, I see Deb on Venmo says, not sure what the DA is doing, but she's not doing it effectively and sharing the grift dollars. Well, thank you so much. Thank you so much. Do it for the grift. And yeah, I think if people are going to think George Pino was lying because he was actually drunk, I don't think that medical examiner is going to move the needle. And I think it's fine if you guys want to think that he's drunk. I'm not opposed to that. I think it's very realistic to wonder, like, hey, there might be some jurors that think that. But for me, my stance is that I don't think that the state has come anywhere near proving intoxication. I
No.
just don't see the evidence on the record. And if the jury follows that instruction, I think that's the tricky part for the state. And that's why they really need to hone in on the statement that I saw this boat that nobody else saw. And show that the only reason he would say that is to lie about his because he knew he was intoxicated.
Well, what I was seeing in terms of, that kind of traumatic amnesia that's brought upon by, like a blow to the head, which he clearly had. I mean, there's no question he struck his head violently, either against the boat or the boat hit his head, whatever the case may be. I mean, you have to, in order to split your skin open on your skull, as I'm sure all of us have bumped our heads throughout the course of our lives, rarely are you bleeding unless you really maybe hit a corner or, it's a really, really intense shot to the head to where it's going to split the skin, to where he had to have 7 staples put in his head, which is not an insignificant amount of staples. So at any rate, I mean, I think that the fact that he struck his head, and again, I'm gonna kind of try to push you towards that concept of if he's making up the lie, and like you said, I mean, people can lie for all kinds of different reasons, but it's also symptomatic of traumatic, not even brain injury in general, but just specifically amnesia, where you can confabulate in order to try to just plug in holes in your memory of the event itself. You know what I'm saying? Like, and if he was calculated in telling the lie, what I'm trying to say is that it was a bad calculation, because there were too many other people on that boat that would be able to say, no, there was no other boat that came by, or I didn't see a boat come by. It was too easily blown apart for it to be calculated, in my estimation. I just think that whatever he was doing in terms of saying it was trying to fill the gaps in his memory, which we're all prone to do. So I don't know. And as far as the intoxication part of it, it's really annoying to me because they didn't charge him with boating under the influence. All right, hold on. Allie's got to come out.
All right, and Beth Ann asked, was his BAC taken after the incident? So he refused the blood draw on the field, like at the boat, when he was speaking to FWC, and that was not played. It was redacted from the body cam footage. So the jury didn't hear questions about, like, do you want to take this field test, or hear him say no. We heard about that outside, and we're familiar with that he refused. Later, around 11 p.m., he has like a 0.00 when he's at the hospital and his blood is drawn, which to me, I don't think we'd get to a 0.00 at 11 p.m. if he was like inebriated and was supposed to still be inebriated around the time of the accident. That's just my gauge on it. But again, I don't think that the jury is getting into that information. So, my analysis is really about what we know on the outside. And then what was interesting is, because this redaction was going to take place with the body cam footage, where the jury was not going to be able to hear the, when there's an accident like this, we want to do a blood draw. Do you consent? And he says no. With that being redacted, there was an issue on like day 2 or 3 where the state and defense were going back and forth, because the state tried to, maybe they don't look at it this way, I look at it as they knew there would be a gap in that audio as it was being played for the jury, but there was still some transcription where there was going to be discussion of, I had the 2 beers. And knowing that there was no context proceeding that the jury would hear. The state presented that 2 beers statement as if it was just something somebody was trying to like wave an excuse around. I only had 2 beers. I don't know why you guys are even talking to me right now. Meanwhile, he said I had 2 beers in response to this line of questioning about the test and the ordinary procedure for this type of accident. And so the defense was like, hey, look, the transcript has words on it for things that they're not hearing. We're not hearing the audio, and can we clean this up? So the state had to go and ask the witness, like, hey, and there was a question about alcohol, and that's why this discussion started happening, right? So they had to like work back what I think became a weaponization of that redaction and say, like, actually, it wasn't just a spontaneous utterance. This guy's just randomly volunteering that he only had 2 beers, which is something that the jurors very well could think, why are you trying to throw that out there in the middle of nowhere unless you're trying to cover your ass? And I think that was a critical thing that the defense needed to clean up, like the type of thing that if you didn't clean that up, you're ineffective.
Yeah,
Because there's no strategic reason to leave it.
No, I agree. Mara had said Bruce Rivers, a criminal lawyer, says people should refuse blood draws and DUI tests. I mean, every criminal defense attorney says that because
take the ride.
I mean, you're giving the state the most compelling evidence that exists in a DUI case. So, in Illinois, what they've done, and they understand that. So the state, in every state's different, but in Illinois in particular, it's an automatic summary suspension of a year of your driving privileges if you refuse either blood
and
draw.
It's a separate proceeding, right? So you end up having 2 actions.
Yes. Like you can refuse, go to trial on your DUI. We can prevail at trial where you're found not guilty of being, driving under the influence, and then your summary suspension stands. So it's one is the state of Illinois, the other is a criminal proceeding wherein the two shall never meet. Now I can attack the summary suspensions if they sworn statement isn't, in every sworn statement in Illinois, that's how they get around due process in Illinois, is they have a sworn statement that's attached to the paperwork that goes to the state when the state's deciding whether or not they're going to give a year suspension or 6 months, because a lot of times we'll have clients that are like, well, I tried to blow, and they couldn't register any kind of output for it. And, the cops always take that as somebody who's not really blowing as hard as you need to, that they're just kind of faking it, so they consider that to be a refusal. And, when those sworn statements come back, they all read the exact same. It's always bloodshot eyes, slurred speech, strong smell of alcohol, and they all read identical. Every cop in Illinois is taught exactly what they need to write on those sworn statements, but that allows the state, without any kind of hearing taking place, suspend the driving privileges of Illinois drivers. So, I mean, if you want to beat the DUI, which you should, and again, every jurisdiction is different. Typically in Illinois, if it's your first DUI, most lawyers are going to be able to secure you what they call a supervision penalty in terms of what you're sentenced with, which means that they stay the conviction. Okay, so you go in, you plead guilty, but you're given supervision, and if you can last the 12 or 18 months without violating any other laws, and if you go and do the victim impact panel where you go and watch people who have been affected by drunk drivers and how it's affected their families, and you're forced to listen to that so that it maybe resonates with you as to why you shouldn't drive while you're intoxicated. And then you have to go through your drug and alcohol eval. You have to go through whatever level you're found to be at in terms of aftercare. And if you can finish all that, then they drop the charges at the end of the day, so you don't have a conviction. And DUI convictions, most states are incredibly tough. Like, proportionally speaking, in terms of misdemeanors, there is no harsher penalty in any other misdemeanor than there is with DUI. So they take it very seriously in Illinois. And, ultimately, if you have a conviction for DUI, I mean, there's countries you can't get into. You can't get into Canada if you have a DUI conviction, you know,
Yeah,
if
they
there's
will turn you
multiple.
around at the border.
Yes, they
I
will.
actually had a friend call me to pick them up because they got stuck at the border and all their friends continued to go through and they needed a ride back because they
Yeah.
were on probation for some, like, I forget what it was called. It's like different. It was like
Yeah. So
like some type of impairment that doesn't specify alcohol, like one of the acronyms. But yeah, they
oh,
got turned around. They got turned around at the border and were just stuck because their friends kept going.
hey,
So
take care. Have fun. Have fun up there.
yeah. But I
Um,
was thinking other reasons, like to not blow. I mean, there's this idea that why wouldn't you blow unless you'd been drinking? Well, you have stories like Taven Galanakis, who blew a zero, was arrested anyway, and it became this whole whirlwind. There was so much going on in the Taven Galanakis saga. Blew a zero, was arrested. Of course, when you're arrested, it gets published that you were arrested and why you were arrested. So now his reputation is out there getting damaged. There were issues with that, and the community was concerned why this guy got arrested when he blew a zero, and there was no other logical basis for probable cause. And a man named Noah Peterson, I think, Phillipson or Peterson, Noah Peterson, I think, spoke out about it at a council meeting and said that this is fascism for them to be arresting this guy with no probable cause. When the body cam shows that he blew a zero, why are they still prosecuting this guy? They end up arresting this guy who's speaking at the city council crying out about this matter. So it turns
what?
into this whole, it's like this whole thing. Just
What?
Google Taven Galanakis.
Wait,
Taven
what did they
Galanakis,
arrest the guy speaking out for?
disorderly conduct or
What?
something.
That's outrageous.
Yes. So there emerged different civil actions. Taven Galanakis recently resolved his jury awarded damages and found the officers and the city liable, city of Newton, Iowa liable for like the false arrest, malicious prosecution, all of those different causes
well
of
they should
action,
have.
violating his rights, and awarded him monetary damages, like $105,000 total that they awarded him for this time where he was arrested. And there's still an ongoing civil action from Noah Peterson that I think the Institute for Justice is helping him with. The guy at the city council meeting who was using his free speech to speak out at a government meeting about something the government was doing, and ultimately ends up getting arrested. So 2 civil actions spawned from this guy who did the test, blew a zero, and he was screwed anyway.
Yeah. And
So
you know, I mean, the reality is that many times people may have imbibed a bit, you know, like, well, yeah, I had a beer. Like, and you know, look, the first rule is you never say anything to the cops. So as soon as you've made that statement, you've already made a horrific mistake admitting that, you know, because the cops are always going to ask you, where are you coming from? Oh, over in my friend's house. Yeah, had anything to drink? Oh, yeah, you know, I had a couple of beers, you know, that typical thing that everybody says. You know, if you've made that statement, you're already up against the 8 ball. I mean, I always advise people never to blow. I mean, it's you're giving the state the strongest evidence that exists in a DUI case. Period. End of story. And if you have people that are like I legitimately only had 2 beers, but you know, alcohol affects everybody differently, and you know, it's like you just don't want to give the state that evidence. So I mean, you have to go in knowing that you're going to take the beat on it, though. You're going to get a year suspension on your license. In Illinois, they have a workaround. It's a giant pain in the ass, but you can get what they call a BAID, which is the interlock system that you put on your steering column, and you got to blow into the tube. And if it registers zeros, then your engine will start, you know, and it takes like 15 minutes. There's no hopping into your car and driving when you have the BAID. It's like it's a whole procedure that you have to go through to get the engine running. And, you know, you're wondering about workarounds. Like, what happens if I have somebody like in my passenger seat and they do the, you know, maybe, but, you know, that can keep you driving. You know, you used to be able to go in and get like a provisional license to get to and from work, you know, because you don't want people losing their jobs.
because that only makes it worse. What do people do when they lose their jobs?
Drink. I mean, it's a vicious circle. So yeah, it's but yeah, we always give the same advice. I always give the same advice. You know, I mean, like obviously you're in a situation where you like haven't consumed anything. You know, I mean, I think the situation Kat was talking about is probably hopefully rare-ish. where you're getting arrested, even though
And then you continue, right? Like maybe the arrest happens, but maybe we don't continue with the shenanigans after we realize that this isn't enough.
right.
Right. But
Exactly.
I don't think the arrests are necessary, or the concern. Like, I don't think we should have a chilling effect entirely where we don't want to investigate things because it might not actually be true that someone's guilty. Like, I'm not an advocate for thinking we should never
A
suspect
free-for-all.
people of anything, but I also don't agree with, yeah. But yeah, there's like other things. So Kitty Koo is saying here, like, hey, there was a case where a girl had one drink hours before being pulled over, but was trashed because of eating bread. So like the keto diet, especially, so there's different types of tests. You have the little thing that you blow into,
Yeah, the
that is usually the
breathalyzer.
field test device because you don't have to draw blood to do it. And it isn't perfect. It doesn't only detect one type of alcohol. And if someone is doing the keto diet or is otherwise dealing with ketosis, which produces a different type of alcohol than would be the alcohol in an alcoholic beverage, that can still trigger something that would be above the legal limit, even if you didn't have any alcoholic beverages.
False positives.
And a lot of people aren't aware that that could be a concern. Diabetes is a common factor that could cause something.
Yep.
There was a lady in New York. It was an elderly lady, and it was something going on with, like, when she would drink orange juice, something with the sugars, fructose, her body would metabolize it in a certain way. She got some type of driving under the influence charge because of what she was eating. And she went through the motions to replicate with some doctor or dietitian or something what would be produced and what could be detected on the field test to prove her case that she wasn't driving while actually under the influence of alcohol. Yeah, but it took her like years to do.
Of course. And money.
And she, if I remember, she fought it. Like, it was one of those penalties, like you said, like, oh, we'll get rid of it if you follow the stuff. But
Like
she continued to fight it
supervision.
anyway
Yeah.
because she was like, I just didn't do this. I
Right.
don't even like that I was accused.
Good on
So,
her.
You never know.
Fortunately, she had the resources to do that,
And the
So
patience.
Kooky Carolyn, she had asked Bob, can you ask Allie if she would put him, and I'm assuming that means George, on the stand if Allie is still there. Allie is we weren't talking about taking the dog out to the yard. We were talking about my dad wants to go back to the ER. I had taken him earlier in the week.
Oh,
He's still not
sorry. I heard you
sleeping.
guys say something about the yard. I must have been ER. That was me.
Very easily, I could have kept it that way, but Allie's like, so Allie's taking my dad to see if they can figure out what's going on. He just can't sleep.
That's good.
He's got terrible insomnia. So
it's good that Allie's doing that.
I would not put George on the stand. I could tell you.
I don't think he needs to take the stand. I mean, there's always that everybody wants to hear from the defendant, but I think that in this case specifically, some of the sentiment is so, like, if he cries on the stand, people are gonna say that he's guilty because of that. If he doesn't cry, he's gonna look guilty because of that. Like,
there's no winning. There's no winning putting him on the stand. You're gaining nothing, and you're exposing him to the one question that we all want to know, which is, does George have an actual recollection of what happened in that moment in time when he was distracted? Because clearly he was distracted. I don't think that if we're to believe the 2 beer situation, which again, I have no idea why it's even allowed in, he has been charged with it. And they're imputing intoxication onto him, throughout this entire case, the state has, as if he has been charged with it. Certainly they didn't have enough evidence to charge him with that. Otherwise, you can bet your ass they would have. And we're talking about a completely different case. If they had the evidence to prove that he was intoxicated, you and I aren't sitting here like, well, I don't know. I mean, if he's drunk and he crashes the boat, well, yeah, you go to prison, and you should. So, I just don't think that, above and beyond the fact that they don't have the evidence, which is the own fault of the investigation, I don't even think if they had the evidence that he was intoxicated to the point where he was not under the legal limit to be operating the boat. Like, I don't know the man from a hole in the ground, but I would have to think that, like, my wife, back in my drinking days, if I were intoxicated and I had precious cargo on the boat with us, Allison would have said, no, you're not driving, you know, and I would assume that Miss Pino would do the same thing, right? If she knew that George was under, because she
Well, and
was certainly hanging around with
the other
George
parents,
and
like
any of them. I mean, they were there for probably too short of a time. And like, I kind of get the impression they popped in for like an hour, hung out, and then most of them left. I don't know if any of them stayed for the duration. You know, you're probably your best bet in terms of the reality of the situation would be George's wife. Like she would have known, like, or she would have been like, hey, you know, maybe slow it down there, big guy. You know, you've already had two. You know, kind of
I
keeping
think
that.
that's something I can't picture being drunk on a boat and not feeling like somebody was speeding, even if they like weren't. Like, I
Yeah,
think that combination would make me feel like everything was moved like spinny.
yeah.
But I
I
don't know. I'm
mean,
not about that life, so
that's what I'm
I don't
saying.
have
Like,
personal experience.
all these kids are about that life, and you know the Pinos are about that life. It's
I do
you know
not
it
have a
is that
boat.
really is a culture, and you know it's like I've done a fair share of boating, both as a passenger and when we've rented boats on vacations and stuff. You know, nothing like the size of like what George has. You know, like smaller type boats that we get for, you know, probably that don't go any higher than 40 miles an hour, I would say is probably the max speed. But you know, it doesn't feel like crazy fast. You know what I'm saying? And like you get acclimated to the speed. And typically we're on
Mhm.
like sport lakes, you know, so it doesn't feel like you're like I'm typically like, man, I wish this boat went faster so I could lose the girls on the tubes, you know, because they're always hanging on and I'm trying to like swerve around, trying to get the tubes to like hit little wakes so they get a little air and, you know, to make it fun. You know, but you're always watching. Like that's a situation wherein if I'm towing girls on the back on a tube on a like a relatively busy sport lake, you know, I have to like I'll turn around when they tell me that like all the people sitting behind me tell me that the girl has dropped, that she's off the tube. I'm then, you know, like I'm turning around briefly because I'm gonna circle back and go pick her up, right? You know, so there, I mean, there's just times where I'm not always looking forward, you know, out of necessity because I'm kind of
Looking to
doing
make
a
sure.
U-turn. Yeah, you know, so
You'd
it's
be
like
negligent if you didn't look around. You'd be negligent if you didn't check behind you on the tubes,
right. I
make
mean,
sure
like
everyone was still there.
I'm not trying to yeah, exactly. I mean, if you're on the tube, if you've got kids on tubes and you don't have like a lookout, that's a bad idea. Like you have to have somebody else on the tubes. Like I would never go out like just solo with like say Scout. She's like, Dad, let's go out and bring me unless the lake was completely empty. But still then, you know, it's nerve wracking because you know I don't have eyes in the back of my head, you know. So it's like I won't necessarily know when I dumped her. But all right, is this that other case you were talking about?
Yes. So
All right.
initially, so guys, we are talking about Leah Mumby, another Florida case where I want you to pay attention to the charges. Initially, we had moving traffic violation. This is a vehicle, not a vessel. Moving traffic violation, reckless driving causing serious bodily injury, and then aggravated battery, person using a deadly weapon, where the vehicle is the deadly weapon. So Allie
Mhm.
broke down a lot of case law on that. Again, this is Florida. So what we talked about with Allie on day 2 about this deadly weapon thing is this is how they're using it with the vehicle.
Yeah.
This is back, let's see, we'll get the narrative here. So back on February 9th, 2025, Leah Catherine Marie Mumby was in operation of a white 2019 Honda Passport. That's vehicle 1. Vehicle 1 was traveling northbound on Interstate 95 near mile marker 291 in Flagler County when it ran off the roadway to the right. The right front of the vehicle collided with the standing tree within the wood line on the east side of the roadway. Vehicle 1 rotated in a counterclockwise direction and came to a final rest within the wood line on the east side of the roadway, facing south. As a result of the collision, the driver, who was later identified as Leah Catherine Marie Mumby by her Florida driver's license, suffered serious injuries. The passenger, who was riding in the right front seat, later identified as Daniel Waterman by his license, suffered serious bodily injury. Leah had to be extracted from the driver's seat as a result of the collision by the fire rescue. Daniel had to be extracted from the right front passenger seat by fire rescue. Upon speaking with Leah several days later, after Leah was released from the hospital, Leah claims to not know what happened prior to the crash and only remembers waking up in agonizing pain. A warrant was issued to obtain data from the EDR from the vehicle at the time of the crash. The following information was obtained from the EDR, and this is something that we don't have with the vessel here for George. The initial conditions, so, 5 to 3 seconds before the collision, the vehicle is moving steadily around 93 to 95 miles per hour, 3 to 5 seconds prior to the crash. The accelerator input increases 4 seconds prior to the crash. The brakes were not applied, ABS was inactive, and stability control was not engaged. A notable steering input of 45 degrees to the right at 3.5 seconds prior to the crash, followed by a sudden left input of negative 30 degrees at 3 seconds prior to the crash. So remember, they're going off the road. I think my camera might be flipped, but they're going off the right side of the road, and the driver would be on the left side, right? So the tree line would be closest to the passenger. And so it seems like this direction, we're veering off the road towards the tree line and then veering to the left a little bit at the last minute, as if maybe like grazing that side of the vehicle, right, would be the ultimate outcome you'd expect with that type of movement. So then we've got braking is initiated. This is just the 2 seconds onward, the final 2 seconds before the crash. At 2 seconds prior to the crash, service brake and ABS activate. Stability control activates at the same time, indicating the system detected a loss of stability. The vehicle decelerates sharply from 93 miles per hour to 52 miles per hour at the time of impact. Significant steering input reflects aggressive maneuvering. The RPMs. The RPM rises from 2200 to 3100 RPM 2.5 seconds prior to the crash, suggesting acceleration or high engine load before dropping rapidly as brakes take over. Impact point. This is the time of impact. The speed was 52 miles per hour. Accelerator pedal was 100% throttle at the time of impact. Brakes are off. Stability control is still engaged. That's a systemic thing. Steering 175 degrees, indicating a hard right turn. The injuries Daniel Waterman sustained due to the crash are as follows. So they go through all of his injuries, right? He's going to be in a coma for some time. He's got a C6 through 7 fracture, cervical spine injury, a clavicle fracture, femur fracture, hip dislocation, epidural hematoma, pneumothorax with pulmonary contusion, zygomatic and temporal contusion, talus fracture, and then Mr. Waterman's injuries were considered life-threatening at the time of the crash.
Also,
On May 15th, so this is get this is going to be very, very different fact. We are like February 9th is when this happens. May 15th, 2025, according to the officer preparing this information, this narrative, I conducted a recorded interview with Daniel Waterman, the passenger. In his interview, Daniel stated that he and Leah were in an argument due to personal issues, with Leah finding out she was pregnant that day, and a text message Daniel received from a female friend in New York. Daniel and Leah exchanged expletives. Daniel stated, Leah began driving recklessly. Daniel stated she slowed down to 50 miles per hour and he tried to get out of the car. But then Leah began to speed up to 80 to 90 miles per hour. Daniel stated the last thing he remembers before the crash was Leah told him, I don't care what happens, you'll get what you deserve, and swerved off the roadway, colliding with the tree, making Daniel incapacitated. Based on the facts of my investigation, Leah intentionally crashed her car. This is evident due to Leah telling Daniel she does not care what happens and tells Daniel he will get what he deserves, and the data retained from the vehicle EDR. Due to the fact that this is the last event Daniel remembers before the crash, I have reason to believe Leah made these statements and immediately swerved off the road to crash her car. The results of the EDR is consistent with Daniel's recollection of the events of the crash. Due to Leah driving at a high rate of speed and intentionally swerving off the roadway to crash the car, there is sufficient probable cause to charge the following statute. So they do reckless driving causing serious bodily injury. Then they explain that Leah drove the car in a willful and wanton disregard for the safety of her passenger, Daniel Waterman, not watermelon. Due to Leah's reckless driving, Daniel sustained, my brain just wanted to say it. Daniel sustained life-threatening serious bodily injury. CPR was performed on Daniel at the hospital multiple times. Daniel had obvious deformity of the right femur, deformity of the left hip, along with spinal injuries. Due to Leah using her vehicle in a manner with the intention to cause serious bodily injury or death to Daniel by intentionally crashing her car, there is sufficient probable cause to charge the following statute. So we have aggravated battery with a deadly weapon. Then, so that's where we're getting into some intent, where we get a divergence here a little bit.
Mhm.
Although, remember, as part of the manslaughter by culpable negligence, the state in the George Pino case included a possible enhancement classification for the use of a weapon, being the vessel. As of July 16th, 2025, Daniel Waterman is still at the ICU. He has now passed away. He is no longer alive.
Oh
So at
man.
the time this was prepared, he was still alive in a
Jeez.
hospital in Daytona.
What was the year of the crash?
This was February 2025.
Oh man. So he was in
So-
there he fought to live for months, huh? Man. That's brutal.
And then we heard the two initial charges. So again, reckless driving, and then the aggravated battery with the deadly weapon, a lesser of aggravated assault. And then they added vehicular homicide. So here's how they're charging it, right? This is how it reads. So on or about February 9th in the county of Flagler, Leah did drive a vehicle in willful or wanton disregard for the safety of persons or property, or did flee from law enforcement officer in a motor vehicle, contrary to Florida statute 316.192, and Leah did, by reason of such operation, cause serious bodily injury to Daniel Waterman. Now, do you think the facts as alleged support this willful or wanton disregard?
Yes.
Do you think the facts here are a similar willful or wanton disregard if we were to compare this to the vessel crash with George Pino?
No, it's not even close. It's not even
And
close.
I don't think the state's even alleging something that gets us to willful or wanton.
They're completely like this is closer, much closer to the Sharilla case. There, I don't think there was any evasive maneuvering with the steering wheel. I might be wrong. I don't think that there was. She never let off the gas at any point in that particular case. Here, and you had similar statements in terms of, they were arguing. The relationship became kind of a main element of that case in terms of why she may have done what she had done. But this is a completely different set of circumstances than George Pino. There's no part of George Pino purposefully, willfully, and wantonly trying to drive into or steer into the channel marker. There's that is not a thing here at all. And this is the same state. I mean, like the deadly weapon aspect of it. I mean, frankly, anything can be
Used in a
deadly
manner.
weapon. Yeah, I mean, like I could think of a million things that I could kill people with. Might take more work depending on what you choose, but I mean, like anything, certainly a vehicle falls within that. I don't know if there's any weapons more deadly than a vehicle. I mean, they're pretty deadly. They can be.
Yeah, and this vehicular homicide charge, which to me is the most egregious because it relates to a fatality, right? This comes about because now we have a fatality. There's also been additional discovery where like family members were sharing messages of issues like that day or that weekend, somewhat close in time, not like 4 years prior. And it seems like they have a text message, and I think maybe I have it written in an article. So let's get through these counts real quick. But vehicular
All right,
homicide.
wait. My coffee has come home to roost, but I want to hear these counts. So can you keep the kids occupied for about 3 minutes or 2 minutes, maybe a minute?
Run,
a minute.
Bob.
All right,
Run, Bob.
I'm going.
He wants to hear the counts already. We can read an article. Let me see if this is. Let's see. I'll go over here. This was from 7 months ago. A young Florida father-to-be was left in a coma following a violent car crash. He regained consciousness long enough to rat out his girlfriend. This is the New York Post writing this, if you couldn't tell by the language choice. He regained consciousness long enough to rat out his girlfriend. And maybe the detective's making that up. Like, maybe it was like, oh, yeah, he woke up and told me, and then, like, I don't know. Is this recorded? for deliberately causing the crash. And if someone passes away and they give this type of statement, the state is going to argue to the judge, look, we know he's an unavailable witness because he's deceased, but this is incredibly probative. This is, we have the body-worn camera available from when he gave this statement, when he said this to the officer. And because he's available, we need to be able to get this in. Like, I really don't think that a judge would not allow this statement to come in unless there's an issue with, hey, we don't actually think this person said that. Or we can prove that he was completely out of his mind and there's no, the statement shouldn't have been taken. But I highly doubt that this will be able to be kept out for the purpose of a trial. They say that New York native Daniel Waterman implicated Leah Mumby as he claimed his girlfriend sneered, "I don't care what happens, you'll get what you deserve," while the pair were driving along I-95 in Flagler County during an argument the night of the Super Bowl last February. With Mumby, 24, allegedly behind the wheel and Waterman, 22, in the passenger seat, the car barreled into a tree, leading the beau to suffer severe injuries that left him in a coma. Like, they just have to add the language flair here. The victim's mother told Syracuse.com. But the Syracuse area native recovered enough to speak with investigators via a whiteboard. So he's writing on a whiteboard, which led to the claims that his girlfriend caused the crash, according to an arrest affidavit obtained by People. He told authorities that the two started fighting after Mumby found out she was pregnant and after he received a text message from a woman in New York. His mother, Heather, said that he was merely texting a friend who was a fan of the Eagles, while her son was a fan of the Chiefs. The two teams squared off in the Super Bowl. Mumby eventually started driving recklessly and slammed her car right into the tree. Mumby, who was also badly injured but survived, claimed she didn't know it led to the crash. Her unborn child also survived, and Mumby has since given birth. Waterman made enough of an improvement that he was transferred from Florida to Upstate University Hospital in Syracuse to continue his recovery in July. That's a long transport. But he died of pneumonia on October 8th. Heather says he never gave up. This whole time, he literally never gave up. Mumby was initially charged with reckless driving causing serious bodily injury and aggravated battery with a deadly weapon in July before she was hit with a vehicular homicide as a result of Waterman's death. And People cites the cops. Waterman's kin is now focused on fighting for custody of his apparent child. Heather Waterman vowed to wage a legal battle to prove Waterman is in fact the father and bring the child to New York. "We'll do whatever we can to bring her to us," she told Syracuse.com. "We want her raised in New York with his family." So they've got photos of Daniel before the accident and while he was in care after the accident, and a picture of Leah down here, a mugshot. And then, let's see. I think that might be the end. Let's see.
So the baby obviously survived.
Yeah. Yep.
Do we know, was he wearing his seatbelt? That's always a fact that I want to know. You know,
they
I
don't
mean,
specify it.
because
I don't think I saw that specified anywhere.
like I don't understand when they're writing up these police reports,
They leave details like that out when
like
they looked at the EDR.
which is an important detail. Like I think you'd be more inclined if you know that, say for instance, you're her and you've become unhinged because he's talking to another girl, you're pregnant with his baby, you're young, you're impetuous, you know, you're furious, and you're, you know, deciding to do something rash. To the extent, if you're putting that much thought in it, and it's hard to know in the seconds leading up to this, like in the heat of an argument when she's doing something just so insane, whether or not she has the wherewithal to be like, all right, well, he's not wearing his seatbelt. If I smash into a tree, I'm going to be fine because I'm wearing my seatbelt, but he's not. So he's probably going to die. You know what I'm saying? In terms of intent, I don't know. Like it's a helpful fact. I wish, because I didn't remember seeing it in the Shrilla thing either, because she had two passengers in that vehicle, one her boyfriend and another a friend. a complete innocent to the entire situation, sitting in the back. And I never saw anything. And people were saying, oh, yeah, he was wearing his seatbelt, but I couldn't find the trial and I never saw it in writing. So I take it with a grain of salt, whether that was actual information that was presented at trial. So this is pending trial. Yes.
Yeah, she waived speedy trial and there's been continuances. So I think the date right now is like July. It's July
Who's this
something,
little
but I wouldn't be
guy?
surprised if it gets pushed back.
Who's this little guy right here?
I actually don't know. It's a different relative. I think it's like a relative of Daniel. She's like an older
Oh, that's
relative.
Daniel when he was a young guy.
Yep. Where was this? This is the vehicle, picture of the
Wow.
vehicle.
What was that? Like a
Honda
SUV or
Passport? Honda Passport? Let me
what
see.
is that portion of the vehicle over to on the opposite side? Is that
I think it's in a junkyard, so it's just another vehicle.
I was like, what? That thing got mangled and it looks like it was they were like towing a
Okay, here's a random Honda Passport picture. Let me open one up. Okay, this is a dumb picture, actually. Let me not do that one.
All right, while you're looking for a picture, got a couple more Venmos came in. Kim, our daily Venmo angel, sent us $25. Thank you so much for your constant support, Kim. We adore you. And then Safi Bay, she paid us $5 and said, crotch shot. And then the Iceman cometh, says, it's Iceman. I genuinely can't stand this prosecutor and her demeanor bothers me. Also, can I get a what up, doe? What up, doe, Iceman? What up, doe? Thanks, brother. And that was a incredibly generous $50 that Iceman sent. You're the best, bro. You're the best.
So there is what the car is supposed to look like.
Well, it doesn't look like that anymore.
Yeah.
That was high. And that's impacted 50 miles an hour, right? That's what they said.
I'm always confused by that because is it registering impact because it's registering right after the instantaneous slowdown of colliding with the tree? Because
I don't know.
In the 2 seconds before, it says that she was full throttle on the gas pedal.
That was
at the time of impact.
Confusing to me. Like the throttle, the gas pedal's fully engaged. That's what it says, at least according to the black box. But there was kind of conflicting information that came out. Like at some point, and you don't know, like when you're going off the road, it's not like you're on paved gravel or a paved road, like the swerving, like trying to, she may have lost control of the vehicle, like depending on what the lay of the land is there. Once you get off the road, like here in Illinois, there's a lot of times there's a ditch, like you get off the road and there's like a ditch down there, especially in a wooded area. Because the roads are typically going to be a little higher. So once you get off-roading, at that rate of speed, it can be difficult to maneuver your vehicle because they said there was a 45-degree turn of the wheel to either to the left or the right. I can't remember. And then back, which is kind of like indicative, or Waterman was trying to pull the wheel himself, one way or the other, or push it. Whatever he's trying to do.
Yeah, like you don't know that instant.
You don't know what's going on.
Like, what are you doing? And like
totally. I mean, I'd be trying to do something.
Yeah, because by that point, the second someone says something in a certain time, if she did say, right, if we take this at face value and he has a memory of this occurring, like this is a true memory, it's actually what happened, that she said something like whatever the phrase was. You kind of know when someone says that like, oh boy, the car's moving too fast for me to tuck and roll.
Right.
Next thing I can do is fight for the wheel.
Fight for the wheel. And maybe try to get over onto that side of the vehicle and get my foot on the brake. Like I'm not going to be sitting there just like waiting to die. I'm going to be trying to do something. But, we're talking about a matter of seconds, so... And are you thinking, is she like that crazy to actually do it? You know what I mean? Like all that stuff going through your mind. And yeah, it's tragic. It's sad. But this is nothing like George Pino. This
And
is
we don't have like, I mean, I'm thinking based on the facts, they couldn't go for manslaughter. This would have to be like
there was intent
murder.
here. Yeah, there's straight up.
Yeah.
Yeah, you know,
So,
you
but
got
right
the-
now we're only at a vehicular homicide as something that they ended up upgrading and adding. So there's some context here in this article from Flagler Live with some other information. And the phrase that Daniel told the officer was, "I don't care what happens, you'll get what you deserve," is what he remembers Leah saying.
yeah.
But they have some new, after speaking to other witnesses, potential witnesses, they came up with some other information to support their charges, plus the fatality. But they've got, let's see. They all had plans to, okay, wait. So the finding out that they were pregnant, and this is short, guys, and we're going to get back to Pino.
Pino.
But they've got the night of the Super Bowl, February 9th. Mumby and Waterman were spending the day with Waterman's cousins, so Daniel's cousins, the victim's cousins, Jessica and Sarah Stappenbeck, who lived in Palm Coast B section near Indian Trails Middle School. That morning, Mumby had discovered that she was pregnant from Waterman. That led to tensions between them, and as she was intent on keeping the child, and he was not sure. During the day, he did say he didn't know what he was going to do, and he didn't like how Leah was handling the situation, Jessica told Flagler Live in an interview. They all had plans to spend the day together and watch the Super Bowl at Stappenbeck's house. Waterman and Mumby did so, leaving before the end of the game and taking I-95 first south, then
What?
north again.
Hold on 1 second.
They leave early.
That was like a nail biter game. Like that game went down to like the very, if I remember correctly, like the very last possession. Point
Yeah.
being, they're obviously bickering to the extent where they don't give a shit what's going on with the Super Bowl, which is fine. But that wasn't like one of the games where it's like a blowout. Nobody's watching it anyway.
Yeah, yeah.
Like that was like kind of, if I remember correctly, it went down to like the final few of that game, if I remember. So yeah, they were in it. They were deep into it. Like
Yeah, maybe even more interesting, they take I-95 first south, then north again after turning around at Palm Coast Parkway. So like maybe they're arguing about returning, maybe, you know, just someone getting lost while they're driving, get on the wrong ramp. It happens. They were arguing. Stappenbeck, who's not on the prosecution's witness list so far, I think I've seen her on the witness list now, said she was the last person to speak with Mumby as Mumby drove. Mumby called her twice, both times upset. This is very close in time, according to Stappenbeck, because she suspected Waterman of being in contact with a former girlfriend. We later.
The X.
Stappenbeck said there was a text from her cousin's phone that night, 4 minutes before the crash, saying, "This is what he gets for being a liar and cheater." So Daniel's phone sends a message to Stappenbeck saying this is what he gets for being a liar and cheater 4 minutes before the crash.
So wait,
And
Steppenbeck said there was a text from her. So wait, is Steppenbeck, he is Mumby's or she is Mumby's cousin? Who's the cousin? I'm lost.
Stappenbeck is Daniel's cousin,
Okay.
but
all
is
right.
friends with both of them, or I guess was, so maybe not anymore.
This
But
is
Stappenbeck gets a message from her cousin, the victim, Daniel, the boyfriend, that reads, "This is what he gets for being a liar and a
wow.
cheater."
So she gets Daniel's phone, texts that from his phone. Clearly, that's obviously Mumby texting that to her from his phone.
And it gives credence to he wakes up from a coma and writes on a whiteboard that you'll get what you deserve. And that's the last thing he remembers before the crash.
But that shows real intent. That's 4 minutes before the crash. Right? I mean, he's clearly not texting that. Right? I mean, like in it would be one thing if she survives the crash, she somehow was able to locate his phone post crash in that vehicle, which I imagine would be very, very difficult. And then picks up the phone and then texts it. But this is clearly minutes before.
Yep. So Stappenbeck
Before
said
we
it
even
didn't
have
pass the
like
smell
the black
test.
box data, right? Like when was the black box data? Was all within like 60 seconds, it seemed like, right?
They said the minutes before.
Wow.
But they what they put in the affidavit was like the seconds before to track the
Man.
speed and the full throttle on the pedal. So Steppenbeck's like, well, that's something we think that Leah texted, because I don't know why Daniel would send that on his own phone
Right.
to Leah.
I'm with you,
Um,
stepping back. That doesn't makes no sense. It's clearly her. Wow.
And he even said that she grabbed his phone from him. So
I'm
I don't
not.
know why she says on his own phone to Leah, because my understanding is Steppenbeck said there was a text from her cousin's phone that night.
What is the top charge right now? Post his.
Vehicular homicide.
Mm, mm.
And then remember, they upgraded to include that, and they had this information already.
Well, yeah. I
So
mean, if he was still alive, they couldn't charge her with homicide, obviously.
yeah, but when they did, they already had information. They spoke to the Stappenbecks, and presumably would be on alert about this text message, which seems to support whatever.
No, what I'm saying is they couldn't upgrade the charge to homicide
Till he
until
died.
Daniel passed away. What? So
Well, they didn't upgrade to this. It was some time, so they didn't upgrade until, do they say 2020, June 2026, and he
oh, all
passed
right,
away in October.
2025. Yeah. So that's almost a
So
year later, like nine months later. Huh.
yep, and it's Leah Mumby did, by operating a motor vehicle in a reckless manner, likely to cause the death of or great bodily harm to another, kill Daniel Waterman, a human being, contrary to Florida statute 782.071A. So if we just swap out vessel and vehicle, is this comparable to what Pino did? Is this the same type of recklessness?
You're not even asking me, right? We're asking you, chat.
Yeah, we're asking the chat, because then we're
Yeah.
gonna get back to court, and you guys, you know what that means, sadly.
You guys can go to Discord and discuss. Yeah, I want to see what the murder 2 statute in Florida is. I'm surprised. Like,
I don't see why it couldn't be murder
that's what
too. I
I'm,
mean, she
that's what I'm saying.
she can put forth some type of like imperfect heat of passion defense or whatever, but
right. I mean, go for whatever defense you want to use, but I mean,
all
I
right, they got back
frankly,
4 minutes ago in court, by the way.
4 minutes of blooping
So they were late
time.
anyway.
Good
Yeah, a
week.
lot of no's in the chat. A lot of no's.
Yeah.
And maybe they'll add a
Is there
murder
a yes?
charge, and I'll
Is
feel
there
more
a yes?
satisfied.
Have
Huh?
you seen a yes?
Someone say yes to troll us.
Yeah, troll us with a yes. Like, it's on all fours.
Put
It's on all
yes
fours.
seriously if you like really think yes and aren't trolling.
Right. Let us know. Let us know in the chat.
But yeah,
Definitely
so
not the same. Yeah.
different counties, different prosecutors. This was again a situation where it started with lessers, that now, because it's going to a major crime, it was assigned to another prosecutor.
Wow.
So
see, now this one fits. I mean, like, this fits. Like, not only does this fit what they've charged, I think they probably could have charged it as a murder too.
I think it should be a murder
I
based on
know,
these
she
facts,
does-
unless
Yeah.
they don't trust these facts for whatever reason.
Right.
But if that text message exists, like, because it couldn't even, I don't even think a typo would make sense. Maybe it was him texting, but this is what she deserves.
Right.
Because it
And-
says he. You could make that typo, but what are the chances?
That she's also cheating, or accusing her of being a cheater because she's talking to her ex-boyfriend, even though she's pregnant with his baby.
Yeah, and like,
I don't even know if
fight.
that's my baby.
Couples can fight and start accusing the other person of cheating just because the other person says you're cheating. No, are you accusing me?
You're the cheater.
Like, it could be that way, but like,
Yeah.
there's the he in the text, not a she.
Exactly. And he's not driving. Like, what is she getting what she deserves if he's not the one behind the wheel?
Yeah, because there's no way that they could have rotated their seats, because they had to be taken. That's very important. It seems like common sense, but to spell it out in the affidavit and the reports that they had to, like, jaws of life, out of the passenger seat, there's no way that after that impact they oopsie daisy swap their seats.
Yep. They're lodged in there.
All right, guys, I think this is the final boarding call, the disembark for the chat.
You are not free to move about the cabin
Because
anymore.
court is back.
That is over.
But you got to
All
do
right.
it's the sunny in Florida. We're landing. It's a wonderful 95
Yeah.
degrees, mostly sunny in Miami-Dade County.
They only do that if you're on Southwest, where they're actually kind of friendly.
Nope.
All right. Did you turn off your chat?
Oh, wait, hold on. I want to say thank you. I'm going to turn it off right now, but I also want to say thank you. I think I'm missing. Thank you from, let me make sure I'm not saying the name. Let me turn off the chat and then get this right before I say someone's name. So long, farewell, chat. And Bob, you are good on yours?
I am good now.
All right. Let me get the court screen back up. We're
We
like
miss
5 or
you.
6 minutes behind now. Wait,
Oh,
Sheriff Chuck
Amanda
snuck
is
some in.
disappointed convicting someone. I didn't convict anybody as shit. I'm telling you what she should be charged with.
Yeah, and again,
Different.
I did a disclaimer. She's innocent until proven guilty before we started this, but again,
Always.
going through how this is alleged, the facts that are available, and what's being alleged. You know, I don't see the state in the Pino case alleging anything remotely similar to something that would get to this depravity.
No way.
So
No way. There's no depravity. There's no depravity. There's none. George Pino had no intent on injuring anybody on that boat, and there's no one that's saying otherwise. There's no evidence of that at all. Poor George Pino.
okay, yes, and I had an anonymous tipper on the tip jar, so shout out to anonymous tipper.
Heyo.
Thank you, Anon. Anon is so generous. Anon is so rich. You got to group all the anonymous together. Sheriff Chuck says, look, I think you're up to 20 now, right? 15 wasn't enough. We're going to do the 20. Just incredibly generous, as
Incredibly
always.
generous. What a guy.
What a guy.
What a guy.
What a guy. Think of you every time I see Chuck Norris anywhere.
Right. Exactly.
Like,
Like, how can you not?
yeah, so now it's just like an association I can't undo. So big thank you.
What a delightful
Extremely
human being.
appreciative.
Yeah.
And bringing us back to our favorite saying here, Bob.
He who labor here seek only truth. Ooh. Woo.
You guys ready to see if the court sound is good or if we have
yeah.
buzzing?
Oh, what do you
Let's go.
what do you think? I'm gonna say
I think it's gonna be better.
I say fixed it. I say they fixed it too.
Because they did all of that, like, you could tell they were working on it when they were like showing the wall.
Trying to figure out which mic it was. Yeah, that's good. There we go.
By the way, I'm gonna make inquiry of Mr. Pino.
Crystal clear.
At some point,
Nice.
probably after you finish this witness, as to whether or not he wishes to testify. So, imagining we've already had some conversations about that, but I'll give you a few moments to speak with him again.
Cough, 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 cough. Somebody's got a nasty cough out there. Gallery.
Alrighty then.
Oh, they fixed it. Sounds glorious.
Yeah, can you imagine if we were jumping like this and it had that noise?
No. No. We got it super on point.
Alright, get in the jury.
Everyone please be seated, thank you. Gentlemen, welcome back. We are ready to continue.
Final witness?
Defense, your next witness.
Andrew Mescolotto.
That's the attorney, I think, right? that was that maritime attorney that the Pinos retained for the Cathy Russon case.
Please step forward, face the group, and your name is sworn.
Do you swear affirm testimony about the case and the truth and whole truth and nothing but the truth?
I do.
Thank you.
Guy looks like a lawyer.
He is the maritime attorney. They called him on like day
Oh yeah.
3.
Mr. Mescolotto, good afternoon.
Good afternoon.
I'll ask you to get that microphone closer to you, or you get
I
closer
think this
to
is the
it.
final witness.
You testified in the court in this proceeding once before,
Yes,
for a few minutes, I think it was last week?
yes, I did.
Okay. And so I'd like to ask you some questions about your the limited subject matter of your testimony. You were asked some questions last week about interrogatories.
Yes.
Okay. First, let's remind the jury who you are and your profession.
Sure. My name is Andrew Mescolotto. I'm a maritime attorney. I'm a partner at the law firm of Fertig and Gramling in Fort Lauderdale.
And what is the typical case that you handle at the law firm you've been with?
So we're a civil law firm. We don't deal with criminal matters like this. We handle marine-related civil litigation and transactional matters.
Okay. And for how many years have you been practicing in this area?
It will be 20 years this September.
And how did you come to be involved in the case of George and Cecilia Pino?
So approximately a week after the boating accident, my law firm was retained to defend George Pino by his vessel marine insurance company.
So who contacted you? Was it the insurance company?
Yes, as is typical, we would get a phone call or an email from the handling adjuster at the insurance company, and he would assign our firm to be counsel for Mr. and Mrs. Pino. The way it works is we're hired and paid by the insurance company, but our ethical obligations, our clients are actually the Pinos.
Okay. But the Pinos did not select you as their lawyer?
No.
And so was there insurance related to the vessel, the Robalo?
Yes. Mr. Pino had a marine insurance policy on the Robalo vessel with insurance limits of $300,000 for liability claims.
Okay. And what does that mean, $300,000 limit? What does that mean?
So unfortunately, he had a maximum insurance coverage of $300,000 for this entire accident. There were some supplemental, there's coverage called MedPay, which pays for reimbursement of medical bills. So he had $5,000 in medical pay coverage for each person that was injured on the vessel, but the primary limit was the $300,000.
And if the amount of compensation or medical bills exceeds that, who's responsible for that?
Mr. Pino personally.
Okay. And were any civil claims, did the insurance company tell you there were civil claims being brought to the insurance company's attention?
Yes, after an accident like this, you would expect, obviously, person sustained injuries, we had a fatality, so you would expect claims to be brought. They either come to the insurance company or they're made directly to Mr. Pino, but everything would have gotten referred to my firm for investigation and handling.
Okay, and how many of the passengers brought civil claims in connection with this incident?
So to break it down, there would be what I would call represented claims. So parties that approached with lawyers, writing letters and sending information. So there were 4 parties that were represented for civil claims. Those would have been Ms. Rodriguez, Ms. Aguilar, the Fernandez family, and the Puig family. And then there would have been other less formal claims. We were approached directly by some of the involved parents to provide compensation for out-of-pocket medical costs, health insurance deductibles. It was very important to Mr. Pino that we did everything we could to resolve the medical bills and compensate those people that were involved in the accident.
Now, ultimately, were all the civil claims resolved?
Yes, all civil claims arising out of the boating accident were resolved.
Okay. With respect to the the civil claims associated with the Puigs, there were interrogatories that were propounded. I think that's the word we use in, is that right?
Yes, so the Puig family, through their attorneys, filed a lawsuit in Miami-Dade Circuit Court Civil. They filed legal claims against Mr. and Mrs. Pino, the Ocean Reef Fire Rescue Department, 2 of the paramedics, and the Sky Helicopter Company that was involved in evacuating Ms. Puig from the accident scene. So when a civil case begins in that manner, I talked about this last time, but each party, any party in the case, has the opportunity to do certain kinds of civil discovery. So the interrogatories you're asking about are written questions that are written by, for instance, the lawyers for the Puig family and sent to my firm, directed to the Pinos. The Puigs also sent interrogatories to Ocean Reef and to the paramedics and to the Sky Helicopter Company. So you're required to create answers to the interrogatories, which are answered under oath by the party within a period of 30 days unless you have an extension. And you can also object to questions if they have, legal objections.
And so both Mr. Pino and Mrs. Pino were obligated to respond to those interrogatories?
Yes, they each received a discrete set. One was directed to Mrs. Pino, one was directed to Mr. Pino. At the same time, we also received what's called a request for production of documents. They give you a list of paperwork and documents they're looking for, and you have to respond with those as well.
And what was your practice, or how did you comply with the obligation that came with receiving the interrogatories?
So typical practice, by this point in the litigation, we had already met with Mr. and Mrs. Pino. We had reviewed materials from the FWC, body cam footage, and other parts of their investigation. We'd also done some of our own investigation, interviewing witnesses, online research, different things. So the interrogatories.
Let's do it one at a time.
Yeah, okay.
So that's generally how you would do it?
Generally, and just, I guess, to put a finer point on it, myself or a lawyer at my firm would actually draft out the answers to the interrogatories. That's not something clients typically do.
And in this case, was it someone at your law firm or the Pinos themselves who actually drafted the responses to the interrogatories?
It was myself and an associate that works for me.
Okay. And what would have been the source of information you would rely upon to complete the interrogatories for Mr. Pino and Mrs. Pino?
So it would depend on the question, but generally it would be my firm's investigation into the accident, which would include information from Mr. and Mrs. Pino, but it would also come from other sources.
Okay. So let's take a look at the interrogatories that are in evidence. I'll start with Exhibit 12. This is the one for Mr. Pino. Judge, I'll approach with your permission. Do we have this on the screen by any chance? Do we have it in? Put it on the screen. Okay, if you could, we'll see if this works. Otherwise, let's have Carlos be prepared to help with that. Question number 5 says, describe in detail how the incident described in the complaint happened, including all actions taken by you to prevent the incident. Fair reading?
Yes.
Okay. And why don't you read the response that was typed in there?
It says, pursuant to Florida Rule of Civil Procedure 1.340C, Mr. Pino refers to his statements on the body cam to FWC investigator Thompson.
Now, I don't mean to do a law quiz, but maybe you could tell us what is Rule for Civil Procedure 1.340C?
Sure. So when you're responding to an interrogatory, sometimes the answer could be extremely long. So you're allowed to refer, instead of typing out the answer, you're allowed to refer to other records that the party sending you the questions would have equal access to. In this case, by this point, all parties in the case had access to Mr. Pino's interview with the FWC that appeared on body cam.
And so the answer to question number 5, who typed that in? Someone from your office?
Myself or someone from my office.
And Mr. Pino adopted it by signing at the end that it was true to the best of his knowledge?
Yes.
Okay. let's take a look at State's Exhibit number 13. This would be Mrs. Pino's response to the interrogatories. Is question number 5 for Mrs. Pino identical to the question number 5 for Mr. Pino?
Yes.
And so we heard the response that was typed in for Mr. Pino. What was the response typed in for Mrs. Pino?
Sure. While returning to Ocean Reef, a vessel passed heading in the opposite direction. The vessel caused a wake, and then the accident occurred.
And from where did you obtain that information?
This information was obtained from Mr. Pino,
Okay.
as well as, from him directly and from his statements to the FWC.
Okay. And so if they were obtained from Mr. Pino, why would they then be in the answers to Mrs. Pino's interrogatory?
So Mrs. Pino is obligated to answer these questions in a manner that's consistent with the position she's taking in the civil case. So it's common to adopt information from other witnesses that you know to be truthful.
Okay. So is it appropriate for Mrs. Pino's answers to the interrogatories to rely upon the recollection of her husband from the incident?
Objection leading, Your Honor.
Okay. I'll try this way. If Mrs. Pino hadn't actually observed the accident, how would she properly answer that question?
It would be prepared for her with information that existed from other sources.
Okay. And so did you approve her answering question number 5 by relying upon the information from the investigation and what her husband had reported?
Yes, otherwise it wouldn't have been in the interrogatory.
Okay. Let's take a look at question number 6, back to Mr. Pino. If you could read that to the jury and then stop a second.
Sure. Number 6 is describe in detail each act or omission on the part of any party to the lawsuit that you contend constituted negligence that was contributing legal cause of the incident in question.
And what was Mr. Pino's response in his interrogatory?
The wake of the unidentified vessel headed northbound was a contributing legal cause of the incident in question.
Okay. And from where did you obtain that information?
This information was obtained either directly from Mr. Pino or through review of his statements made to the FWC.
And did you understand that that recollection reported in there was the recollection Mr. Pino had reported immediately after the accident?
Yes, absolutely.
And you saw it with your own eyes from the evidence?
Yeah, I certainly watched all the body cam interview.
Now let's compare that to Mrs. Pino's answer to number 6. If you could read number 6, or is it exactly the same?
So the question and the answer are exactly the same. This is in part a legal question about the Pino's position in the lawsuit. It's not a purely factual question. They're asking about negligence and other defenses and claims that are in the case. So this is a mixed question of law and fact. So of course, an attorney would prepare this for their client.
Let's go to number 8 for Mr. Pino.
Would you like me to read it?
Please do.
Sure. Do you contend any person or entity other than you who is or may be liable in whole or in part for the claims asserted against you in this lawsuit? If so, state the full name and address of each such person or entity, the legal basis for your contention, the facts or evidence upon which your contention is based, and whether or not you have notified each such person of your contention.
And what was the answer to that question in Mr. Pino's response to the interrogatory?
The answer is yes, they have a contention. The unidentified vessel headed northbound in REM and its operator. The unidentified vessel headed northbound created a wake that caused or contributed to the accident.
Okay. Is that the same question and same answer given in Mrs. Pino's interrogatory?
Yes.
Identical?
Yes. And again, this is a mixed question of law and fact. This is a Florida standard interrogatory that the Supreme Court has drafted for civil litigation. The purpose of this is to make you disclose other people that you believe were involved in the accident. So all parties can know about this at the inception of the case, not find out much later.
So explain that in terms of giving notice to the opposing party in a litigation. What do you mean by that?
So there's a complaint which the plaintiff files that's answered by the defendant, but it's very basic information. So the purpose of initial paper discovery like this is to kind of flesh out what claims for the plaintiff or defenses that a defendant may bring in a case. So, for instance, the Puig's attorneys can fashion their discovery plan, what witnesses they want to depose, and that sort of thing. So these are required to be answered such that, as a defendant, the Pinos would be giving fair notice to the plaintiffs of their position with regard to the cause of the accident or contributing cause.
And if Mr. Pino's recollection at that time was that there was another boat that may have contributed to him losing control of the vessel, if that's his recollection, was he obligated to notify or to respond to that in the questions propounded in the interrogatories?
Oh, absolutely. That's the purpose of these questions.
Okay. Let's see if there's any others. I think that's it. Can you take that back from you?
Sure.
At the end of the interrogatories, it is signed by each of the parties, Mr. Pino and Mrs. Pino, respectively.
Correct.
And there's a declaration that each makes that it's under penalty of perjury under the laws of the United States of America that the foregoing interrogatories are true and correct to the best of my knowledge on a particular date.
Yes.
And do you recall these interrogatories were signed in October of 2023?
Yes.
And even what happens, well, let me take that back. Mr. Pino was obligated to give his best recollection at that moment in time?
Yes, on the variety of issues in the interrogatories. There's legal questions, factual questions, a mix of different things for both liability and damages.
And Mrs. Pino, could she rely upon his recollection in responding to the interrogatories propounded upon her?
Absolutely.
If I could just have a moment. Judge, those are all the questions I have at this time.
Thank you. Mr. Mescolotto, good afternoon again.
Good afternoon.
You indicated that the answers that you just read now for us are a question of mixed law and fact, right?
Some of them.
Okay, and so like questions about how did the crash occur, is that one of the questions that you would say is a mixed question of law and fact?
I'd have to look at which question you're talking
Sure.
about. I don't have them committed to memory.
So I'm going to show you State's Exhibit 12, which is an evidence, and this is the interrogatory that was entered on behalf of the defendant, in this case, George Pino, who is that man there in the light blue tie, right?
Yes.
For the record, identifying the defendant. There was a question that was asked, number 5, describe in detail how the incident described in the complaint, meaning, of course, the crash, happened, including all actions taken by you to prevent the incident. And what he says to answer that question, basically, not to put it in legalese, but like maybe everyday language, is what I said to Lieutenant Thompson, yeah, that's how the incident happened. Is that fair, accurate?
Yeah, that's what it says.
Okay. And is that what you would consider a mixed question of law and fact, or is that just a question of fact? How did this happen?
No, that would be a question of fact.
Okay. And then number 6, describe in detail each act or omission on the part of any party to this lawsuit that you contend constituted negligence that was a contributing legal cause of the incident in question, the wake of the unidentified vessel heading northbound was a contributing legal cause of the incident in question. That's asking for facts too, right?
That's a mixed question of law and fact.
Okay.
It's asking for contentions concerning negligence and various other points there.
So the answer is saying, I'm not necessarily the one at fault. This other vessel was the one at fault.
No, that's not what it's saying.
It's saying that constituted negligence, right? So the other vessel was the negligent vessel?
No, it's saying negligence is, it's different than criminal law. Many people describe it like a pie. 100% of the fault for an accident gets divided between the participants. That interrogatory is simply saying that the unidentified vessel bears some, we contended that the unidentified vessel bears some percentage of the fault for the accident.
Right, but if there was no other vessel, then this would be an inaccurate statement, correct?
I don't believe it would be inaccurate.
If there was no other vessel that contributed to the cause of this crash, then saying the wake of the unidentified vessel heading northbound was a contributing legal cause, that would be an inaccurate statement, correct?
That's Mr. Pino's recollection.
Well, that's what he told you was his recollection.
Correct.
Because you obviously would not want to put into a court file a pleading that was, from your vantage point, untruthful, right? You're an officer of the court.
Correct.
And so you have obligations when you file a document that what you're filing in good faith you believe to be accurate.
Yes.
And you thought in good faith that you could trust that what your client was telling you was truthful, right?
Yes.
Now, if an interrogatory is posed to a party to a lawsuit, hey, how did X happen? If that party does not know how something happened, that party can answer, I don't know the answer to that question, can't they?
They could.
And so when Cecilia Pino was asked about how the crash happened, she could have answered by saying, I don't know because I wasn't watching when the crash happened. She could have answered that, correct?
She could have.
But she didn't, did she?
No.
Now, you indicated that Mr. Pino wanted to do everything he could to resolve the claims, right?
Yes.
Okay, but that's not really true, is it?
I would disagree with you.
Because isn't it true that you wound up filing a pleading on March 15th, 2023, trying to limit his liability for his actions in this boat crash? Didn't you?
The federal court action?
Yes.
Yes.
In fact, may I see this? Oh, thank you. I could I'm showing counsel states 5.
Mr. Judge, may we approach on the exhibit?
All right, that was quick. So we'll just jump a little.
Yeah, the old interrogatories. Time will bite you in the butt.
All right, counsel, you can proceed.
Thank you. So, Mr. Mescolotto, in point of fact, on March 15th of 2023, you filed on behalf of George Pino a petition for exoneration from or limitation of liability, didn't you?
I'd have to look at the date, but
For the record, I'm showing the witness dates 5Y for identification.
yes, this is a petition for exoneration from or limitation of liability.
And who is the petitioner seeking exoneration from liability?
Well, it's exoneration or limitation. we wouldn't be seeking exoneration in this case, but to answer your question, it's Mr. Pino.
Right. It's not the insurance company, is it? The petitioner is George I. Pino, hereinafter referred to as the petitioner, correct?
Correct. In Florida, insurance companies are not parties in cases like this.
And so within that document, the defendant was seeking to limit what kind of liability he might have for his responsibility in this crash, correct?
Yes.
And in that petition, he gave a series of facts about what happened in the crash, didn't he?
The petition is not signed under oath, if that's what you're getting at.
Oh, so you don't have to be truthful in a court pleading if you're not signing it under oath?
You're talking about Mr. Pino.
Yes.
Mr. Pino didn't draft that document.
Understood, but you weren't there when the crash happened, were you?
Of course not.
Right. And so really the only source of information for how the crash happened was Mr. Pino or the people that were on his vessel, correct?
We also did investigation, but yes, the primary source would have been Mr. Pino and the people on his vessel.
And so the information was that there was, at about 6:30 p.m., that his vessel was subjected to a large wake thrown by a large center console or sport fish type vessel heading northeast on the intercoastal waterway, while his boat and the other one were going through the channel in the vicinity of navigational marker 15, correct? You remember that?
Yes, if that's what it says.
And that in that area, it amplified the size of the wake of this other vessel, correct? That was the information that you were given to put into this pleading.
Yes.
And that the vessel left the scene and to date has not been identified, correct?
That's an accurate statement.
That's what he said, right?
It's an accurate statement. We did not identify the vessel.
What if there was no vessel? Then of course you didn't identify it, right?
Presumably.
Okay. You also were given information from your client that the other vessel that his vessel began to turn unexpectedly on its own and put itself on a course roughly heading toward navigational marker 15. That was the information that was provided to you by the defendant, correct?
Yes.
Also that he attempted to steer and correct course but was unable to prevent an collision with navigational marker 15. That also is information given to you by the defendant.
Yes.
And this information was given to you while the defendant was trying to limit the liability that he would have for the damages that he caused to other people in that crash, correct?
Yes.
Additionally, again, you indicated that Mr. Pino wanted to do everything to resolve the claims, correct? Now, right?
Yes.
Now, the interrogatories that we were talking about, those were signed on October the 19th of 2023, right?
Correct.
Now, in addition to having filed in March of 2023 a pleading to try to limit his liability, you also then on August 14th of 2023, you filed a motion to try to get the lawsuit dismissed, didn't you?
We filed a motion to dismiss.
So the answer to my question was yes, right?
Well, the purpose of that motion was never to have the Puig's entire lawsuit dismissed. We were taking legal issue with certain claims that were brought against Mr. Pino and Mrs. Pino. Legal arguments about the viability of the claims. The purpose of a motion to dismiss is not wholly to knock out a whole case. It's also if you have issues with the claims that are being brought. We believe certain claims were legally insufficient. We filed a motion to dismiss. There was hearing before the judge, and it was granted in part and denied in part. So we received some relief, not all we asked for, and the lawsuit continued.
Right, but that certainly is not necessarily indicative of a person who's trying to do everything that he can to resolve the claims. That's a person who's trying to limit what claims he has to have.
No, by this point, the three claims that I mentioned before had already been settled or resolved, and we were litigating with the Puig family. In that situation, they brought a claim that could not be resolved at that time, and so we were required to do certain things to defend Mr. and Mrs. Pino's rights
No, of
while
course.
working to try to resolve the Puig claim, which is what ultimately happened.
Right, but it certainly hadn't happened. There was not an agreement by the defendant in this case to allow what the Puigs were seeking to go forward. At that point, he was saying, no, I'm not willing to do that which the Puigs are asking for. Isn't that true?
No, that's not accurate.
So he was ready to settle
So
as of August of 2023.
while the Puig claim had been mediated prior to them filing a lawsuit, so Mr. Pino and his wife attempted to resolve that case before litigation was ever filed. They continued to attempt to resolve that case throughout the entirety of the litigation. And it was only when we got to a certain point that a resolution was reached. So you simply have to do certain things to answer pleadings, respond to complaints, respond to discovery. All the while, efforts were underway behind the scenes to try to resolve these claims.
Right, so mediation was attempted first. That was unsuccessful, and there being your client being, or your then client being willing to do everything he could to resolve the claims. And then after that was unsuccessful, then a lawsuit was filed against him, correct?
Yes, and then there were multiple other mediations between the Pinos, the Puigs, and all the other involved parties while the case was progressing.
Right, and the other involved parties had nothing to do with George Pino. They had to do with other entities like, Ocean Reef Volunteer Fire Department, things of that nature, correct?
Yes, the Puigs brought claims related to the treatment their daughter received after the accident.
Right, but I'm not really focusing on those claims. I'm asking you about the claim between the Puig family and George and Cecilia Pino. So to the extent that during that litigation, a motion to dismiss was filed, that's not necessarily indicative of a man who's trying to do everything he can to resolve the claims, is it?
I would disagree with you.
Okay. Now, in order to file that claim, once again, you had to rely on information from your client at the time, George Pino, right?
In part.
And so, because his wife Cecilia has said that she didn't see the crash, really the only source of information that you had about how the crash happened was pretty much from your client, right?
Not exclusively. We had interviewed other persons aboard the vessel. I had spoken with the FWC investigators. I had reviewed what reports were available from the FWC.
Sorry, go ahead.
Laura Adams appears to have no clue how civil defense work works, like how it operates. Like she, in terms of like civil cases, and we've handled our fair share of civil cases where, we're going against the insurance company. Because a lot of times, if this thing goes to trial, meaning a civil case, you have the parties. Are you back? I heard Allison screaming bullshit. She's acting stupid intentionally. But the reality is that when you get into that courtroom, it's the plaintiff and the defendant, even though it's an insurance company and the insurance company's lawyers that are the ones that are fighting the claim. So everything that this guy is saying, he's trying not to give away kind of state secrets, how the sausage is made in that particular industry. And my least favorite lawyers on the planet are insurance defense lawyers. They try to avoid, for their client, being the insurance company, paying out anything, and they'll go to whatever lengths they can. So, interrogatories are probably the only time that insurance defense lawyers talk to their client, which is the defendant in the case. Like, this is not like a lawyer, like you're thinking like, oh, I need to make a call, and talk to my lawyer. It's like law firms, usually larger law firms, handle, the claims work and the litigation for most insurance companies. There's some smaller firms that handle it for smaller insurance companies. But, you know, this isn't your typical attorney-client relationship when you're dealing with insurance defense lawyers. So just want people to be crystal clear on that fact. This isn't like George was calling this dude up all the time and they were having back and forths. And these guys are trying to avoid as much liability for their company's coffers, the people that are paying their salaries. And the other part of civil law that's always so annoying is that plaintiffs' attorneys in civil cases, a majority of the time, take cases on a contingency, meaning that they're not going to get paid. They front the cost for the suit, and then they get paid out when it's either settled or they go to trial and they get a judgment. And most of the time, the defense for the insurance company, because how these guys get paid is hourly. So that's why you see protracted litigation. There's an inherent conflict for them to resolve the cases quickly, unless they can get somebody to bite on a ridiculously undervalue offer early on. Like if somebody's desperate for money and they're like, oh yeah, we'll make you an offer that's 20% of the value of what the case would typically be thought to be.
Yeah.
So, you know, like you'll go through the whole process, all the interrogatories, all the discovery, all the depositions, because that's all billable hours for these guys and gals that do it. So it's a weird area of law. Yeah, like I don't know what Adams thinks this is proving, but in terms of moving the needle at all, I don't think that it does. But that's just me. I'm done.
I'm done.
I'm done.
I think he is too. He's like, I said I could be here at 2 and I just want to go.
He's like, I'm over it.
I never want to hear the word interrogatories again. I'll run it back to the beginning of the question.
Pretty much from your client, right?
Oh, you were way quieter. Now she seems really loud. Lower that a little.
Not exclusively. We had interviewed other persons aboard the vessel. I had spoken with the FWC investigators. I had reviewed what reports were available from the FWC. We had access to the body cam footage, so there was a lot of sources for information in addition to Mr. Pino.
Sure, but in terms of how the crash itself happened, body-worn camera couldn't tell you, could it?
Well, the investigators certainly had their theories about how the crash happened, which were relayed to me.
But again, body-worn camera footage doesn't tell you how the crash happened because the body-worn camera wasn't turned on until after the crash had happened.
Well, body-worn camera footage captured interviews with Mr. Pino and many other people that were involved in the accident, so it did provide information.
Okay, but in terms of the actual conduct of the operator of that vessel, are you saying that the girls that were on the vessel were able to give information about how George Pino navigated the boat?
There was some information received from the girls about his navigation of the boat on that return trip, yes.
At the time of the crash?
Not at the time of the crash.
Right, not at the time of the crash. So you really didn't get any information about what was happening with that vessel at the time of the crash from any of the girls because they were not paying attention to how he was navigating, were they?
Correct.
Okay, so now, in terms of explaining how the crash happened, George Pino told you that his vessel was subjected to a large wake thrown by a large center console or sport-type fish vessel, correct?
Yes, we've already talked about that.
Correct?
Yes, we've already talked about that.
Yeah, I know. We talked about what he said and what you put in a pleading in March of 2023. I'm not asking about a pleading that was filed in August of 2023, about 5 months afterwards, correct?
Yes?
He also told you, once again for this pleading, that the boats were transiting the Cutter Bank shallows in the vicinity of navigational marker 15, correct?
That sounds like it came from the FWC report.
Okay. Are you aware that the defendant talked about the fact that he alighted with the last channel marker in the Cutter Bank channel?
I don't know that I remember that level of detail right now. It's been a couple of years since I've been involved.
Sure. If it were the case that the defendant gave a statement that he crashed into the last channel marker in that channel, and if the last channel marker in that channel was channel marker 15, if those facts were true, then if your client is telling you that the crash happened in the vicinity of navigational marker 15, then what he said to the police would be accurate, correct?
I'm not sure I'm following you.
Sure. Let me break it down. Sorry, I should ask the question better. Let's suppose that your client, former client, George Pino, told the police the night of this crash that the crash happened at the last marker, okay? And let's suppose that the last marker of the Cutter Bank channel is navigational marker 15. If he said to the police that the last navigational marker was where the crash happened, and if the last channel marker in that channel would be channel marker 15, then the information that he gave to you about where the crash happened would be accurate, correct?
If I'm following you, it sounds accurate.
Okay. He told you that he adjusted course to meet the wake and impacted the wake, right?
Yes.
He talked about trying to attempt to steer and correct course, but could not prevent the collision with navigational marker 15, correct?
Correct.
Now, probably a lot of people have heard of the so-called attorney-client privilege, right? You've heard of it.
I definitely have.
Okay. And the idea behind the attorney-client privilege is that, for the most part, what a client tells his lawyer is going to be kept confidential unless under certain extenuating circumstances. Fair to say?
Yes.
And one of those exceptions that can lead to the attorney-client privilege not being applicable is if the client waives that right, meaning gives you authorization to divulge this information to others. Correct? Correct?
Generally, yes.
And so in order to file those pleadings, the motion for limitation of liability, the motion to dismiss, as well as the information in the interrogatories, George Pino had to have given you authorization to release that information, correct? At least the information he gave to you.
I don't really see statements in a pleading requiring a specific waiver from Mr. Pino to draft a motion to dismiss, for instance.
What I'm getting at is that you didn't violate any kind of ethical or bar rule by sharing the information you had gotten from the defendant, in this case, in those pleadings, correct?
No, of course not.
Thank you. Nothing else.
Yes, sir. Mr. Mescolotto, the conversation you've been having with the prosecutor relates to the civil claims that were being brought by the passengers, correct? And in particular, the Puig family.
Yes.
Okay. And so with regard to the Puig family, that was the one claim that was litigated, correct?
Yes. The other claims were all settled prior to a lawsuit being filed.
So no lawsuit filed in the other three claims. Those were settled pretty quickly after the accident, right?
Within a period of months, yes.
Okay. The Puig family, you tried to mediate, or you told us that there was mediation efforts, right?
Correct.
Now, the insurance was only $300,000 for this accident, right?
Yes.
And the claims being asserted by the Puigs and others well exceeded $300,000.
Many millions of dollars were claimed.
Okay. And by the time, well, there were three other families, the Fernandez families and two others, that was resolved. That would have, without getting into the exact numbers, money was paid over to those families that was no longer available to the Puig family, correct?
Correct. Mr. Pino paid out of his savings to resolve those claims.
The Puig family had claims that they were filing not only against Mr. Pino, but also Mrs. Pino.
Correct.
She was not the operator of the vessel, was she?
No, she was not.
And she still was being sued in connection with the claims brought by the Puig family.
Yes, they had a different theory of liability against Mrs. Pino.
Okay. And you were representing both Mr. Pino and Mrs. Pino?
Yes.
Okay. And the theory of liability against Mrs. Pino, who was not the operator of the vessel, and was she the owner of the vessel?
She was not.
Okay. Were you, as part of this course of civil litigation, bringing to the court's attention whatever, I say, motions or legal issues with regard to a theory of trying to impose liability on Mrs. Pino?
Objection, this is beyond the scope of cross.
The fuck it is.
Will the court allow recross then?
No.
I couldn't hear you, Judge.
Tell her, babe.
Okay. Well,
I'm sorry, could you repeat?
yeah, the prosecutor asked you about a petition for exoneration and limitation of liability, right?
Correct.
And explain to the jury what that is.
So as a vessel owner involved in a casualty of any type, really, this type of accident, a fire, anything that can happen on a boat, they have a right under federal maritime law to file this petition for exoneration from or limitation of liability. It's a type of lawsuit that's used in a situation where you're expecting multiple claims, because it requires the claims to come into a federal court proceeding rather than having to defend multiple different lawsuits in state court. Like if each family had filed a lawsuit, Mr. Pino would be defending against 4 separate lawsuits. The limitation gives you a vehicle to be able to defend one lawsuit and have all the potential plaintiffs come into that case. It makes these cases easier to litigate. And the other thing about limitation is it's a use it or lose it type remedy. If you don't file that within 6 months of the first written notice of claim, you're barred from filing that lawsuit. So in these type of maritime accidents.
Can you explain why that's so relevant? That it's something that if you don't file it, it goes away. So that would mean typically, whether you plan to use it or not, what are you going to do?
You're going to
Oh,
file.
you're muted, Allie.
You're going to file.
What he said.
Yeah.
And I missed the beginning, but did they make it clear that George never contacted you and hired you, like you were retained by the insurance company?
You mean gave like the little speech explaining how civil litigation really works to all the people that have never been in civil litigation?
Yeah.
I know they didn't.
Bob did it for the chat.
I did it
Well,
for our
I'm just
people.
wondering if it's possible that he hired separate counsel outside of his insurance company or something.
It sounds like they were all going to be, they were concerned about excess verdicts and, him getting hammered. So, they
But
paid
did they
out.
mention the insurance company and that whether he works for the insurance company?
I
I don't know if it's that clear, but they're talking about this happening within the context of the insurance company and limitations of the insurance payouts and all of that. So they are putting it in the bubble, but I don't know if Howard is the way you just came in and said that. I haven't heard a plain language question from Howard that would spell that out for someone that couldn't have an Allie here to explain
And I'm just wondering if there's because we've had defendants call and be like, I want my own lawyer because they're not paying out, and I don't even know if that's a thing, but we're not the firm for you. So I don't know under what clauses of insurance that you can say I reject your lawyer. But when the insurance company, if the insurance company is going to pay any of it, they are going to want their own lawyer. And I'm just surprised did they prevent them from doing that in a motion in limine, or is there something different that might have happened here where he actually
retained his own counsel?
retained his own counsel?
I get the distinct in terms of his answers with regard to the interrogatories and who prepared them. I think he's the insurance defense guy, and
if he had done that, then his criminal defense lawyer would be like, you were specially hired because he wanted to settle, and the insurance company has their own lawyer and their own ways of doing, he would have highlighted it that way if it was like that.
the bigger issue for Pino is he only had a 300,000 cap on it, and these are multi-million-dollar lawsuits. It was always the threat of an excess verdict was real, a real and present danger. So at some point, George probably would have had to have conversations with the insurance defense. Or like, we're going to pay out the policy, like,
Right.
but 300,000 isn't even scratching the surface here.
You
The
gotta hire
question
your
then
own lawyer
becomes, like, did they have an obligation to continue to try
to
to work
defend.
out, and defend the claims when it was coming out of George's pocket at the
And
end
maybe
of the
not.
day?
That could be an answer as well, that maybe it's some insurance loophole that once they put forward their entire, but part of the reason you pay for insurance is so that you have that representation when you get into an accident. So
Sure,
I'd be
for sure,
surprised.
for
Maybe
sure.
I can look into it, but I wonder if there's something like you're saying, insurance company puts all their money on the table and then they're like, if you want to hire somebody else to continue this, you can.
And they
You
went to
know,
so many rounds of mediation, and they were getting numbers, you know what I'm saying? Like, they were hearing numbers about what the potential value of this claim could be. So it's like they weren't going into it blind. Plus, with the actuaries that work in insurance defense, and especially like maritime cases, they're going to know what boat accidents pay out based on past verdicts. And it's not like it's a secret, and it's all formulaic in civil law. Typically, X injury is worth X amount depending on the age,
right. And technically, the
occupation,
younger you are and you have no family and you're not bringing in your own income, you're worth less
yeah,
value-wise for a defense firm
which is
because you're
bizarre.
right. Like, instead of you have your whole life ahead of you, your life should be valued higher. It's like, well, you don't even support anybody. You're not already making any income. You're like, your life's not worth that much. And
Right, you're
what
not
Bob's
bringing
talking
shit
about.
to society.
So, and it's like ridiculous, obviously, because the person's too young and common sense dictates, like I said, you have your entire life ahead of you. The value of your lost life should be so much more. Also, the impact it has on other people, but that's not how insurance defense actuaries, as Bob was, discussing, goes. And to your same point, Kat, about why you have to file this, whether, if you're going to use it, and it makes the most sense to use it because, you know, a lot of times it's like, and I heard him sort of say it here, like the first one ready to settle, they may end up getting all the money, because they're ready to settle first. And then it leaves nothing for the rest. Like we've done plaintiffs work where the defense, attorney's like, well, look, there's $750,000 here. There's three of you guys. Work it out. Tell me who wants what. Otherwise, you know, so doing this federal thing where you're all in one lawsuit also allows for that, where one party is not getting screwed because I settled with everybody else already. So, but to that same point, I was going to say that's the same thing with filing motions dismiss and filing, you've got to do the steps. He's got an ethical duty to do those things. And if he is technically an insurance defense attorney, they're going to do those things to the benefit of the insurance company, even if the actual insured, the named defendant, is like, no, just pay these guys whatever they want, give them the entire policy. Although
So
that, like Bob said.
I think there were different attorneys that filed the limitation of liability it was something where they capped the damages at the value of the vessel, was something that was filed early on. And I don't believe it was this attorney that did that thing. So my assumption would be that the attorneys who did file that were with the insurance company.
Yeah.
Because that's
All
a
right.
very insurance company thing to do, cap it at the value of the tangible object thing itself, that we can
Right.
put a
number
MSRP
on.
minus depreciation value on. And then this guy was brought in on the state's case in chief. He was presented as the lawyer that was retained when Cathy Puig, the Puig family, filed their lawsuit. And now we're learning more that actually he was in play a little bit earlier than that, but still it seems like for the matter of dealing with like these out of court settlements, and of course Cathy Puig ends up going to court, it's filed as a lawsuit, and not necessarily directly with the insurance company. But I'm assuming this guy would be in communication with the insurance attorneys.
I mean, I'm not Wait, so
Every
why do you think like he was definitely involved with all the earlier cases? I mean, like he was saying behind the scenes when an insurance defense firm is handling a case, I mean, you're trying to settle it the whole way, which makes me think that he is the insurance defense guy because they're trying to settle it prior to a claim being filed. I mean, that's
Right.
the way it really works. You know, you're trying to if you have a client that comes in and says, okay, I was injured in an automobile accident, and you say, okay, well, start getting me your medical records and we'll take a look and I'll see if I can negotiate with the adjuster. Cause at some point you're dealing with just the adjuster. And when it gets closer to the litigation phase, that's when they're going to bring, because adjusters are in-house, they're paying them a salary. Whereas again, the insurance defense lawyers, it's a firm. They're billing the insurance company hourly for everything that they do on all the cases that they're handling. So, I mean, as soon as the cases were filed, at that point, then like Allie was saying, they've got to do all the work. I mean, they have to defend the claim just like any
I
other.
mean, we did a plaintiff's case once that went on for years that we settled for, I don't know, 1.8, something like that. And the defense attorney said to me, I still made out the best, meaning
Yeah,
him.
All
personally.
right, so Discord chat is saying like, now he clearly testified that he was hired by the insurance company, right? But he was still framed, at least in the state's case in chief, as having been retained for the Cathy Puig lawsuit. And again, I'm
Right
saying that
there,
now that we have the defense case in chief coming up, we're getting into these deeper areas
right.
where we're
So
finding out that it was a little bit
Well,
earlier on and
the,
it wasn't just this like,
the problem with the Puigs is by the time they decided to litigate or they were ready to litigate, the money had all been paid out. Because 300,000 isn't shit. You know what I mean? It's like they divvied up whatever it was. That's why they were saying by the time the Puigs got to,
the table.
like any kind of real settlement talks and or litigation, like whatever coverage was gone in terms of the insurance. So it was all coming out of George's pocket. So like, out of their savings account. So yeah, I don't know. I mean, this guy,
In a normal scenario, he'd be an insurance defense attorney that's hired by the insurance company.
Well, they're just on retainer. They're not
only
hired.
works for
Right.
George in name only
Right. That's it.
on paper.
And then just so you know, at a trial, like the jury is never told that an insurance
Civil.
company's paying out the money. Yeah, of course I'm talking about civil here. That it's the plaintiff is not paying out. It's the insurance company that's defending it. And ultimately, unless it's an XX verdict, is going to be paying the money. Now you would figure most people common sense wise would know that, like, especially in car accidents, people carry insurance. In most states, it's mandatory. So, when you end up going to trial, that's the whole reason you're carrying insurance. One, to pay off any claims, and two, to defend the claim if it ends up going into litigation. But you're not allowed to say it. It's like Ali was saying, it's in name only, because the defendant's sitting there, the lawyer isn't saying, oh yeah, I represent the interests of Allstate. I'm trying to fight to keep my client's money, who is really Allstate, not the defendant. So, it's a slippery kind of way to do it. And I kind of hate it because I think it's relevant. Like I've always felt like jurors deserve to know that if they don't know it. It's irritating from the plaintiff side for sure.
All right, let's see what he says for himself.
run it back to the question where Laura Adams jumped in. All right, so they're expecting multiple claims.
In a situation where you're expecting multiple claims, because it requires the claims to come into a federal court proceeding rather than having to defend multiple different lawsuits in state court. Like if each family had filed a lawsuit, Mr. Pino would be defending against 4 separate lawsuits. The limitation gives you a vehicle to be able to defend one lawsuit and have all the potential plaintiffs come into that case. It makes these cases easier to litigate. And the other thing about limitation is it's a use it or lose it type remedy. If you don't file that within 6 months of the first written notice of claim, you're barred from filing that lawsuit. So in these type of maritime accidents, it's standard procedure to file a limitation of liability action for this reason. Now, in this case, We
Theory.
didn't end up litigating.
Sorry, what?
We're both going, yeah, sure, fire lawyer.
Yeah, like in theory, in theory.
In
Yeah.
theory.
We get it. We've dealt with them.
But yeah, we're when it comes to civil, we're plaintiff's lawyers. So she would be like the prosecutor saying prosecutors do good things. So we're of course going to be like, yeah, sure, defense.
Well, I mean, I guess I should elaborate on my takeaway. Like this guy, for the titling, the claims, the characterization, he is retained by the Pinos. That is what's being said. Whether the insurance company put him there, whether he's like got the insurance company's interest in his back pocket, but his fiduciary obligation should technically be to the Pinos, and maybe it isn't, who knows.
No, but
he's being
sorry.
presented as being retained by the Pinos, and the state is working with that characterization and trying to show that, look, you were retained because you felt like you were going to have this liability because you knew you did something wrong. You knew that you weren't going to be able to defend yourself against it, probably alluding to alcohol. And they're going to use the Pinos retained an attorney to the fullest against the Pinos.
Correct. And fire lawyer's point is taken to the extent that he does have a duty to zealously represent them, meaning file whatever motions. But again, when if that person were to say, I don't want you to file any motions or defend this because I want them to get the very most money they can get, the person be like, wait, no, I can't do that.
That therein lies the rub, fire lawyer. That's like we're sending off good faith letters to insurance defense lawyers because they're not acting in good faith. They're not making good faith offers. They're coming at us with bullshit, that's what I'm talking about with the conflict with insurance defense attorneys, because at the end of the day, the person that's paying them, the lawyers, is the insurance company, and that's who they're billing. So there is an inherent conflict, because you're right. I mean, these insurance defense lawyers do have a duty to zealously represent the actual defendant, but there's this like pull with the fact that the person that's writing their checks and paying them, they're sitting there saying, look, you need to minimize this claim and do whatever the hell you can to minimize this claim. We don't want to pay out on this thing, or we want to pay out substantially less.
There's never a scenario where the defendant, the actual defendant, so George Pino, let's say that he had a $20 million insurance policy, and he wanted Lucy's family to get $5 million, the other families get $1 million each. He doesn't get to say that. He doesn't get to make the insurance company settle with them for the full value. That's not his call. And so, but yeah, they're supposed to be zealously representing the named party. But
I would say it's, some of what you're saying just goes to not every lawyer is of the same caliber and operates the same way. So some of the bad experiences could be because it's a lawyer, not necessarily because it's a lawyer through insurance company with an issue that came up.
Yeah, they're pretty much all the same, Cat. I hate to say that, but it's true. Insurance defense lawyers are like, that's so at any rate, Josh sent a $1 Venmo. He says, yes, he said the insurance company retained him, but technically, going to what fire lawyer is saying, he works for Pino, which is true, but
and that's what the state's weaponizing. The state wants it to look like the Pinos went and had to retain someone because they were panicking, because they knew that they were like driving drunk and crashed this boat drunk. Like, that's, to me,
then he needs to re-nail that down here again with, my client didn't hire you. My client had no say over the motions that you filed, those kind of things. But
yeah, well, interesting. I mean, not a field that I think I'd be very good in. It seems like a lot of paperwork.
Oh, it's all paperwork. Civil law is all paperwork. It's all paper.
Until trial.
Almost, but nothing makes it to trial. Almost everything settles.
I like reading. I don't like preparing documents, so I don't think it'd be for me.
Civil trials we actually did. One that settled literally on the courtroom steps.
Yeah.
One I know went to trial. And I have to think about it because I have a horrible memory. So, but go
I
ahead.
mean, like 99.9% of all accident, like MVAs, settled.
Motor
You know, you
vehicle
just,
accident.
yeah. Yeah. I mean, they just don't go to trial very often. That's, I mean, everybody in that courtroom, starting with the judge, is always really pushing towards settlement. Like nobody is trying to take these things to trial. So,
No.
yeah, it's a
Well,
whole
even the
thing.
first day of this trial, we had that little exchange, that little dialogue where the state was like, well, he knows what our minimum would be. And the judge is like, did you give him something specific? And she's like, we gave him the bottom of the range that we'd be open to.
So her
Right
answer is
before like
no.
jury was called in. Yeah.
Yeah.
So
In the federal case, because the 3 other claims were resolved, there was only 1 claim left. And in a situation where there's only 1 claim against the vessel owner, you can't proceed in the federal case. It requires multiple claims. So if you looked at the docket of that case, eventually that case was dismissed voluntarily on Mr. Pino's behalf.
So I don't want to lead you, but I want to make sure the jury understands. If there are 4 passengers making claims in 4 different places, even if they haven't even filed the lawsuit yet, if the Pinos want it all resolved in one forum, federal court, you as a lawyer would need to bring that to the federal court's attention within 6 months?
Objection, it's leading.
I'll try again. Let me start with this. Did Mr. and Mrs. Pino have anything to do with your decision to file that pleading?
No.
Did they even know you filed it?
They will.
Objection calls for speculation.
Excuse me. Yeah, how would you know?
Go ahead, you can tell.
Objection, I thought the court
Forgive me.
sustained the objection.
Yeah, thank you. No speaking objections. I sustain
Hey, Adam,
this.
calm
Sure.
down. Big
The
mouth.
decision to file that petition, is that your decision?
I was directed by the insurance company to file that petition. Mr. Pino was made aware of it, but part of the relationship when you're being defended by an insurance company, they have the right to control
There you go.
what litigation is filed, how it's litigated, what money is spent, and how it's resolved. So some of these aspects were outside of Mr. Pino's control.
And that's what I was getting at.
That's what I was
Do you
trying to
file something like this in virtually all the cases where an insurance company is involved?
Well, yes, and specifically in the type of case where you have a marine accident and you're facing multiple claimants.
And ultimately, I think you told us 3 out of the 4 passengers or their families you were able to resolve without ever having to go to court. Fair statement?
Correct.
And with regard to the Puigs, that case also resolved itself, but it wasn't through this federal court motion that we were talking about, correct?
No, if you look at the docket of the federal case, there was no litigation went on there. It was filed because we had to file it by a certain date, and when the other 3 claims were resolved by Mr. Pino and his wife, the need for the federal case went away.
Okay. And then what happened to the case involving the Puigs claims?
So there was some litigation, there was some discovery, which is common in complex situations like this. The case was mediated multiple times, and eventually the legal dispute between the Puigs and the Pino family was resolved, and then it's my understanding they also resolved with the other defendants.
With the paramedics and the other claimants?
Ocean Reef and those other parties.
One moment.
Anything else?
Thank you, Mr. Mescolotto. Those are all the questions.
I'm gonna ask for recross.
Thank you, Your Honor.
She did not wait. She said your excuse instantly, so she couldn't even ask for a recross.
Take care now.
Judge, may we approach about the next steps?
All right,
Is
so I
the
think
case
this-
done?
I
Yeah.
think that's their last witness, and then they just have to go through the.
They're gonna have to allocate board if they haven't already.
So they're gonna have to. Well, they're not gonna do that until after closings.
Well, yeah.
Well,
that's
Wish should
true.
testify too. They have to ask him if he wants to, even if they.
Oh, him, yeah. And then they've got to have their judgment of acquittal motion and their jury charge. So I guess they'll be doing that Thursday. closed.
Yeah, because
And what does
they
that
want to
mean,
give the jury a
closing
long. I don't know. Do you
Monday?
think they're going to rebut?
Oh God, with what?
Just because why Laura Adams would be like, I'll
Whose
call
head
my
is
own
that?
doctor.
What is wrong with this cameraman?
That guy likes to be right.
It's his ear hair and shit.
Earl.
Another witness, and I have a few other things that we need to address without the jury present. So we're going to take about 15 minutes right now for the jury. Leave your notepads and inside the office, please, on your chairs.
There is another witness.
I'll text you.
They asked to approach too, so
Maybe it is the prosecution.
Huh?
Rebuttal. They want something.
no, but the defense didn't rest. But I guess they could bring the defense and have them rest. Let's see what they argue. This
GA
cameraman's
Catmom
risky
spent a
with the
$3
jury.
Venmo saying that the prosecutor still highly irritates me.
Oh, she's the worst.
Thanks, GA Catmom.
I mean, the worst is like a stretch. If you got to know, I'm just prone to exaggeration. There's way worse, but she's the worst.
She's the worst of all time.
So you guys, I
She's
think
got to look over the jury. You guys hear what that awesome question I just asked?
Did you get
You
my
got
point
that right.
there? Did you hear that question? I just want
That was a good one.
that one though. That one.
Which trial was it? Was it not Faust, where the guy kept talking to the lawyer to the jury, and then everyone was like ablaze on social media about how horrible he was, and then he stopped doing it?
Oh, what was that case? I know exactly. No, that was no, that was Richens. That was Ramos.
that's what came to mind. That guy that was like
Yeah.
very
Ramos.
Yes.
His first witness, he was on fire, just like, he was walking over to her, he was doing all kinds of shit. Like
I think Ali was getting confused with the like reaction directly to moment, because the defense attorney in the Foss case, Ahmad Cruz, when it came to cross of the alternative suspect, Chris Melton, the ex-boyfriend of the victim, his first question was like, how come you didn't have any tears just now?
I remember that.
Like,
yeah.
so
No,
there's
that
a
was
lot
good,
of
though.
commentary about that.
No, but it was definitely right. Richens, where he was like the whole time just talking at the lawyer, the talking to the jury, and then would point.
You wouldn't
Sometimes he wouldn't take his eyes off the jury, and
he wouldn't. He'd just be like, yeah, it was crazy. So like that went away overnight because
he's probably not
that's not
doing
good.
it ever again. He's probably not doing. I don't mind
Teachable
it
moment.
for
Teachable
like
moment.
a question and a half. You know what I mean? For like
Especially
a
to wake the
powerful
jury
moment.
up for something important.
Right, but like to just and the whole like,
The double shooters.
Pew 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 pew
pew pew.
pew 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 pew.
Ayo.
Cathy Russon is who's I assume a little bit ahead of us. She says George Pino will not testify.
Oh, well,
Thanks for the spoiler, Bob.
Spoiler
what
alert.
the hell, Bob?
Spoiler
Are
alert
you
after the
serious
fact.
right now?
Whenever we bring the chat back, everybody yell at Bob whenever we bring it back.
Yes, that is so unprofessional.
None of us
That's a
thought
rookie move.
George was testifying.
Nobody did, but still.
I
rookie
didn't.
move.
Did you?
There's still a little suspense. I
Rookie
didn't.
move.
I didn't think he
No.
needed to. Doesn't
She
matter
said
what
like
the choice
a
was.
witness. People could be sitting there thinking,
No chance.
"Well, maybe it was." Look,
No chance.
just eat it. Rookie move.
Sorry.
There you go.
I
Hey,
really
Bob,
shit
you're
the bed.
fucking up.
I'm gonna
Fucking
mute
up,
him.
Dave.
Just a few minutes. It might take 1 minute. Just give us 1 second.
Oh God, I am like, my neck hurts, my shoulders hurt. Not
You
good.
need one of those like expensive chairs.
Oh my God, we sat in like the $10,000, $12,000 one at Sam's. We were thinking about it. Like,
Costco.
Costco, right? Should we get this check? I couldn't get out of it.
It was pretty luxurious.
I mean, it like basically massaged your toes.
Oh yeah.
Massage
your eyeballs.
Oh,
Hey,
shit's popping off out
Shit's
there.
popping off.
So, just another big case update. Rex Heuermann sentenced to life without the possibility. Times 8 today.
Times
So
8.
See,
that
now
is
that's
done.
not a spoiler.
That is
Right.
not a spoiler. That is not a spoiler. No spoilage there. And the judge gave him a little business during the sentencing. So there was a camera in there which they released after the proceedings. So some of the footage. So yeah, the ogre is done.
Gone.
Yeah.
Bye, Felicia.
Bye, Felicia.
Judge, maybe we may need about 5 minutes. Can we use the jury room?
All right, they're gonna go confer.
We're gonna go talk to George.
Oh, see, Bob?
Oh,
we would have
yeah.
all been in anticipation.
Oh, George!
We would have all been sitting here in anticipation.
Listen,
Look how many
Cathy's
lawyers
not
just
a-
went.
All right,
She's not
so,
a
you know,
fortune
what they're
teller.
doing
Maybe she's
now is
wrong.
they're discussing whether George is going to take the stand.
Oh, yeah.
And it's such an in-depth discussion. It's so not resolved that they need 5 minutes in a jury room. Woo! Oh my
Yeah.
gosh, you guys. Maybe they're actually calling it. Maybe he's going to testify.
Oh, yeah.
Wow.
Make the argument, babe.
We can't have.
Make the argument.
Conversations we can't have.
Make the argument for George testifying. If you put him on the stand, somebody asked.
George might be insisting. He might be adamant back there. It's a real fight. I wonder, guys, might he come back and take the stand?
I wonder. I think some people might.
Me too, Kat. I'm
be
wondering,
surprised
will he
he's
take
not.
the stand?
Thank you, Your Honor.
No, I think some people like, based on the commentary, like he's so self-absorbed, he's going to want to take the stand. I think there are some people that are watching the show that might.
Yes, sir. We explained to Mr. Pino his right to testify and his right not to testify.
And?
Two competing rights. He needs to choose one. And with our advice, he has elected not to testify. I've explained to him that if you choose to testify, that you would colloquy him and explain to him from the court, I believe the same thing I've explained to him, and he's prepared to let you know that that's his decision.
Okay, very good. And I think you've already, I think I saw you this morning. Okay, you know, we're just about at that point in the proceedings that, well, I think there might be another witness being called in the case. This would be the time that if you wish to testify, you are certainly entitled and permitted to do that. You remember that I had instructed the jury, even during jury selection, that every person who's accused of a crime, any person who's accused of a crime, has an absolute right to remain silent. At no time is the person accused required to make any statements or give any testimony at all. And that applies similarly to you. And a jury cannot hold it against someone for choosing not to testify. Okay? So this is one of the decisions, there's 4 or 5 decisions that are held by the defendant solely. Your lawyer cannot make the decision for you. It's never going to be their decision as to whether or not you testify. But you took time, and I want to make sure you had sufficient time to speak with your attorneys about this important decision. Hi.
Yes, Your Honor, I spoke with my legal team at length, and
Okay, let me keep going, but have you had sufficient time to do that?
I have sufficient time.
All right. And while they even give you their advice, understand that's their advice, and sometimes I'll have someone say, well, on the advice of my lawyers, but the real issue is, you have to make this decision as your own, knowingly, freely, and voluntarily. While again, lawyers can give you advice, they can say what they think would be best for you, but it's not their decision. So, and they're giving you advice based upon their assessment of the evidence that's been presented.
Yes.
All right. And have you made a decision as to whether or not you wish to testify?
Yes, I have made a decision.
Okay. And what is your decision, sir?
I do not wish to testify.
All right. And has anyone forced you into that decision?
No.
Threatened you in any way?
No, Your Honor.
Said to you, Mr. Pino, not only are we giving you the advice not to testify, but we're telling you that better not testify, or anything along those lines?
No.
Okay. All right. So this is your free and voluntary decision.
That is correct.
Do you understand, though, that you do have the right to testify if you wish to do so?
Yes.
Okay. Very well. No one is forcing you into this decision. You're making it of your own free will.
That is correct.
All right, very good. So, you can have a seat, that's fine, and I think we're going to have your witness, you want to check on the witness?
So here's where we are. The witness is here.
Okay.
She's the witness who had testified previously, who and not had an opportunity to,
The other, right,
so
okay.
there's a recording that she would, I guess, listen to, I guess, authenticate.
It's her on the phone, right?
That's right.
Okay.
And so
Do you have it?
we do.
Okay.
It may require, because the volume is not very high,
Okay.
so that it may be clumsy in terms of how it's presented, because she would need to listen to it, maybe even with headphones on the TV, or on the
She could
TV.
come up here on the witness stand with a computer, listen, observe and listen, and then you could just continue with the questions.
Okay.
Any issue with that, counsel?
Well, yes, Judge, because number one,
course.
I don't think that she can be impeached based on her saying, I don't remember. What they can do is try to refresh her recollection with something. I understand that, which they want to show her may be in evidence, but she shouldn't have her recollection refreshed in front of the jury in that way. Normally, when up until the time we had all this video evidence, it would be a matter as simple as showing a written statement or a deposition. So I would suggest to the court that they see if they can refresh her recollection outside the presence of the jury, play whatever portion of the video that they want, ask her if it refreshes her memory. Then they could put her on the witness stand and say, did you have an opportunity to view part of your interview with Lieutenant Thompson? I think that would be the way to handle
Let
it.
me ask, did you go back, because you were going to go back and look at the exchange that had taken place? Whatever
We did,
it was?
Judge. Mr. Forrest has the exchange of what was said.
Judge, I looked at it. So basically, the defense asked about whether or not the witness saw the defendant on the floor, unconscious and bleeding. Her response was that what she was then shown her a transcript of her statement to detectives, asked if it refreshed her.
I'm sorry,
Yes.
was that the transcript of this?
Correct. It's a transcript of, yes, Judge, it was that transcript. She was shown that transcript, and she said, I don't remember, but I guess I had to have said that. So to me, they did impeach her, and really, I don't think any extrinsic evidence is necessary, because she said, I had to have said that in front of the jury.
Okay, so this is, I think, how it's best to handle it, all right?
They're giving deference to the
You call
defense.
her, well, she called as a state witness. right?
Finally.
So you're going to call her as a defense witness. You want to address this area, okay? But before I bring the jury in, all right, I'd like her to sit here and, without any conversation, review it, look at it, okay?
Authenticate it.
And we can go through the steps of seeing if, you know, you can ask the question to see if this item refreshes her recollection as to what was said.
Wow.
Okay?
Outside of the presence of the jury.
All right. So do you have headphones or a way to?
Well, if it's outside of the presence of the jury,
They
you
don't
can
need
play it.
Put it on the TV, that might do the trick.
Okay, that'll be fine.
Shall I get the witness?
Yeah, so let's go ahead and bring the witness in first, and then we'll bring the jury.
So I've got two questions, Kat. One, how did you get the "We Love Due Process" over there? I don't know how to edit.
Yes,
any
we
of
need to
this.
know. We need to
Oh,
know.
okay. So I have two different versions of it,
Oh,
but you can
Oh.
also like sometimes, and I don't think you can see me transform it. You don't see any action on the screen as I'm like manipulating it, right? You probably don't see
No,
it till
but
I hit
I
update.
can't do that. When I have hours up, I've tried to drag things and move it, and I can't do anything.
I think the best thing to do is, well,
I'm
because
gonna have to
you
call
want
you, and
you
you're gonna
also
teach me how to make a
yeah,
banner.
we'll
Okay.
do that. We'll do
And
that.
then every time I hear the words like close to willingly, knowingly, voluntarily, all I hear in my head, babe, is Gacy. When he says that on the tapes, he says everyone who came in my house came in willingly, knowingly,
knowingly,
voluntarily.
voluntarily.
And I'm like, and I
What a
can't
creep.
hear it now without hearing the creep's voice in my head. And if you don't know what I'm talking about out there, listen to Buried, the John
Inside
Wayne
the
Gacy,
inside the John Wayne Gacy investigation.
Inside the John Wayne Gacy investigations, wherever you get your podcast. But and for those of you, when you guys come back in from the chat who have listened, tell me if that's like something that happens to you too every time you hear that. Like I've heard it maybe more than everybody else, but it's like I can't get it out of my head. It's just so depraved. That's all.
That's all.
And remember, also yell at Bob when you come back.
Yes.
Oh, yeah. And also,
Rookie.
Deb sent another $10 Venmo saying, hate to break this to lawyers, but jurors want to hear the defendant deny. I've been on 2 juries. Very
We
tough issue
know.
in both. Psh, Deb, aren't you like a long timer on our channel? We obviously know that. That
Yeah.
doesn't.
I
mean,
think it would backfire though. He's gonna cry, and then it would be a whole issue.
In
and
every
then it's
case,
like, or
in
not
every-
cry.
You know,
we
Kat, but I
always
wanted
know
to.
every jury wants to hear from and every single person on the planet is like, oh, well, if I were ever accused of a crime and they were trying to convict me of it, there's no way in hell that I wouldn't testify. Yeah, watch.
Yeah, the one time that Bob and I let a defendant testify, well, I say let, you know, like you heard the judge, it's their choice, but not unless they're what's her name? Not Richens, but the other one that went through 5 lawyers and then
Sarah Boone.
yeah.
Oh,
You know,
yeah.
they're going to like listen to their lawyer's suggestions. So it's really whether you let them, you know. But the juror came out and said that they thought he was like, from his testimony, they thought he was an asshole and they didn't like him. So that, you know, it's like, but to Kat, you mentioned earlier, like people saying, oh, this guy might testify like that. It goes against what people say about him as being absorbed. How in the fuck do people out there think they know a damn thing about what and who George Pino is? Like, how do they know if he's self-absorbed or not? Has he been
But
out
that's
there
the
in
way
these
people
streets?
think. That's the way
Right.
people
For what
think.
reason? Just
Welcome
because he
to
has a boat?
He has
Streaming
money.
Trials,
It's 'cause he
Allison,
has
where
money.
everybody makes broad generalizations about everybody on screen as if they're TV characters instead of real people. It's like we like what? Everybody does that. Everybody like, oh, that guy's fake crying. Oh, that like you don't know jack
No,
shit
but
about
fake
this.
crying is one thing, but
Any
saying
part
he's
of it, it's all
self-absorbed.
the same shit though. All of it's
Right.
the same shit. All like any kind of estimation on what somebody's doing being authentic or not is a complete speculation because you don't know anything about the person. It's
Yeah.
crazy. It's crazy, you know, but like it's part of what people enjoy about watching trials. It's everybody's entitled to their opinion, you know.
And to that person's point, who was it again that sent the Venmo?
Deb.
Deb.
Bob and I spent like a concerted effort during voir dire of jurors to like really go at them with that. Are you going to be in the back of your head thinking, well, I kind of think this guy should have testified. If he didn't do anything, why didn't he testify? Like, I know you're saying it and the judge is telling you, but in your heart of hearts, are you sure you won't hold it against them? Like in like every different way, and to each juror, not to the panel, like to a question that you must answer and you must answer and you must answer, you know,
Yeah.
just in hopes that maybe they'll be like, when they're thinking of it in their heads later, they're like, all right, I promised I wouldn't do this and I won't do it, you know, because we know that I'm always like screaming at, and that's the whole thing that I'm always screaming because I mean, lawyers forever, it has just been, all right, we rely on reasonable doubt, and they don't go on the offense and put on a case and like do their own thing a lot of times. And it's supposed to be, you know, all on the state's burden, but we know jurors as people, we've seen it too many times. And even nowadays with big trials, and you're like, people being like, well, Karen Reed didn't prove that she didn't do it. She didn't prove those house guys did it. You know, and then it's like you just want to take a fucking hammer to your head and be like, no, she doesn't have to prove anything. She just has to make you think, could it be something else? And did they prove it? Did they prove it was her? Or could it be someone else? Either one gets you reasonable doubt, you know. But we appreciate it, and thanks for the Venmo.
Thank you.
I don't know why they're doing this. Don't you think they've established enough that he was on that boat?
I couldn't hear you, I'm sorry. Yeah, and actually, well, here she is. Maybe we can resolve it even without it, because we sent her the recording over the weekend. Maybe she's already listened to it. So we can find out during this colloquy right now.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth? Yes.
Come and have a seat over here. Why don't you inquire?
Okay, and good afternoon, Ms. Monterrey.
Good afternoon.
When you were here last time, Ms. Gomez had asked you some questions about the statement you gave to Lieutenant Thompson in April of 2023. A recorded statement. Do you remember having given that statement to Lieutenant Thompson?
Yes, I don't remember the date, but yes.
Okay. And at that time, do you recall telling Lieutenant Thompson when he asked you about where George Pino was on the boat after the impact, that you had said, he was on my right, like on the floor, yeah, and he was bleeding, he like unconscious, and then the boat was like sinking, so I jumped from my right, like I jumped to my right. I don't know, I didn't see George after. Like I saw him, like when I jumped, he was still on the floor.
Looks confused.
Yes.
You recall telling that to Lieutenant Thompson?
Yes, after listening to the recording.
I'm sorry?
Yes, my memory was refreshed after listening to the recording.
Okay.
And what you told Lieutenant Thompson, is that
Don't ask
was it
anymore.
true that you saw Mr. Pino bleeding, unconscious on the floor?
Yes.
Thank you very much. So,
Should I have the witness step outside now?
I don't think it's necessary. I would then just, we don't need the recording if the witness is prepared to just testify to that. Those three questions will be done.
All right, and I don't, you're calling your witness.
That's right.
In front of the jury.
That's
All
right.
That's fine, Judge.
That's it. Okay.
So the judge is saying, do you want her to be off? So
That
then
way
you
you
get
can
to
call her
in?
informally.
Right.
The jury's what, down the hall? Okay.
Judgment, before we proceed, may I just ask the witness one last question while we're before the jury gets here,
Sure.
so that we clarify. Last time you were here, you were asked some questions about who told you to jump from the boat. Now, do you have a recollection of who it was that told you to jump?
George?
Before he was unconscious, or after he was unconscious, or when?
He told me to jump after he was unconscious.
When he regained consciousness?
He was in the water and told me to jump. So I'm guessing after he regained consciousness.
That's your best recollection?
Yes.
Should have saved that.
All right, so if I could, please, I'm going to ask the witness to just sit right on the benches outside. We're going to call you back in. When the jury is
Yes,
coming
Howard.
forward,
He said it
okay?
while he was
All right,
unconscious.
just don't say anything as the jury's
Well, because
walking by.
they want him to be
Okay?
unconscious longer, I think.
Yeah.
So that
So the name will go up.
I was making fun of him because his question didn't make any sense.
Proceed.
And he clarified it.
The witness as your next witness, okay?
all right, bloop, bloop, bloop.
Oh yeah, sorry.
Bloopage. Bloopage.
Hey, I wonder if George will
I would have a
testify.
motion to make post-trial, a post-resting motion. How do you want to handle that?
The
before
JOA
the
again.
State's rebuttal case? If
We're
they have
doing a
one, I don't know if
rebuttal.
they have one.
Oh.
If you don't mind me asking, will this be the last witness?
Right,
Okay.
yes.
I would say, Judge,
I'm going to probably ask the jury just to step into the jury room for purposes of you making any, after you rest. Well, actually, then it would be, we would go through to the state's rebuttal.
Right.
And at that point would be your additional motion. Do you have a rebuttal with this?
I do, Judge, but I don't want to drag things out, but rather than litigating what I presume will be the second JOA motion.
I'll do that today.
Oh, 100%, but like if the judge would give us like 20 minutes or so in between the defense resting and us litigating the case, and then the state putting on its rebuttal case, that would be great.
Okay, but
No.
you haven't done this, right?
Yeah, we're going to finish today.
Oh, I just wanted to.
Yeah, we'll be done
That
today.
witness is available.
Correct.
Okay, all right, that's fine.
Why would they be arguing their JOA before rebuttal?
And so we're going to rest after this witness with the understanding that we've offered the Thompson, Scolavino statements, and the court has excluded them.
Correct, but you're going to mark them.
They're marked.
They're marked already,
it's-
so we'll put on the record what they're marked as is for identification.
Doesn't need to be in front of the jury, obviously.
No, do that now, actually. Which of course, let's walk in
They're
there as soon as you saw.
834.
Which of course, let's walk in
They're
there as soon as you saw.
834. That's the FOIC report.
Correct.
So at this time, we will formally offer Defense Exhibit A34 for identification. That would be the incident report. Just those statements that we contend are admissions by the party opponent that alcohol did not contribute to the...
That we addressed during our pre-trial litigation?
Yes, Your Honor.
Okay. And that's marked already as 834?
Yes,
Yes.
Judge.
Okay, so marked for identification is 834. My ruling remains the same, but the record is clear. Stay with it.
And likewise, the admission by ASA Ruben Scolavino that the case did not support a recklessness charge.
And that's in the form of?
That would have been within the deposition testimony of Lieutenant Thompson.
Do you excerpt that? How was that?
That's going to be a good stipulation.
Because you're gonna make a copy of it, I presume, it's part of the record, and it'll be marked for identification.
Shall we mark it as 835? Is that
It's going to be 838.
838, excuse me. We'll mark it as 838, and we'll tender it to the court after the jury steps out. Does that help?
Okay, because the other, I guess the incident report was already previously marked for identification. We're jumping from 34 to 38.
There must be something in between.
Yes, there are things in between, Judge. They're jumping to the 838.
So you need the first page of the deposition so we can identify it. And I assume you have other copies, but
Yes.
whatever the excerpt portion is, we'll note that it's 838 for identification as part of the record. But we have to make sure, understand, it's not existing, going back to the jury, my ruling remains the same.
Understood.
Yes.
Ready?
Can I go ahead and bring the jury in?
Yes, and Ms. Gomez is going to do the examination.
I can just mark this after, it's not.
All right, defense, would you call your first witness?
The defense calls Carolina Monterrey.
All right, would you please step forward, face the clerk, and be sworn?
You solemnly swear affirm testimony about to give you the truth and the truth and nothing but the truth? Yes.
While you're here, let's see. Thank you. Remember to keep your voice up, okay?
Good afternoon, Ms. Monterrey. Can you please introduce yourself again one more time to the jury?
Hi, I'm Carolina
Oh
Monterrey.
my God. Hold on, let's lower that. That's like when Bob comes in super loud.
Ms. Monterrey, have you had an opportunity
Objection.
a video recording of your interview with an officer following the accident?
Yes.
And having reviewed that video, did you refresh your recollection that following the accident, after the impact, you in fact did see Mr. Pino on the floor, unconscious, bleeding?
Yes.
You recall having witnessed that right after the accident?
Yes.
Okay, that's it. No further questions, Your Honor.
Okay. Any questions?
No,
Very well. Witness is excused.
Fence rest.
Well, they're getting some stipulations in.
Judge, we have no additional witnesses. Mr. Pino's case rests.
Thank you. Okay.
Well, what about the stipulations? That's evidence. I thought they...
It seems a little strange, but I'm going to ask you to put your notepads down. Did you have a snack yet? You did. Good. Would you please, if you would, step into the jury room. Please do not speak about the case.
So here's the thing. The judgment, or let it play with the volume down maybe, or you can just bloop it, I guess, after.
Yeah, I'm gonna
But
skip forward.
your motion comes after, so it comes after the close of the state's initial case, and then
after
the
the
close
close
of all
evidence.
evidence. So I don't understand why we're even talking about doing it right now before they call the rebuttal witness, but whatever.
Is the state calling a rebuttal witness?
They said,
They
yeah.
said they have
I
one.
mean, come on, this chick wants the last word no matter
Oh,
how.
good old Laura Adams. All right, so before we hit it back up, so Michelle had asked, do you think the maritime attorney helped or hurt George's case?
Now I'd like to know why she asked that, why she thought it hurt. I didn't get to see it all, but I would have assumed it helped to establish that that this was the lawyer restating prior words, and also it almost showed they did their own investigation and still thought that that was the possible scenario, right? That there was I just thought it was odd that the defense is going through so much with the memory, concussion witness to explain a false memory, but on the other flip side, having this lawyer come in basically to say, and you know what, could have been a car with a boat with a wake. I mean,
Yeah.
because that's kind of what he did, right? Or no?
Well, yeah, that's kind of what he did. But there's a couple of things with insurance policies. They don't pay out in intentional acts. So if you intentionally do something that, the insurance
They
companies
didn't get to ask that, did they?
no.
Oh.
And they also didn't get to ask whether or not they had investigated if he was intoxicated, because they won't pay out if you're intoxicated either.
I think they also wanted to make sure that the attempt to impeach Miss Pino, Cecilia Pino, was completely taken off the table.
Yeah.
Because I think Carolina, I mean, why did I say Carolina? That's the witness we just had. I think Cecilia explained it on her own. And I think the questions were quite different. Like, we had the prosecutor, while cross-examining Cecilia, tried to frame a question about, what's your understanding of what happened? She tried to frame it as if that was signing off as her personal knowledge and only her personal knowledge, when I don't think the interrogatory was even phrased that way. And so Cecilia responded back well, that was my understanding of what happened based on what people were saying, what my husband said. And that was it. But I think a lot of what we're seeing with the attorney being called back to the stand is to show look, she's not the one that would have written that language anyway.
Right, exactly. And my only statement on it is I agree with you, Kat, in terms of your estimation on how the jury may have been perceiving that particular attorney as to what his role was, or who had actually hired him, or who he represented, was damaging to George, in the sense that I think that it could make the jury feel a certain way. And then, the thing that Allie and I were both hoping that Howard would come up and say, he did say, where he made it clear who the lawyer worked for, so I think that mitigated it some. Whether or not that guy is going to swing a vote one way or another, I don't know. I don't think so.
Yeah, I don't think so.
But and then there was one, but thank you, Michelle, for the question. It was a great one. And then Deborah had said, wanted to just chime in one more time just to clarify. All right. So she had said, hey, look, I just want to make abundant, just to make it clear, so you're very clear on this. I do not believe that a defendant needs to testify, or the defense needs to disprove anything. Just saying what my experience was on two juries in New Hampshire. We know. I know, that's what we're saying. We know every. That's
why would you get an attorney if you were innocent? It's just a thing. And I really think that having conversations like this is getting more people to think hey, maybe sometimes innocent people do take plea deals for certain reasons. Maybe people lawyer up because they're innocent and don't want something to be used against them, and they have zero guilt, right? I think a lot more people are warming up to those realizations, those sentiments, those realities.
Yeah.
But I don't think that was necessarily the case before, you could watch trials with a chat on YouTube
Oh
and
yeah.
see somebody else's perspective out loud.
I like to think that it's channels like ours, our two channels, that have gone a long way in educating people about exactly what you called it, which is a reality. Like the amount of people that have not committed crimes that have been overcharged and are offered, a downgrade from a felony to a misdemeanor with no jail time, plead out to things that they haven't done all the time because the state has overcharged them on something, and they're saying, they'll put them through the process, they'll put them through the ringer for a year, 8 months, a year, and then they'll all of a sudden they'll say, all right, well, we will make an offer, we'll reduce it to a misdemeanor, no jail time or time served. And we are obligated to go to our client and say, hey, I think we could beat this at trial. However, they're
There's
making
always
this
a risk.
offer. Right. And that no jail time thing, they're like, "Psh," I'm like, I'll take it. I don't, it's like,
And
I'm not
getting
trying
out
to
now
go.
if you're already detained
Right.
and no
Exactly.
bond.
Exactly. So, I mean, it happens all the time.
I don't know if they're speaking here because captions like popped on. It just says you.
Okay, we seated? Let me just give you a couple of minutes to gather your thoughts, and then I'll go ahead and take the motions, okay?
Didn't they just have a couple moments? But okay. All right, so here we go with JOA round 2.
Whenever you're ready, Judge. So, Your Honor, we're here again moving for a judgment of acquittal on both counts. We understand that the standard for Your Honor's review is taking the evidence in the light most favorable to the state. Could a rational jury find that the state has proven all the elements beyond a reasonable doubt? And so I'm going to try to read my audience, that being you. You've already ruled, at least through the state's case, that there was enough evidence. And so what I'm going to do is readopt the arguments I make, but ask you to focus now just on the culpable negligence manslaughter charge, because that is the more serious charge. Of course, both of them are very serious. As the prosecutor alerted you, the guideline sentences for vessel homicide, 9 years in prison. The guidelines for culpable negligence, I think, is 11 years. So we're talking about two very serious charges. But in terms of the government or state's burden of proof, there is a higher mens rea element with regard to culpable negligence. And so even if the court is going to allow the recklessness charge to go to the jury, and I've argued to you why that shouldn't happen, because there is no evidence of a course of conduct by Mr. Pino to drive in a reckless manner. For the state to establish culpable negligence, there needs to be, apparently under McCreary, recklessness plus, something beyond just being reckless. It has to be something even more serious. And to be clear, even if you were to grant the motion just as to the manslaughter charge, we would still be facing this recklessness charge. And I'm inviting the court to give greater consideration to that, if for no other reason that to try to get a jury to understand the difference between the two. I think you're going to find, if you haven't already gone through the nuances of the jury instructions, it is going to be a nearly impossible task to explain to the jury the difference between the two, because the language for culpable negligence incorporates the word reckless. And so it is particularly confusing. And so we're quite confident in our position that mere elision coupled with catastrophic injuries does not establish recklessness. The evidence presented through Mr. Albert, the lieutenant who served as the government's expert, I think the takeaway from his testimony, the government's theory when we brought him back, is that Mr. Pino simply did not see the marker, whether it was because the passengers were seated in the designated bow seats and raising their arms and distracting Mr. Pino, approaching a marker that is 5 feet lower to the water level than the other markers in the channel at a time, high tide, when that marker was at 6 feet above the water line, and the passenger seated on the bow would necessarily have obstructed the view of that marker. The combination of those things, under Mr. Albert's theory, would have required that Mr. Pino take some action to have the passengers clear the way for him to see, and that his failure to do that was the cause of the accident. That is the takeaway from Mr. Albert's testimony, all of which adds up to, at best for the state, ordinary negligence. Failure of Mr. Pino to create a proper ability to see this marker that's lower in the water at high tide. It does not evidence some course of recklessness, given that Mr. Pino had navigated that channel that day, both going up to Billy's Point and returning back. His operation of the vessel put no one in danger. He was able to navigate through that channel, coming back at the speeds that the state contends were, in their view, excessive, but apparently not so, because you've heard it already from other witnesses, including law enforcement officers, including David Rodriguez, who was traveling upwards of 55, if not 80 miles an hour in Biscayne Bay. And so it was ideal conditions to operate a vessel at the speed at which Mr. Pino was operating the vessel. So all that the state has as a theory is that Mr. Pino, looking through a windshield with 7 girls sitting in a designated bow seating, some of whom were celebrating the birthday by waving their hands and singing, obstructed Mr. Pino's view. He did not see the marker as it approached in the last 9 seconds. There was plenty of time, if he had seen the marker, according to Agent Albert or Lieutenant Albert, to avoid the marker. But of course, if he didn't see it, that explains why he hit it. And I say to the court, if you think that maybe there's recklessness there, we say not, based on all the cases we've cited, it certainly doesn't then elevate to culpable negligence. And so at a minimum, Judge, if for no other reason than to give the jury a simple question to answer, if they're going to have to decide this case because Your Honor is not prepared to grant a judgment of acquittal as to both charges, we submit that at a minimum, preserving our issues for appeal as to both counts, we suggest to you that the immediate option would be to grant a judgment of acquittal as to the manslaughter count. Thank you, Judge.
Thank you, sir. State?
One moment, please, Judge.
So start off with, if you can answer the
Yes.
issues of fact in dispute for why the case, both counts should go to the jury at this point. And while my standard of reviewing the second motion for judgment of acquittal, and generally, by the way, we would have this argument post any rebuttal case by the state. So I'm going to take the arguments here and consider them renewed because I understand the state is going to call the rebuttal witness. Go ahead, State.
Your Honor, at this point, even with the defense having presented a case, this is not a scenario where a second judgment of acquittal should be granted. Number one, the claim that the defendant's view of the channel marker was obscured by girls standing and singing and dancing, I would point the court to the cross-examination of Miss Portocarrero, who testified that yes, they were dancing and singing and all of that at some point on the boat, but I asked her very specifically, in the moments leading up to the crash, were people standing up and singing? And of course she said no, because it's illogical to believe that people are standing up and singing and dancing while a vessel is traveling just shy of 50 miles per hour through the water. Moreover, it is...
Well, there's a conflict in the testimony, right?
I would submit no.
Let me make it clear. No one has contended that anybody was standing. It was simply that they were raising their hands dancing.
All right,
in their seats.
All right. But there's conflict because maybe one or two witnesses testified to something about moving their arms around, but in terms of how much of a view could or could not be obstructed, isn't there a question for the jury?
No, because the only witness who said anything about that was Ms. Portocarrero, and I asked her, was that going on in the moments before the crash happened, and she said no. So from the state's perspective, the defense established that at one point the girls were doing that, but not at the time in the moments leading up to the crash itself. So that's number one. Number two, there's no, even if hypothetically there were arms waving, the seats, they're meant to be seats. It defies logic to think that this vessel, which the court had the opportunity to see, the jurors had the opportunity to see, that young women seated on those seats, just the mere waving of their arms. None of them are like, mixed martial arts fighters or something. There's no way that their arms would have obscured the view of that channel marker.
That's not what your
Beyond
expert
that, the defendant himself confirms that he saw the channel marker when he's at Elliott Key and talking with Lieutenant Thompson about how the crash happened. He talks about the fact that we were approaching the last channel marker. So clearly he knew it was there. Clearly his view was not obscured by these young women's arms. Now his view may have been obscured because, I don't know, he closed his eyes for 9 seconds. He was looking at something else. He was looking down at a screen. I don't know what he was doing, but whatever it was he was doing, he did not see this for at least 9 seconds, which is a really long time when you're going that fast, or he did see it and just thought, I'm not going to do anything. Either way, when a hazard that you know exists is coming up rapidly to you and you have the ability to see it, if we just agreed in criminal courts that, well, as long as the person didn't see the hazard, then it's just negligence, that just does not make sense. And the law is supposed to make sense.
Well, so counsel raised the argument, well, even if there's evidence of recklessness, certainly there's not the greater amount of evidence to rise to culpable negligence. Can you answer that?
Well, I would submit to the court, as I did in our first JOA motion, had there not been all these additional people on the vessel, had there not been all the alcohol that we know was consumed by the defendant as well as the girls that were on the boat, if under that set of circumstances, and if he wasn't even traveling as fast as he was, if he, pursuant to the GPS data that we have, ran headlong into that channel marker when he had ample time to avoid it, I would agree this would just be vessel homicide. But this is reckless plus, because he did have 12 minors on the boat, many of whom had been consuming alcohol. He himself admits that he had been consuming alcohol. Now, he claims it was 2 beers. the jury gets to apply to his statements the same type of evaluation as they would to anybody else. Did that witness, or did his statements come from a person that might have, I don't know, a motive not to tell the truth? If this defendant was so brain damaged that he's making up, claims of other boats that now the defense says, yes, they weren't there, then maybe also he forgot how many beers he actually had. Or the converse could be true. He deliberately knew there was no other vessel, but he wanted to blame someone else for his actions. And he knew that he'd had more alcohol than 2 beers, but he wanted to undermine his liability, culpability, what have you. So this is not just recklessness. This is recklessness plus, because not only were there all those minors on the vessel, but even if hypothetically each of them only weighed 100 pounds, you're talking about an extra 1,000 pounds on the bow of that vessel, which, as the court has already heard, is going to make the vessel more difficult to navigate, especially given that boats are steered not from the front, but from behind.
Did she ask the witnesses
Obviously,
any of their
boats
weights?
don't have brakes, but we have so much more here than just a man who runs into a channel. We have a man with alcohol on board, with minors on board, with many minors on board, who also has a long-standing knowledge of that channel and where that channel marker is. So in terms of culpable negligence, I think we have absolutely established culpable negligence, because it is such an entire want of care as to almost be a deliberate disregard for the safety of those that were on his vessel.
How does the GPS at all play into this in terms of how the GPS was set or not set?
Set or not set?
In terms of assisting Mr. Pino, if at all, in the navigation. What was the only evidence is the GPS, right?
Right.
And
Well, it's not the only evidence, but in terms of the track of the vessel prior to impact, absolutely.
Okay. But there was a change in that.
The only change in the vessel's path right before impact was when he went further 5 degrees to port, which put him right on that path, which is why this is charged as manslaughter, not only on the culpable negligence theory, but also the state has pled that by intentional act he has committed manslaughter, because he may not have intended the death, which of course the jury instructions state, but he was the one deciding to go full throttle. He was the one deciding where to steer that ship. And he steered it, we know, 9 seconds prior to impact, right into the path where that was going to force him to hit the channel marker. I'm sorry?
Also, it stayed on the original path without that change that was effectuated by the operator.
Yes.
Okay. Then the marker would not have been hit.
I'm sorry, I didn't hear the first part.
The marker would not have been
No, I'm sorry, if the court could just back up. The premise...
The operator maneuvers the vessel.
But for that maneuver.
9 seconds before.
9 seconds.
Prior to the maneuver, the vessel, if it had continued on the track without the interaction of the operator, would have not hit the marker.
Of course.
That's...
Yes. It was his action that put him on that collision course, which I don't want to leave out the fact that, yes, for those 9 seconds that channel marker was visible, but it was visible even prior to that.
Okay, let me ask this. You had pled in alternative theories under the manslaughter.
Yes.
So explain to me how, in terms of culpable negligence, how, if at all, or what the state would have to prove if you are proceeding under the alternate theory in culpable negligence.
Culpable negligence being the ultimate theory, alternate, or the intentional act?
There's 2 theories.
Right.
So if the state proceeds under the intentional act,
yes,
there's the evidence of the claimed intentional act would be that change in direction.
Yes.
Okay. So culpable negligence would not be something that would need to be established by the state under the alternate theory as charged through manslaughter.
Right, it's kind of like kidnapping. You can charge somebody with that they've moved someone with an intent to harm or terrorize them, or that they moved them with an intent to commit another felony. Either theory can work. Here, there are two theories for manslaughter. Manslaughter by intentional act, by the act of him simply choosing to go on a path that put him on a collision course.
But where's the intent to
And
terrorize?
or
Where's the depravity?
manslaughter by culpable negligence, because the way that he was operating that vessel was so grossly and flagrantly dangerous as to almost invite a proof that it was like almost a conscious disregard for the safety of others. You know, quoting
and
the
that's
language.
based on more than speed alone?
Of course. There's never speed alone. And speed alone, although I know the defense likes to, chant that jingo, Luzardo in the 3rd DCA specifically said we reject the idea that speed alone is not enough. The 3rd DCA said speed alone is not enough until it is. But there's never only speed. There's speed plus the location, plus the weather conditions, plus, there are so many different variables.
Well, the nature of this channel.
The nature of the channel. It's a narrow channel.
Would you consider that in terms of the prior knowledge of Mr. Pino, would you consider that something relevant, meaning the narrowing of the channel and understanding, how the channel moves?
Yes, because again, when we look at the way that part of Biscayne Bay, when it filters into where Card Sound is, there are only so many ways that vessels can traverse between those two bodies of water. And so by the defendant choosing to operate on the wrong side of the channel, maybe in and of itself doesn't create a danger, but if a person drives on the wrong side of the road just because they see nobody's coming in the opposite path, well, the problem is with the nature of traffic, it's always moving. And we know that there were a lot of vessels around because within minutes after this crash, Good Samaritans are coming to the scene.
And so the totality of your position is that given the totality of the circumstances, the jury could find, a reasonable juror could find, a reasonable juror could find that the elements of the manslaughter, even under culpable negligence, are met. I don't want to put words in your mouth. I want to understand if that's the argument.
That is the argument, and I haven't had the benefit of sitting down and going through all the evidence like I will for the closing argument, but I think that all the highlights from the state's case in chief that the court, and I understand it's different standards, but all of that evidence that came in, none of it was undercut or undermined by the defense case in this matter.
Just one question from the defense, and then I have for the defense. I'll allow you 2 minutes of rebuttal, but my question is, as the state in charge, the manslaughter under alternate theories, can you respond to the intentional act?
Of course.
Yes.
No one's claiming he intended to strike.
Ali, quick question before that. Can a judge constrain the theories that a party can argue as part of something like a JOA?
Yeah, because if it's not the theory that the state presented at trial, and now they're trying to rely on it, then in that sense, she could, limit them. She can't really limit what the defense is arguing as far as, what their theories are. They can do, either side can argue anything from the evidence, but the theory that the state is convicting upon, it's not supposed to be like willy-nilly shifting all about. It's supposed to be like what you presented. We're going to have to listen to this again. Maybe either all three of us or Bob and I will listen back to it and do like a separate video on this, because
I love it, because I love listening to it. And I think the judge is asking good questions. I think the judge is actually kind of giving, she's not intentionally giving advice, but I think she's steering the state to maybe consider that if they argue both things in closing, they might look ridiculous.
Right.
The intentional act?
Of course.
Yes.
No one's claiming he intended to strike the marker. That's not the state's theory.
The intentional act of shifting the
The course, changing course.
Changing course.
Yeah. So the boat was on a path to clear channel marker 15.
Right.
Right? And so the GPS track shows the boat starts heading, changes heading, which the state says puts it on a collision course. Okay. So no one's denying that Mr. Pino was in control of the vessel. The state's theory is he's in control of the vessel, and the state's not contending that he was intending to collide with the marker.
It's still playing, so it's the court camera again. That's annoying. Okay, so it froze for like, oh no. Oh no. Oh no. So we're missing what we wanted to hear.
Because the decedent had no evidence of blood alcohol. So there's no claim that the decedent was intoxicated. So that's a, that's a red herring. There were other girls on the boat who were intoxicated, no evidence that the decedent was.
Okay, well, I want you to come back to focus on, so under the alternate theory of manslaughter, intentional act.
Mm-hmm.
Okay.
The intentional act would have to be he intended to hit the marker, which no one says he did.
Okay.
He intended to operate the vessel. He voluntarily operated the vessel, but it was not his intent to hit the marker. The state's already told you repeatedly if that was his intent, he'd be charged with murder.
But what the state's position is, I think I understood, the intention to actually change course, even the slightest change in course, which then,
Is there evidence he intended to
I think I
change
understand your
course?
point.
Is there evidence that he, on the record at all, that he intended to change course?
I mean, the state keeps saying like he chose a specific course. I don't know. I wish
it
he
just,
would
like,
have. I
merge?
wish the defense would have shut up because I saw the judge struggling to even restate the state's position, and then he's like, "I think I see where you're going," and I wish he would have just and let the judge stumble through trying to restate what the hell the defense's the prosecution's theory is on this.
Look at the freeze. She's like so skeptical right now, trying to put it together.
Go back.
He changes course.
You want it?
Yes, so you can see it there, right there. Perfect.
He intended to operate the vessel. He voluntarily operated the vessel, but it was not his intent to hit the marker. The state's already told you repeatedly if that was his intent, he'd be charged with murder.
but what the state's position is, I think I understood, the intention to actually change course, even the slightest change in course, which then,
What?
I think I understand your point. He changes course to the south. Had he continued changing further south, he would have avoided the marker.
Okay.
Had he left the course as it was, he would have avoided the marker. So he's driving along, and the state's theory is the vessel in Mr. Pino's command starts heading further south, and the vessel is now on a collision course, according to the state.
Okay.
But it wasn't Mr. Pino's intention to aim at the marker. There's no evidence that was his intention. So when we talk about an intentional act that's reckless, yes, I agree. If it was his intention to hit the marker, guilty. But that wasn't his intention. No one says it was. There's no evidence that was his intention. That's the point. See if there's anything else I wanted to say. Oh, and then the state's reliance on Mr. Pino having consumed some alcohol throughout that day isn't sufficient under the Jackson case that we've cited, that has, when we submitted it to you in the form of the proposed jury instructions. And so, since there's no evidence of impairment, no evidence of intoxication, what we're left with is nothing that could elevate this from, if you find reckless to be sufficient for a jury to consider, taking it to the next level of manslaughter and culpable negligence.
Consider the argument of counsel on the second motion for judgment of acquittal. As to count one, the court is going to maintain my position at this point that there is sufficient evidence to go to the jury on manslaughter, and the motion is denied. As to the vessel homicide, there is sufficient evidence to go to the jury that the operation was vessel homicide operating in a reckless manner. So the motion is denied as to both counts. The defense second motion for judgment of acquittal. And again, I'm going to consider this as the argument you would make and present post a rebuttal witness, okay? Because generally I'll take that after the rebuttal, but I didn't want to, timing-wise, keep the witness too long or keep the jury too long.
And may we inquire potential projection?
Absolutely. It's the state's intention to call Rudy Puig, the father of Cathy Puig, not to get into anything other than Cathy, prior to this crash, was healthy, was active.
That's not
was
rebuttal.
An athlete.
That is not rebuttal.
Post-crash, she now is bound to a wheelchair and needs 24/7
What is that
medical
rebutting?
care. And the reason why I believe this is rebuttal, Judge, is because on redirect, after I had crossed Mr. Mescolotto about simply some pleadings that were filed, the defense brought out information which, frankly, I'm not sure if it even violated any kind of confidentiality agreement. I'm not involved with any of that. But the fact that
How is it not
Mr.
sympathy?
Mescolotto
No matter
volunteered
what
things
pretext.
like everybody else settled except for the Puigs, I think the fact that their daughter was subjected to a unique level of injury that
Too much
requires
prejudice.
a significant
Nope.
amount of money. I'm not getting into the terms of the money, but
Nope.
simply to establish that the injuries that Ms. Puig suffered were catastrophic in nature.
This is
It would be no more
absurd.
than just a couple of sentences, but I think it leaves out there the way that Mr. Mescolotto volunteered information to the jury, the thought that perhaps the Puigs were just, looking for money or something, for
It's
their
more
golden
prejudicial
ticket.
than probative. It has no probative value.
Unreasonable. We started to go down a path with the additional questions about the plea litigation that I'm going to allow very limited.
Wow.
Very limited. I imagine this will be over defense objection. I don't want to speak for you. And I think in the questions in redirect, I didn't particularly expect it, but we got down a path. But again, this is not a feature of the case.
Absolutely not, Judge.
And I would, if the defense requested any kind of instruction, or I may be instructing the jury.
This
I'd
is
like to
insane.
address that now, because we're, again, in this matter, in the criminal matter, the
Outrageous.
alleged victim is only Ms. Fernandez, while there were other individuals who were certainly alleged victims. That's part of a civil, whatever the civil matters were, and I don't want to confuse the jury at all. I want to make it clear that this is, this is the only
Please start
individual
screaming
who
and
is
waving
the
and
victim
like.
in this criminal matter.
I've spoken with Mr. Puig. He understands that this is going to be very, very narrowly tailored questions. The whole thing should not last more than a couple of minutes max. I'm not going to make Ms. Puig a feature of this trial in any way, shape, or form,
You're
and I
putting him on right
haven't at
before-
any point in this trial.
You're ending on a bookend
All right,
of.
what would you like to say, Counsel?
So obviously it's over objection, and I assume Your Honor has ruled. I'm struggling to
Find the
identify,
relevance.
since the state had, on cross-examination of Mr. Mescolotto, brought out the business about the exoneration of liability. I think my questions were focused on what that means, and that it consolidated all the cases. It would consolidate all of the cases. That's
I
exactly
can't
what he
believe
said.
this.
I think it went a little bit beyond that, maybe not an exact response to your questions, although I think you were trying to narrow him in the questions. Some of the responses was not clear, I don't think, and I don't see it inappropriate to be clear to the jury that there were different levels of injuries, and basically leave it at that.
Yes.
So can the
Why
court,
couldn't she ask
of course,
that on cross?
I object, but I understand the court rules, and I'd like to understand then what the court is allowing so that I can.
I don't want to go down that path of the, terribly expert.
Wow. Judge, why don't I do this?
Jurors, and it's very, very difficult.
Why don't I just tell the
She's
All right.
trying to make it so she doesn't give an explicit ruling.
So here's the thing. There is such a thing, I think, as too much deference. See, I am not the one like to be afraid to just get bitched at by the judge, to get shut down. Like you saw
Look
in
at Janelle. You see
YSL.
Janelle's
that
hands
guy's-
right now? She's like, look at her
But-
hand here.
He's saying, I understand the judge's rules and that you've already ruled, but she fucking ruled before you talked. So that's
Yeah,
when you have
fight
to
that.
say, Your
You didn't even
Honor,
let me make my record.
right. In all due respect, I understand that you see that we have an objection, but I need to make a record and I would like you to consider my points before you rule. So I understand. I'm taking this as a preliminary ruling until you hear what I got to say. And she's going to have to listen. He's being too deferent. Like there is no relevance. She has been trying. Like now I feel like her because I'm like, she has been trying. The prosecution has been trying to get the fact that these other children had catastrophic injuries, had severe injuries, get the other injuries and the other injured children in front of this jury. And now she found a window. And I guarantee you that she did not just ask this guy to testify 10 seconds ago when the guy got off the stand.
I agree.
And
Absolutely
that
agree.
I would be like absolutely asking them that. I would be making a huge, I'd be saying all of these things right now. Your Honor, I'd like, first of all, has he been sitting in the courtroom? He's not sequestered? So let's get him out while we have this argument, first and foremost. And secondly, all the things that I said. And if she wants to get this information in front of the jury, then she should have done that. Then we can recall the see, that's a problem when the judge doesn't allow recross, because she could have recrossed him on it. She's forcing everyone to have to like recall witnesses, but this is a too emotional witness to do it through. It's way more. There is no probative value. How does it impact the state's case whether or not this other woman wanted to settle or not? She is the one that tried. Right. She is the one that was trying to make it seem like, as you kept pointing out, Kat, that George is making all these decisions and trying to limit his liability and avoid accepting responsibility and not being accountable to these children, these poor victimized children. That's the picture she was painting. That's why they had to ask those questions. Now, what the fuck did she just say her point was? Well, Your Honor, I think it left the jury thinking they were being unreasonable. How is that a thought that impacts this case and gives you the right to then put on evidence to clear that thought? It's an irrelevant thought.
If it's excluded, and I guess the argument would be that the defense somehow opened the door. I disagree that this was opened up, because they're even saying that like this is not an opening the door for the condition of Cathy Puig. Like,
but
the
that's
judge
what she
is
wants to get in.
maintaining
She
that.
said she wants to get in that they have
There's no way to
catastrophic.
separate. There's no way to separate the two. And if the defense had certain motions in limine and knew certain constraints were in play for this entire trial and built their strategy around something that's now going out the window during a rebuttal case, how is that not a problem?
What they should be asking for is, Your Honor, what we would suggest then is a stipulation or limited instruction that says you're not to consider, that both parties agree that the litigiousness of such and such was warranted. I don't know, whatever. You can say whatever she just said. This left the jury thinking vomit out of her mouth. Then I would say, then I will stipulate to the judge advising the jury that repeat vomit the parties agree that's not the case. It was something like that they were too litigious or that they were pushing. I don't know what it was, but how the fuck does it have anything to do with this? I mean, like, this is just insanity. And to me, these lawyers are all sitting down, acting like this is no big deal. And it's a huge fucking deal. It's a huge fucking deal. For the last thing the jury to be hearing and seeing is,
Girl in
there was
wheelchair rest of her life.
right. What? What? Are you gonna hold up the picture again? Oh, he's not gonna cry.
What if she has a picture of Cathy to show?
Oh, I'm sure. Like, and I would be challenging her on that. I mean, I guess he's been there every day, but what we would like to know, I mean, it wouldn't matter at the end of the day for whether he can testify or not, but damn well she did not just come up with this right now. She was always putting him in on rebuttal, trying to find some way to do it. She probably asked those questions just so the defense would have to touch on it, just so she could make this ridiculous argument that the judge is buying. And the defense is not objecting enough. To me, when he's saying, I understand, it sounds like you've already ruled, and I understand the rules of this courtroom, that once she rules, you're not supposed to be coming back and trying to get her to change her mind, is what I took from that. Like, why he's like, so I'm not going to do that thing you don't want us to do. But everybody needs to stand up and say, wait a minute. Your rule is premised on both of us getting to speak first. I might have points you haven't considered, Your Honor.
Yeah, and it's
Wow.
at that point I don't know. I never like when a judge doesn't want to hear an argument. At least one round from both sides. Like sometimes they try to rule before someone gets their final reply. But at least
Usually
both
they can
parties have
do that.
spoken.
If
Yeah.
they're going to rule against the person that has already spoken, then go ahead. Right?
Right, but let them speak.
If you're not going to, no, I mean, like, if she was going to rule against the prosecution without letting the defense speak, okay, obviously that's fine. But if you're going to rule in her favor, you sure as shit better let the other side make the record and have a chance. You're supposed to be contemplating all people's arguments here.
Yep. And
she should have said, I'm inclined to. So let me hear, unless you change my mind. That's what she should have said.
Yeah, I agree. And maybe she will. She's been kind of wishy-washy.
He doesn't seem like he's saying anything else. It seems like he is sort of done, except asking to understand
I
what
think
exactly.
Janelle was like, you got to tell her. Janelle was doing the hands, Miss Gomez.
Oh, the lawyer next to her. I thought you were talking about the prosecutor.
Judge, why don't I do this?
And it's very, very difficult.
Why don't I just tell the court, spoiler alert, this is my direct examination. What is your name? How old are you? Where do you work? Do you have any children? How many? I then will ask him about his daughter Cathy, how old she is now. I will ask if she went to a birthday celebration weekend at Ocean Reef Club for Ceci Pino's birthday over Labor Day weekend of 2022, that his family knew the Pino family, and that when she went to go to Ocean Reef Club for that party, at that time, she was healthy, she was active, a good student, and an athlete, and that after the boat crash, she is very different. She is now bound to a wheelchair. She requires 24/7 care. She has to get therapy for speech, and that this kind of medical care is expensive. That's it.
I'm like, honestly, my mind is exploding.
So my recollection is in the government, in the state's direct case, they asked several witnesses over objection about Ms. Cathy Puig and how she's not in the same condition now that she was before.
They
The
did.
court had allowed that
asked
already
Cecilia
over
that.
objection. This is now trying to
Cumulative.
add.
We're getting into a lot.
No.
Of, you know, it's a lot. Much more expensive injuries, has had extensive injuries to the point where she has continued care and will continue to need care for the remainder of her life.
The defense is, I want to strangle them. Why aren't they screaming relevance? Why aren't they screaming
Well,
prejudicial?
that she's wheelchair bound and that she will need medical care for the rest of her life.
How is this
Hey, Judge.
even rebuttal?
You've established, you think it's relevant over our objection that she requires continued care. I think if that's what you're trying to accomplish, going into the details becomes unnecessarily inflammatory.
That's not detailed. We could go into a host of other issues.
So how come she just
that
gets
Ms.
to
Puig
keep going?
needs, but the fact that she is now wheelchair bound and requires 24/7 care is the most de minimis way to describe what has happened to what once was someone that was
How
able
is
to go
this
on
relevant?
this journey.
She was able to go on the trip as a healthy 17-year-old. And because of what transpired, her life has changed to the point where she will need continuous care for the rest of her life. Continuous
Now you're going to tell him how to answer?
And counsel, let me tell you why I'm comfortable with that, okay?
Why? I don't.
Is because the implication perhaps was that
Cost of coverage.
there was some unreasonable aspect of the pleas remaining involved in litigation with the Pinos.
They needed
But
more.
how is that relevant to this trial?
That issue, okay?
Okay, Judge, that's fine. Let me just make sure that I'm understanding. So Mr. Puig will be able to say now she has injuries that will require care for the rest of her life.
Correct.
Okay.
I am sorry. The issue is that it seemed like they were being unreasonable. There should be a stipulation they were not being unreasonable.
It might have gone somewhat beyond the scope of your questions, but he perhaps left some type of impression.
But how does that impression matter? You're prejudicing the defendant on an impression that doesn't matter, whether
That
or
isn't
not.
even a certain impression.
And it's not right exactly. But even if they're left thinking, wow, those litigious motherfuckers, how does that have any bearing on Lucy and what happened to Lucy? This is, and I don't think the defense has made a proper record in this case. He just keeps saying over our objection to relevance. So yeah, he has said relevance, but he never really, fleshed it out. How
At
is
least state the basic words of relevance, cumulative, prejudicial, inflammatory, like we.
But to say specifically that, Your Honor, I cannot for the life of me see. Your Honor seems concerned that the jury might be left with the impression that what's this family called? What's the girl's last name?
Puigs. The Puigs.
Say it again.
Puigs.
Puigs.
It's Puigs, but it's like Pweegs phonetically. Puigs.
Puigs. Okay. Family was being unreasonable in their litigation. Let's assume, just for this, that every juror believes that. How does that have any bearing on whether or not George is guilty of the homicide of Lucy? And you're allowing this information that you have said before is prejudicial to a certain extent, so you're limiting it. You're letting it in on something that I didn't do, that you're saying the witness sort of kept giving information, but on information that doesn't matter. And again, I would then say, I am comfortable with you or a stipulation that both parties agree the Puigs were not unreasonable in their litigation methods, and they were 100% reasonable. And that's it. Whatever they want. This is, I think, like,
do you think this is actually, I had a light bulb. Do you think this is really because of the insurance guy, or do you think this is because George didn't take the stand, and so they couldn't ask George, like, and Cathy's not the same person she used to be, just like they did with Cecilia when Cecilia was on the stand?
This has nothing to do with, we've already discussed that there's no chance in hell that in the like, I don't even know how much time they had since he's gotten off the stand for her to go and talk to this guy about, I'm going to want you to testify. She talked to him about this long before that. And hopefully the defense asks that question. When's the first time you talked to the defense about testifying here today? I mean, it's hard because it's a victim's father, but I'd be just dying to know.
I know. Oh.
Clear off with the jury, focusing again on this is a criminal matter. This is not a matter involving the civil. This kind of civil litigation.
And so if you're going to allow that, then I would propose as a way to communicate to the jury that a stipulation to that effect.
I remind everyone that the alleged victim in this case is Ms. Fernandez, and this is a criminal matter.
What I mean to say is, I understand that the state would prefer to call the father.
There you go.
So that the jury can see the father. But given that he is not the father of the technical victim of this case, if the court is going to allow the fact of the required continued care for life, it can come from a stipulation of fact rather than creating even more
But it's
theater
the wrong stipulation.
in the rebuttal case.
Judge, I can assure the court that Mr. Puig will not cry anywhere near as much as Mrs. Pino did.
That's fine, okay. We're not gonna do that. I don't think there'll be anything more. I'm not going to, no need to do this through a stipulation. We have the witness here, it's over defense objection, but
Look at Carolina.
Judge, I do also plan on calling Mr. Fernandez.
Carolina
as a
does
final
not like the
rebuttal
prosecutor.
What? Now she's got another rebuttal witness?
This is the final.
Judge,
No,
I
her,
do also
Mr.
plan on
Hernandez.
calling Mr. Fernandez as a final rebuttal witness.
Oh, the father, Lucy's father. So they're gonna put the two dads on the stand as a rebuttal to what?
Ask that. Why isn't counsel saying, what is he rebutting? I don't understand.
State?
Thank you, Your Honor. In rebuttal, the state will first call Rudy Puig.
So would you please step forward, face the clerk, raise your right hand and sworn?
Do you solemnly swear affirm testimony about the truth of looking at the truth?
I do.
Now we're going to see any
May I approach us 1 second, please?
They're gonna keep trying to fight this? Let's see. Oh. Yeah, like, let's see. A minute. No, about a minute.
Good afternoon. Can you please tell the jurors your name?
My name is Rudy Puig.
How do you spell your last name?
P like in Paul, U-I-G.
Okay. As you probably know, this courtroom is large. The microphone, for some reason, was placed over there when the jurors are there.
Okay.
So please try to keep your voice up, okay?
Yes, ma'am.
How old are you?
I'm 54.
Do you work?
Yes.
What kind of work do you do?
I'm a director of business for a security company.
Okay. Do you have any children?
Yes, 3 of them.
Okay. What's your oldest child's name?
Amanda,
And how old is she?
she's 26.
What's your second oldest child?
Rudy Jr., he's 25.
And your third child?
Cathy Puig, who's now 21.
Did your daughter, Cathy Puig, go to Ocean Reef Club the weekend of Labor Day in 2022 for a birthday party for Ceci Pino, the daughter?
Yes, ma'am.
Does your family know the Pino family?
Yes, we do.
And do you, in fact, know George Pino?
I do.
Do you see him in court today?
Yes.
What's he wearing, just for the record?
He's wearing a blue suit with a light blue tie.
For the record.
Stipulate. So reflected.
When your daughter, Cathy, went to go to that birthday party, was she an athlete?
She was an incredible athlete.
Did she go to school?
Yes, she did.
Was she healthy?
Yes, she was.
Now, do you get contacted on the evening of September 4th, 2022 by a man named Hillary Candela?
Yes.
And you learned that your daughter was involved in a boat crash?
Yes.
Is your daughter in the same condition now that she was when she went to Ocean Reef Club?
No, she's not.
Does she now need 24/7 medical care?
Yes.
And is that expensive?
Very expensive.
No other questions?
Thank you. Any questions?
No questions.
All right, thank you so much, sir.
Thank you.
State.
State will call Andres Fernandez. Good afternoon. Just for the record, can you please introduce yourself or reintroduce yourself?
Andres Fernandez.
Mr. Fernandez, were you here in the courtroom when Mrs. Pino, the defendant's wife, testified?
Yes, I was.
Is it the case that growing up you and she were very close?
Very close.
And is it the case that you did attend her wedding to George Pino, the defendant in this case?
Yes, I did.
Is it the case that in your early years of marriage and when your daughter was first born, your two families, the Pinos and your family, were very close?
Yes.
Did the girls go to the same elementary school?
Yes, they went to school together.
At some point, does your daughter wind up going to a different high school than the defendant's daughter goes to?
They actually, in middle school, they began going to different schools.
Even though they were going to different schools, were they still friends with each other?
Absolutely.
But as time has gone by and the girls have gotten older, is your family kind of doing its own thing and the Pino family doing its own thing?
Yes, our relationship began to distance at that point.
Okay. On the actual weekend when your daughter Lucy went to Ocean Reef Club for the birthday celebration for the defendant's daughter, little Ceci, did you have plans to attend a dinner that was the night before the crash happened with the Pinos?
No.
Did you have plans to go the night that the crash happened to that party at The Point that was planned for the girls?
No.
In fact, what was your plan for that night?
I was going to watch the football game with my father.
Okay. Did you have any plans to go out to the sandbar on Sunday, September 4th of 2022?
No.
We went through this already.
But you did?
But I did.
And why did you go?
Because Lucy asked me to go.
Okay, no other questions.
Any questions?
Hello again, Mr. Fernandez.
Hello.
Do you recall that you sent Mr. Pino a text message earlier before the sandbar event, actually telling him you planned to go to the sandbar?
No, I actually sent him a text message the week before. And I had, established communications with him that we were also going to be down there that weekend. But talking about specifically going on Sunday, I don't think I made any concrete plans.
You just hold on one second.
Yeah. Would it refresh your recollection to see your text?
What was the point? Like, just
So
to
that's what
establish
this
that
was
they
rebuttal.
weren't close friends?
Yep, that's what they were rebutting.
They were close friends until the day right before this happened?
No, they
Like-
said when
May I
they
approach the witness
They
to
went
see
to
if something
school,
refreshes his
colleges, or
recollection?
The family separated a little.
Yes.
Does that refresh your recollection that you were actually planning to go to the sandbar on Sunday after you played golf, that you'd be then tailgating? Let me start again.
Tailgate.
You recall writing a text message to Mr.
Objection,
Pino.
this is hearsay.
it's not for the truth of the matter
Did
asserted.
you send a text message to Mr. Pino that said, Billy's on Sunday for me for sure after golf. I'll be tailgating at Billy's for the FSU game on Sunday night. I'm not arriving till Saturday because of Columbus's beach bash party on Friday night that all the kids are going to.
Correct. I had sent, this exchange was the week prior to that weekend.
Okay, so, and that was really the last
Yes.
text message?
Yes.
Okay. So the week prior to that Sunday, does that refresh your recollection that you had communicated to Mr. Pino that it was your plan, at least then, to go to Billy's Point on Sunday after the golf game?
It was my plan then.
Okay, thank you.
Anything else?
last word.
By the time Sunday afternoon of September 4th, 2022 came around, why did you no longer plan to go out to the sandbar?
Because I had, as I said in my earlier testimony, that it had gotten late. That day, we were already running late, and I had plans with my father to watch the football game. So our intention was to no longer go out to Billy's Point.
His tone got very intense and almost like stern and aggressive when he talked about this on direct too. And now that this is being re-highlighted for me on redirect, I'm evaluating it differently. And I feel like this is the same exact thing as somebody making an excuse after an accident, that their ego does not want them to admit any fault, because it's hurtful. It's hurtful to think that had you been there longer, or had you said, hey, don't go at all, or hey, don't go to the party the night before, ride with me out on the boat and I'll take you, I'll be your transporter. But for that, your daughter could still be here. That is a very difficult thing to deal with. And it's making me relate what he's doing here and how he seems so defensive that it was never his intent to go out to the sandbar for this long period of time where he knew his daughter would be drinking and engaging in the usual activities. This walk back, well, that was a week before, I changed my mind. To me, that's no different than somebody getting into an accident and saying something else caused it.
Right.
It's a denial to yourself and not necessarily a denial of consciousness of guilt of a criminal act.
Right.
And I'm not trying to pass judgment on him. This is somebody's being criminally charged here. And this is the evidence that's being presented. And I think this is suggestive of the idea that, he did actually plan to go out there, but because of what happened later, he looks at it differently in retrospect.
Right.
Your Honor, the state of Florida rests its case.
That's it.
All right. Can I see the letters of the court reporter? 20 seconds on it.
Let's see. And what if it's no longer, we heard that Lucy had messaged him, like, making sure, or like, that he would come out to the sandbar. What if that was Lucy, like, I thought you guys were coming, where are you?
Yeah.
Or like, we're going to be leaving here soon. Are you guys going to be coming out here in the next few minutes, like the next half hour or so? Like, we didn't actually see those specific messages, but I mean, to me, that kind of makes it all the more heartbreaking. Like, if you were really originally planning to go there, you changed your mind and thought maybe you wouldn't be able to go at all, but you said, let's make it work because Lucy's really asking us. And thank God you did, because of what happens when all is said and done. Like, that's a really heavy thing for any person to deal with. And I don't think we understand the way our own minds work when we try to deal with things like that, and how we fit the pieces back together and try to tell ourselves what we really meant to do that day or not.
I mean, I'm still shocked that the judge allowed the prosecution to offer rebuttal evidence that tended to establish other crimes not charged in the indictment. Period. How she thought to support a collateral issue, that's what we call that, an issue that's not relevant to the matter at hand, it's collateral. She allowed this. I mean, I'm still just like so shocked by it. I can't get over it, but I guess let's get through this so we can bring the chat back.
Yeah. Get ready, chat. Got a little bit of housekeeping. And then it's your turn.
All right, ladies and gentlemen.
Speed her up.
But we are not going to begin the closing argument.
Okay, well, let's actually get the schedule.
To you, we do not have court on Friday. Courts are closed, it's a holiday. And so because of that, I have to make sure that once the closing arguments have concluded, that I have sufficient time to then instruct you on the law and then have you begin your deliberations. I'm not comfortable doing all of that tomorrow with you, all right? Because again, then we would have Friday, Saturday, and Sunday with no court. So, we have agreed that we're going to have tomorrow off. Friday will be off anyway. You're going to return Monday at 10 a.m., and we will begin closing arguments on Monday, the 22nd, at 10 a.m. And hopefully you should get the case then, the jury should get the case by mid-afternoon, and then you can begin your deliberations on Monday. All right? So that's the plan. So you'll be returning on Monday to the jury room, 10 o'clock. Please put your envelopes inside your notebooks, and your notebooks inside your envelopes. That's what I want to say. Do not discuss this case, please, with anyone. Certainly not with each other or anyone else. Please don't do any research or independent investigation to gather any information outside of this courtroom. That is not evidence. You have all the evidence, okay? And you cannot rely on anything other than the evidence and the law I will instruct you on to ultimately reach your decision. If you see any of us at any point outside the courtroom, we will continue to ignore you. Keep your juror badges well displayed, and I'm instructing everyone also, please stay clear of anyone wearing a juror badge, even if you do not recognize that as one of our jurors. Okay? All right, so we'll let you go at this time. Have a restful and pleasant few days. You should go about your business in terms of work responsibilities or any other obligations that you have when you're not doing it. Okay? Very good. Thank you. All right.
The last thing they got to hear before they leave was 2 family members.
That was marked. This is the thing before I said I was going to wait on the
Yes,
transcript.
thank you. And that would be 38, I think.
Yes, Judge, 8:38.
Okay, thank you.
Mark by his page.
Yes, sir.
And you have to print the exhibit we showed Mr. Fernandez for that.
Yes.
Well, that'll be it.
That's fine. All right, so, our plan is, I think, I'd like to get a good, solid working copy of our jury instructions before the weekend. So I would propose that, I don't know what your day looks like tomorrow, but it would just be for our purposes, with regular, jury will be here. I was thinking maybe 1 o'clock, and here, and we'll work on the instructions. I have your special requested instructions, so I think our focus is going to be on the 2 charges.
Would the court like us to meet here or in 4-6?
You're going to pick up all your items anyway.
Yeah.
So 4-6 is fine. You can use my regular building. Because again, we're not going to have a jury here. So we'll just be addressing the jury instructions, and I can't think of anything else right now, but you'll certainly let me know tomorrow if there's anything else.
Sure, this courtroom is available, given that it's more spacious for the lawyers. Is it possible to
I'm just
stay?
realizing you have a lot of people there. So, all right, it will be available.
Thank you. So we can meet here?
So I'll see you all here at 1 o'clock tomorrow, okay?
Judge,
Ma'am? Counsel?
we just want to address one issue with the court before we break today. So,
Don't you know?
there was an incident yesterday during the state's cross-examination of Mrs. Pino that I would like to just alert the court. Ms. Adams was towards the witness stand and she was facing Mr. Pino, and I personally observed it myself, something of a stare down followed by Ms. Adams rolling her eyes at Mr. Pino. After that, I also know that it was captured by Court TV. It was published. I received a video from somebody that shows that part. I just want to raise it to the court's attention. I don't think we're going to have any of those instances anymore because we won't be in front of the jury. But considering that this is now the 2nd instance, I know that Your Honor, we were in court last Friday. Something happened between them, and I just want to alert the court one more time and just try to avoid any kind of situation like this moving forward. And that's all I know.
Did we get that? Did you get that?
Let me see you all at sidebar.
We can rewatch it.
Myself, and I'm going to put it on the record at sidebar with the court report. Thank you.
Oh, we
She
do this
made
at
some
sidebar?
He made some options. Of course, she's going to talk shit only at sidebar. And I'm
Yeah, because she
hoping
admonished previously the whole open courtroom when I
Right.
was. Do you have something you
She
want to say
said,
to me?
I have observed some things myself. Now, I
Myself.
hope she means about this prosecutor. Can you go find this thing?
Yeah, can we find the chat would probably do it faster than I would. But
Well, when do we know
but
when it happened?
I have Cecilia's testimony clipped. And let's let this sidebar. Let's run it
Wait,
back.
Cecilia's testimony. All right,
That's what
I'm
she
going
said,
to try
right?
to look while you're looking. Yeah.
I clipped Cecilia's full testimony, so if we just go to the part with the redirect, we should be able to look for it. See. I do feel like we commented on her face yesterday. Like, look at her face, but I don't think I thought that she's
Was it
looking
today
at
or
Pino.
yesterday?
Let's see. Let's run this back. I think it was yesterday because they already have the footage from court TV.
Oh, the girl that testified was not
The wife.
Cecilia?
That's
Oh,
Carolina. Carolina
this
testified
is the
today.
wife's testimony.
Hmm?
Okay, I'm gonna see if I can
let's
find it too.
see.
There was an incident yesterday during the state's cross-examination of Mrs. Pino, and I would like to just alert the court. Ms. Adams was towards the witness stand, and she was facing Mr. Pino, and I personally observed it myself, you know, something of a stare down followed by Ms. Adams rolling her eyes at Mr. Pino. After that, I also know that it was captured by court TV. It was published. I received a video from somebody that shows that part. I just want to raise it to the court's attention. I don't think we're going to have any of those instances anymore because we won't be in front of the jury. But considering that this is now the second instance, I know that, Your Honor, you know, we were in court last Friday. Something happened between them, and I just want to alert the court one more time and just try to avoid any kind of situation like this moving forward. And that's all, Your Honor.
Okay. Let me see you all in sidebar because I made some observations myself, and I'm going to put it on the record at sidebar with the court reporter. Thank you.
Oh, okay. All right. So Paige, shout out to Paige, has a clip.
Oh, she does? I was still looking.
Yeah.
Okay.
Yeah. All right, wait, let me figure out. Actually, let me upload
Well,
it
let's
as
get,
media
you
to
know what?
StreamYard.
Let's get
finish
live.
the day, get the chat. Let's finish the, you're right, you're right.
Right, okay.
All right, chat, we're going to bring you back and then we're going to watch Paige's clip. So we're going to, when you get back, yell at Bob, shout out to Paige when you get back in. And what did you want to know people's thoughts on? There was something that you wanted.
I forget. Hopefully they remember because they know I won't.
Is that it? Did they come back?
Yes,
Come back on.
Yes.
I will. I'm dropping the girls off at Target.
All right, love you.
Aw.
Oh. At sidebar, in the record, I was able to address several matters that I need to address in my own observations. So I think that, and I'm hopeful that I have cleared up all of those matters, and we will be able to proceed without any further disruption along these lines. Okay? Other than that, I don't think there's anything else for us today. See you all tomorrow. 1 o'clock. I'll see you. Thank you.
Thank you.
Wow.
I think Janelle held it down.
Remember the petition to expunge that we didn't have the order? I called them and they keep filing it.
All right,
So
this is it.
I see they just keep filing yesterday because I called them, yeah. Because the rest, everything is in order.
All right.
All right,
so,
people. Chat's live. Let's go.
All right, I'll give it. Let's do do you have anything you need to read out? Let's give people some time in here. That way they can comment when we play this. It's an 18-second clip, guys. Make sure you
All
show
right,
some
so-
love to Paige in the chat.
I wrote that let's go just to try and see if it, and then it's
Pushes
weird.
it
It says
through.
this comment has failed to post to Cat Not Williams. Maybe because yours wasn't up yet. Let me try
Yeah,
again.
if you try again, it'll probably go now. Because I saved mine right after you said that yours was live.
Okay, now it went. All right.
I see. Oh, look at this. There's 3 let's go from Defense Diary. So let's get
You
you
guys
on
gotta
stage.
X out and come back.
Gonna move Bob till he comes
Refresh.
back.
Yeah.
And
So she's got it like clipped right at the spot.
it's 18 seconds. I mean, I'm
Oh, boy.
falling into it. I didn't watch the clip, so.
No, good, good.
But I did have this. Did I upload it? There was another clip where it was so stupid, but it was making me laugh when I saw it yesterday. Where is it? I think I might have deleted it. But she was like telling Ed Borrellino Like, how about we do this? How about you go back to your own podium? Thank you.
Yeah, I saw that. Like, come on.
Oh, just hilarious. All right, guys. Here we go. We're going to do the clip.
Wait till they're on.
Oh, wait, this is actually, I uploaded the podium clip.
Oh, Lord.
So I do have the podium clip ready. We can watch that one first, which is not the eye roll clip. I also didn't realize, I think when Cecilia was leaving the courtroom yesterday, she like, you know, when like people cry, they'll go like, and do that kind of like gasp, like they're breathing in air and it makes a noise. Like Cecilia was doing that as soon as she got out of the court door yesterday when she got off the stand. And I didn't catch that while we were watching. This was the podium clip, not the eye roll.
You take your podium, I'll take mine.
Oh, sorry.
Just thought it was funny because the other day she was using both podiums the other day.
I was thinking, I had like thoughts when that happened initially. I don't know what's happening. How come they're not coming back?
I don't know.
Let me try refreshing
Also,
my screen.
I'm going to find another way to, it's like not letting me upload this video to StreamYard. So let me just put it in like a Google
Like
Drive.
I refreshed the stream with the customization. So like after I click save, I refreshed that screen. But yours
the other
should
day
be
it
working.
took a while too. We miss you, chat.
We do.
Probably
We do.
rioting over there, like free them.
And I came in to see, I don't see any Venmos. My Lord. I'm getting hot in here. Take my clothes off.
Yeah, I still don't see it. Anyway, so I mean, I can see chats in the chat. They're not coming through to us on StreamYard. But if you can see yours, I can see.
How would I see mine? How can you see yours? Where's
know.
that?
I mean, we'd have to like watch it through YouTube.
Oh. Oh.
Maybe if we just like go like this, it'll work. Try
Now
to
I'm,
send
like,
something
frozen.
to your chat from StreamYard.
Oh,
And see
things
if it
are
does
here.
anything.
I do see it.
It let mine go through. Who knows? Anyway, since I had to upload the video clip separate anyway,
Bob's
it
calling.
took me some time.
Bob's calling. Hey, babe. Yeah, he's like, the chat's working. We can't see it yet. That's all. Oh, yeah, it's so weird. It says stream this to your audience. What's that? Are we not? What? Has it always said that at the top? Stream this to your audience?
It's if you want to add another destination.
Oh, we're already doing it. Yeah, it's so weird. We have like, we're here. Allie needs to refresh, but it's Cat that it's like the on the screen for Cat and I, not like in StreamYard. All right. Well, we see it. All right. So then.
All right, they're here. They're here. It worked.
Okay. Came through.
Bob did something.
Bob did something. All right.
He
Come on.
fixed it.
Get back here, babe. Everyone's waiting for you.
Is he almost here?
Are you close? Where are you? Bay?
Uh-oh.
Are you close? Where are you?
Uh-oh.
So you're 10 minutes away. All right. Bye. Oh, Courtney beat fact. Factual lie.
Uh-oh.
Yeah, that's what I'd like to know. Hey, Bob, what do you think there?
Yeah, we need Bob. We're gonna save this super chat for Bob. It's a great one. It's so good.
Yeah.
Let's shout out to I want outdoors. All right, so we can watch the clip when Bob comes back too, but do I have this one shared?
Oh, and Tiffany says I sent 2 Venmos. What in the name of all that is? Let's see.
You ready, Allie?
Yep.
State's Exhibit 117, 5X, 118.
I'm sorry, 17.
117, 118. 18.
I feel like I've noticed her like do oddities
I
a few
missed it. I was looking
times.
at the Venmos. Do it one more
Oh,
time.
wait.
Sorry. It's like, how did I miss these?
Oh, I unshared the screen. Hold on. I clicked the wrong thing. This one.
And then you got to pause it right at the eye roll.
It's exhibit 117, 5X, 118.
I'm sorry, 17.
117, 118.
Wow.
Staring at him.
18.
Oh,
And the thing is,
a nod shake.
yeah, so I
too.
say it's not even the eye roll because maybe the jury wouldn't be able to see that from the side. But
Right.
if you do the
Mm.
and like I feel like she's done that at the table several times too. And again, like things happen. People have human expressions, but she made such a stink about George's expressions. And then she made the comment today. She made the comment today like, "Oh, Rudy won't cry like Cecilia cried on the stand yesterday."
I know, her
Like
and her
that
little
was so
digs.
unsolicited.
Yeah. So before we go on, let me just say, because I did see Tiffany's and a couple others. So we've got, let me make sure it doesn't say, all right, Peyton. Hey, Adams, if there's so many boats around, wouldn't it be reasonable that he did hit a wake that caused him to divert course anyways? Ha ha ha, I can't stand her. Love you, Bob, Allie, and Kat.
Aw.
And then we had the Tiffany double ups with Allie. Your rant is all of us right now. Thank you, because it was insane. And then there's a couple more. Oh, yeah,
And
that's
by
the
the way,
same
guys,
one.
the jury is, remember, I mean, they've kind of shown it, like that jury bench is like, I can't like show off the screen, but a little bit further off the screen on this side here, like basically enough for like two witnesses to stand in front of the screen when they need to show something. And then the jury's right there. And George Pino is right next to this camera. So when she's looking sort
Yeah.
of near the camera, but to the side
Right.
of it, she's looking at George.
There's no one else she's
She is looking
like
at George.
shaking her head out. Tiffany also says, "Get it, girl." And then Happy Cammer 28 just says, "Pino trial streaming." Thank you. So I think
And I
that
don't know. Since we have the everybody resting, I usually do a poll when the defense rests, but we didn't have the
yeah,
chat
we
come
have
back.
to. So we should
Did
do.
the state meet their burden beyond a reasonable doubt is the first poll I typically do. And it's a
So-
burden question. It's not a question of for this question that I'm going to put up in my chat. I don't know what Allie will do. It's not a
do I have
question
to
of
do
how
a
you would
separate one?
vote.
I'll do the
You
same
can do
one.
whatever.
I'm
You
going
can
to
do
do the
whatever.
same
We
one.
can do the same.
Yeah, how do
Again,
I
we'll do
forget how to
multiple,
do
you
it.
guys. Oh, go to wherever you can see your chat in your own channel, and then
I
hit the
am.
plus sign. It's like a plus sign.
Oh, the plus sign. Oh, okay. So you're saying start a poll. You're saying do you believe? Not the jury. This is do you believe?
Yeah,
the
has the
state is-
state met its burden beyond a reasonable doubt? And so it's not what you think the jury is going to do. It's not a
So
prediction
let's
of
say,
whether you
do
think he'll
you
get convicted.
believe? Do you believe the state has met its burden? And then you can just say beyond BRD, beyond reasonable doubt.
And
'Cause it
I'll
limits
do
the
yes
words, right?
on both counts, yes on one count, and no.
Okay, wait. So yes on both. Yes on.
One count. Do we know?
Well,
for
we
a
might as
fact
well
that they're
say
gonna do
on lesser,
lessers?
right?
Yeah.
Because either it's both or just lesser. Yes on lesser, and then
Well, it could be a yes on like vessel homicide and not on manslaughter.
yeah, but if a lesser is a lesser, so it would be almost. Wait, you're muted.
I'm muted.
I
you
hear
hear
you
me?
now, so I don't know.
Right, because they could come back with guilty on 2 counts. They could come back as guilty on 1 count. They could come back guilty on just lessers. I think there's only going to be lessers included for the vessel homicide, but I don't know the language. I don't know what they are.
Okay, so I'm doing yes on both, yes on 1 count, and nope. Now I can't hear you again.
I wasn't talking.
Oh, you know why? Because I'm on the screen where I can see you as though I'm watching. So I'm
Oh, you're
watching your
watching in a stream.
yes. So I'm watching your face, and it's like you're talking. Okay. All right. So
Or we
yes
could
on
do
both, yes on
yes on
1,
both.
and yes on 1 count, and then no. Right?
Yeah, so I mean, do you want the yes on 1 count to be 1 count or lessers?
It's whatever I'm going to do whatever you want. How about yes
Yeah.
on? Just leave it as 1 count or 1 count or lessers.
Yes on both counts, yes on 1 count or lessers, and no, not on either. Like, or no full acquittal, whatever.
Okay. Starting.
Starting.
So we have 3
Vote away.
options, right? Okay.
Yep. Vote
And then
away.
we see it over here. Okay, and then I also have Bob did that one. Okay, I think we're good then.
Kylie wants a 4th option.
Oh, Tiffany came back and
Very
said,
cute picture, Kylie.
Bob, you need to speed it up, then slow it down randomly like a roller coaster. Yep.
Oh my goodness.
Today we will be observing 2 people struggle to create a 3-question poll. Stand by.
Oh, Mom of 3. If you missed it, they did the second judgment of acquittal arguments before the state's rebuttal, which is odd, but that's the way they did it, and it was denied.
And the judge,
So
yeah,
they did do that.
She didn't even take it under the
Oh,
advisement.
sorry, my question is stupid. I think I was typing the question while listening to you. I said, has the jury met their burden? It's supposed to read, has the state met their burden?
From your perspective, not the jury's.
And the question is, has the state met their burden, and not what the jury will do? But I mean, we are right now at a 94% acquittal, so that's very different from, like, remember we did the poll like day 1 or day 2, and you might not have been on screen, but Bob was here, and Bob's like, "Oh, Cat's chat is the law and crime chat today." So
I'm at 89. I can only see nope, though. I can't see like how many people voted the other options. Where should I?
oh, you gotta like click it to pull it up. If it'll like expand itself upwards if you click the top of it.
6% yes on both on me, and then 4% yes on 1 or lessers. You know, and that's to them, not to the jury. After this, we're going to ask you what the jury thinks.
Yeah, sorry, my question has the wrong word. I know, I'm not good at multitasking. I'm really not good at multitasking, and I will type the word that I'm hearing. Like, as I'm typing, I will type random words that I'm hearing. Like, it just goes. Oh yeah, that was. Yeah, I think that poll was about the crying.
Which
Yeah,
crying?
I think the first poll we did was about, like, do you believe that this is genuine or faking / manipulative or something, was the first
Oh,
poll.
performative or
Yeah,
real.
something to that, like.
Lady died too, says I vote to convict Adams for getting on my nerves for 2 weeks. And Gina says, to me, the only thing Adams proved was that she needs her diaper changed, Passy and Blanky. It's nap time because she threw her temper tantrums. Huh? I mean, that's legit. That's legit.
I know. I think she's the perfect prosecutor for somebody that thinks that trials are about sympathy. Like, she's the type of prosecutor that would get elected because people said, "Oh, she got justice for Lucy if George is convicted for 30 years."
So
and to me, that's a different stance than, has she like with integrity, argued her case and proved her case to argue the elements of what is charged here.
Got a super.
Yeah, I was like, Christian, that's the perfect question. Perfect timing. Thank you for the super. It says, do you think the jury will feel bad for Lucy? Absolutely. I really think at least somebody on the jury will. And I think that's what the state is banking on. Based on their performance, what they're trying to put in front of the jury, I think it's obvious that they're trying to play into the sympathy. I just don't see how anybody watching this trial could say with a straight face that Laura Adams isn't trying to weaponize sympathy to get a conviction. And sympathy should not play a role in the guilt phase of anything. It shouldn't. The jury's going to be instructed that they shouldn't consider sympathy.
I'm still shocked that she let the father of the other child testify. It seems insane. It really
But yeah,
does.
and in turn ignore the evidence that they're tasked with. I think there's layers to it. I don't think consciously what happens is people will ignore the evidence per se, but they'll take in the evidence with this framework of, oh my gosh, look at beautiful Lucy who had her whole life ahead of her, and this guy stole her life from her. And that's really, legally, that is not the question that's being asked on the verdict form. But I think that's how the question will get processed. And I think that's why deliberations are so important, because hopefully on every jury, there's somebody back there that says, look, this is what we're supposed to consider. This is what we're instructed on. These are the charges. This is how the law is laid out. If we have any questions, we can send a question into the court. But our job is to answer these questions and not consider sympathy. So what do you think, Allie?
I mean, I think you're absolutely right. Like, they're not, it's a subconscious thing. And they're going to want, retribution for what happened to these girls, and especially for, a life lost. I was trying to watch that eye rolling on my screen because I couldn't see. Oh, here, I think this is it.
Do you want to share it directly from the...
Well, it's the same thing that you played. I'm just trying to figure out if I can see it better here, but I can't find the same spot. I think I'm missing it.
Also, are we at 25 now? We're at 25. Holy moly. Let's throw some cowboy hats in the chat for Sheriff Chuck. Just gifting out tons of memberships today. That's 25. And also reminding us of the, correcting us when I say the wrong thing on screen, which I appreciate too. So big thank you.
Very, very generous of you.
It's
right,
his toll for saying we can't come up with 3 poll questions together.
I went up to 8. I got 142 votes, 8% yes on both.
You need to vote in my chat, guys. We're at 60.
I mean,
we're at 85% for no for full acquittal, 10 on 1 count or lessers, and 5 on yes on both.
Wow. You said 6 on 1 count or lessers?
13. Well, it just switched. So 13 on 1 count or lessers now, 82 on full acquittal.
Yeah. Allison Jones says, not proven. And that witch prosecutor needs sanctions. I know toddlers who behave better. Shame on you. I mean, that seems like a running theme. People think she's acting like a little toddler. I mean, when you talk about establishing that there was a lack of sort of, that she was she took this case personally and that was driving her decisions. You've got these 2 instances. And I wish we would one day know what she said, what the judge said on sidebar.
I want to know a few of the sidebars here. Some of the issues were you can tell whatever they asked right before they come back and they ask the same question. So whatever the issue was in that moment, it was overruled. But there were other moments where it was just can we approach before we call a witness? And we didn't really get to even have a hint at what they were talking about. We have a question here from Chelsea. Allie, do you think any of these issues could be used to overturn the case in case of a conviction?
I mean, I do think that the sympathy card and letting the other accidents in, and even like, especially on rebuttal. I mean, I do think that that could potentially be, a big factor.
Deal tipper.
And there was some stuff they didn't let, like, they didn't let the defense establish how much of a relationship the two families had. And then they allowed her to call him on rebuttal to say, we didn't really have that. I don't really care about them. I don't think that one, I don't think that rebuttal is going to mean all that much, but the, like injuries to the second child, that's pretty big. And I think that that has the potential, and especially when the evidence is not overwhelming. I think that the court would say here that the evidence is relatively weak. It's inferential, not even circumstantial. It's like inferential. You have to infer, from the
The course
circumstances.
change was an intentional course shift, and
Right.
not just someone nudging. I don't know how to drive a boat, but couldn't you just like not be paying attention and like suddenly you're drifting, but you don't realize that you just drifted
Right.
because you're like grabbing a phone? Which that's still my theory about like if you wanted me to spell out what I think the most likely thing that happened is, there's that cell phone distraction. That's just, it's everybody gets
Meemaw's
distracted by cell phones.
Meemaw's got jury duty tomorrow.
Oh, let's get some W's in the chat for Meemaw and a fellow cat doing jury duty. Guys, take jury duty seriously. If you know someone that's doing jury duty, like tell them that it's cool. Encourage it.
Yeah. Don't
Unless they're a knucklehead.
Right. Then tell them just get out of it. Say some like offensive shit and get out of
Have
it.
you seen the jury duty show where they stage the one guy to say that he's racist?
Yeah.
To try to get out of jury duty, but they don't. That one guy doesn't know that it's fake.
I mean, that'll do it every time. Or even better to just say that I never believe a word a cop says. I actually disbelieve it. I think that they always lie.
Yeah.
So then let the prosecution use their strikes.
I was gonna say, you let the prosecution use their peremptories. Although that wouldn't just be a for cause?
I mean, it should be, but still keep it on the prosecution side. I mean, you see the judge all the time say things like, but if I tell you that you should, not do that, or you're going to not do that, right? Right. And then Lady Die 2 came back and said, I'm in my 40s, and with so many people watching trial now in 10 years, I feel juries will be more trustworthy. I think you might be right. Seems like older people are selected for juries as the pool. Hey, babe.
What's up, girl? What's up, girl?
We got this poll running on our respective channels. We've got 86% saying the state, from the jury's perspective, the state has not met its burden, so nope. And then 7% yes to both, and yes on one or lessers, both at 7 right now.
So that's not what they think the jury is going to do.
No, I'm sorry. It's their perspective, right? Do they think? Sorry.
Do you believe the state has met? Okay, so it's not what they think the jury is going to do.
Right. That's going to be our
do that
next
separately.
one.
Okay.
Right.
And interestingly, our chat's at 15% yes on one count or the lesser. So we are leaning towards a split the baby type of, maybe could be split the baby, or what you think was actually.
Do you have nope as an option?
The no is at 79.
All right.
And our no is at 85.
Resounding.
Yes.
Resounding. Okay.
Oh yeah, Sheriff Chuck
reminder.
has a question for you, and so does
Oh yeah.
Yeah. Wait, no, wrong one. Where is it? This one.
Oh.
Question for you.
Yeah, Bob.
No, I don't think he'll testify.
I mean,
I have it on good word. He will not testify. Thank you for asking. Proud Boomer. Wow.
Nice. Thanks.
Thank you.
Proud of you
I
too,
can't tell
Boomer.
who those are for, but whichever one. Thanks.
Oh, they're for you.
Oh, well,
Ours have
double
the
thanks.
little paperclip looking thing on them.
I don't see that shit. It's bizarre. Why do you see
Hey,
it and I don't?
are you in the chat?
Yeah.
You have to
Yeah.
look
StreamYard.
over, like, if you hit the star, you can see them in there.
I'm in the start, and none of them have a paperclip.
Yeah, they do.
Not on my end.
Iceman, $10, Agree Alley. You see?
Mine, I'm telling
The
you.
paper clip is like on the profile picture of the
Yeah.
person.
I'm not seeing it.
No,
I don't know.
I'm not walking down there to point it out for you. I'll tell you that.
I'm gonna take a picture so that I can prove it to you.
Yeah, prove it. Prove it.
But I'm in the I was in the supers. I have to find one. Who can I do? Like I could do Iceman. Okay. So you're saying on your end, Iceman has a little picture of a thingy, and mine, Iceman does not.
All right.
Sending to Kat and Bob.
I
To
believe
confirm.
you. I believe
All right,
you.
then I'll just send it to Bob.
Yeah.
If he comes back and like, what do you mean? What about that clip right there's?
He's gonna change the Defense Diaries logo on the background of your your backdrop to just be a paper clip to troll you. The link. It's like a linky thing.
Gerald
Link.
says, I believe he's innocent as far as boating accident. However, he is guilty of providing alcohol to minors. I mean, if he was charged with that, I'd have to agree, you know.
You think jurors will just use the available charges to...
I hope not, but that's been my concern from the beginning, that they're going to be like, well, he should have never had these girls drinking all day and then getting on a boat, period. He's
Honey,
guilty.
these aren't what you sent me are not supers. It's just you just took a picture of the regular chat.
Well, I did the super side too, and I didn't see Iceman because you mentioned Iceman, so that's
He's there
who
at
I was.
10:51.
Oh, there's Iceman. Okay.
Chat wants
Oh
you
yeah.
to see the eye roll.
Oh yeah.
Oh, you got to watch the eye roll. What spot is this at? What time? Because I can't.
If we
I was trying
listen
to
to a
find
word she
that.
says, you can search the transcript and probably jump to it if you just find like 2 or 3 unique words that someone says right here, like the exhibit
Okay.
number maybe.
State's Exhibit 117, 5X, 118.
I'm sorry, 17.
117, 118.
Staring at George.
18.
Yeah. Oh, she did the little.
The head shaky.
Old
All right, I found it.
is over there. I don't know about her. She's too deep in. She's too deep in. Reminder, in a mere 55 minutes, we're live with Judge Carol Erskine.
Oh yeah, we got to wrap up. I've got work to do.
Go through the
because I want to watch that.
Yeah, she's been sending various things. I sent you the
You mean Allie, right? Not me.
Yeah, I sent
Okay.
Allie the opinion.
No,
Can you
I got to
can you
read
give
that.
an elevator pitch quick on who Carol is, a little bit of the case, and why you're going to be talking about? I mean, for those that didn't know, Adam Montgomery's murder conviction was overturned, but not his other charges.
Correct. Yeah. So tonight at 6, she's
It's gonna be great.
It's going to be great. She's phenomenal. I love having her on for multiple reasons, but the main reason is that I don't have to talk much because the judge just takes it away and goes to work.
But can you explain who she is?
Oh yeah.
For those who do not know.
All right, hold on. I got to pull up her full bio.
Well, she's a Massachusetts judge,
retired
Massachusetts judge, and she was personally involved in the Harmony case because she felt that there were like breakdowns in the state with the DCFS, with the police, with everybody, and that they should be looking into how they allowed this child to get placed back with his father. Like among other things, she did like an investigation. She sent stuff over.
Here, I'm going to pull it directly from our thing, Bay. So it's a very thorough. So Judge Erskine served 20 plus years at the First Justice of Worcestershire County Juvenile Court and is a lifelong child advocate, college educator, and adoptive mother. She personally presided over the adoption of Harmony's half-brother. And after the case, she wrote a cruel injustice,
Who's
which is a book,
Harmony?
right, about Harmony, and filed a formal complaint.
For people who
Harmony
don't
is the
know.
child that the
Adam
the
Montgomery's daughter that he
that
murdered.
yeah,
Right.
that he was originally convicted of murdering and now has been overturned because of errors.
Right.
So her sibling was successfully moved to a family for proper care.
Right.
But Harmony, the system did not work for Harmony.
And so,
Harmony
right.
stayed with Adam Montgomery.
Right. And the judge had filed like, she's a true child's advocate, like a children's advocate of the highest order. She filed a formal complaint asking the FBI to open a federal civil rights investigation into New Hampshire's DCYF and publicly questioned the state's $2.25 million settlement with Harmony's mother, Crystal Sorey. Nobody's better positioned than her to discuss all the things we're going to be discussing tonight. So, and she's just great. She can break things down into layman's terms, and she's just super engaging, super bright. She's fabulous guest. Fabulous.
I think it's the best way to learn about, it's not just like if a child needs some type of care, you don't just get blooped up and can just go to somewhere better. Like there's a whole system around it. There's imperfections. It takes a lot of advocacy to try to get the system to improve.
Really does. Really
and
does.
she's been right in the heart of it for years
So
and years.
I've got to hop off and do some work for that.
Yep.
But love you guys, and I guess see
Right
you.
back at you.
Oh, we're gonna have.
When you end your stream, make sure you do a redirect to the Judge Carroll so people can go and hit the
Oh,
notify
Bob will
button.
do that.
I
So
did.
I'll
I
leave
did.
before.
Already did
Okay.
it.
Perfect.
Oh. And we
Mine's
don't
set
end
up
ours.
too.
We wait. When you end yours, it ends ours.
Yeah,
Yep.
so if you're gonna drop off, me and Bob will close out real quick. Bob, you
All
have
right.
you want to answer some questions real quick?
Let's see. And Beto, she said, can they add a contribution to minor charge when giving to a jury? No, they can't. They can't do that.
There is no like, so lesser included are determined by like, they're written as statutes, and there's even like beyond the statute of what would be an allowable lesser included, there are often like bench notes that a judge can look at and refer to when determining, even though this lesser is technically available, does it meet the criteria? Is it something that I can actually allow to go back as a lesser or as a general instruction to the jury? So here, there is no, for the manslaughter or the vessel homicide, statutorily, there is no lesser included that could relate to like boating under the influence or providing alcohol to anybody. And the reason that things are set up that way is a lesser included, it still falls under the umbrella elements of the top charge, which means the defense would properly be on notice to know what they need to prepare for to defend themselves against what they're accused of. And if a lesser didn't fall under that same umbrella with the same elements or less, then the defendant wouldn't properly be on notice if you just decide, oh, at the end, we're actually going to charge with whatever. And
do you guys understand what Kat's saying? It's the elements have to be the same, and for a lesser included, hence the term lesser, you're just having to prove less of the elements, but it's still the same elements. Whereas if you're to drop a new charge on, it's new elements because it's a different crime. So, and you have to prove each and every element of each and every statute that you're charged with if you're the state or if they've charged somebody with it. So yeah, no, they're stuck with what they are, moving forward on right now. And there is no changing that at this point. So, but thank you, Ann.
Yeah. Then I actually did not catch what time they're coming back tomorrow, but it's going to be.
It sounded like
jury charges.
I was listening and watching. I thought she said around 1. I don't know.
So
that's how it wasn't in the morning. It was definitely in the afternoon.
She probably learned not to keep trying to do these things with her calendar calls that are running late every morning. So the last few days, guys, if you missed it in the chat, we've been saying like, hey, Judge Marissa Tinkler Mendez is still doing calendar calls in another courtroom. She handled 2 different calendars for 2 different divisions this morning before coming over here for trial. So maybe she just learned, let me like start this after a lunch break, give herself some time to get it together. So,
Yeah.
okay. Yep. Everyone's saying factual lie says 10.
10.
but everyone else says 1, and then Factual Lie says, oh, I thought 10. So you actually lived up to your name for once. Just kidding.
Oh, zing.
You know,
Zing.
anytime we say something about factual anything, I think of Factual Lie.
Aw.
Like the word factual makes me
Aw.
think. 10 a.m. for Monday for the jury to come back.
So openings Monday. Should they'll
Closings,
get they'll get
arguments,
yeah. Oh, what did I say? Openings? Yeah. Closing arguments. All right. Yeah, I think that's all we got. Did you guys get through all the other soups?
Yep. We reserved that one for you to ask about whether you thought George was going to take the stand.
Yeah.
It took me a second reading it to realize too.
I've changed my mind. Yes, I think George is going to take the stand. I mean, he
All
should.
right, so
He
guys,
really
you
should.
already know this evening, and I'm glad you guys are doing that because I was going to stream, and I had a kerfuffle this morning with another case, so I don't really feel like streaming today. So I'm so glad you guys are doing not just a stream in general, but a stream that you were originally going to do that Sunday night, right? And then you guys rescheduled.
Yeah. It just didn't work because I didn't know when the last softball game, or if we were going to have a last softball game tonight. I didn't want the judge staying up too late. I'm like,
that's
Judge,
when you did the
what's the
proctor
latest?
stream.
Right,
So
exactly.
I was in there and I'm like, I got so amped up, I couldn't go to sleep. And that was right before I woke up at like 4 a.m. to go to Miami. So the proctor stream really pissed me off. So guys, tonight, just starting in about 45 minutes here, come hang out at Defense Diaries for, if you don't know about the Adam Montgomery overturned appeal, Defense Diaries and myself, we both did a video reading the opinions and going through it. So you can get the background real quick before the stream starts in 45. Other than that, tune in tomorrow, 1 o'clock for jury instructions. You know me, I think they're fun. I think they're interesting. I think they're critical.
And in this
important.
case,
Critically important.
They're everything. They are everything in this case. I mean, they truly are. This is a perfect case to kind of drive home what you're saying, just exactly how important jury instructions are, because sometimes, you know, like in cases where it's pretty evident which way the thing's going to go, it's not the case here. Like I think this is a very borderline case just in general, even with the proposition that, you know, we all know juries are there to convict. That's what they have a tendency to do. It's what they want to do. You know, but these jury instructions here, in terms of trying to really kind of define what culpable negligence is going to be interesting to see how they do it. I mean, I think Howard's, you know, really made it a point to say, hey, look, you know, like I'm really worried about this ability for us to be able to kind of define what's what here between
because the
culpable, negligence,
phrasing is going to be reused in a lesser, and we haven't really seen what lessers they want to send back to look it up, but so we'll have to hear that tomorrow.
Yeah, 100%.
But when you have similar phrasing used in 2 different contexts, where it makes it seem like, because to me, vessel homicide is less significant than a manslaughter count, but there's a lesser for the vessel homicide that contains culpable negligence language. Or something to that effect, or maybe negligence and recklessness.
I think it uses the word reckless within it, right? For culpable negligence, you know.
So then I mean, that gives you the circular, incorrect conclusion, but a very common sense conclusion that, well, if we find him guilty of the lesser included for homicide, for the vessel homicide, which has these recklessness and negligence phraseologies, then that means we also met everything for the manslaughter.
Right. You know what it kind of reminds me of is the language from Karen Reed 1, where Canoni just refused. There was it was very confusing the way that the instruction looked. She was refusing to put in a box just to say not guilty. And so it was the things, well, if you do not find
keep going.
Right, keep going. It was very confusing. And ultimately, you know, that proved itself to be true, you know, and even though they sent a question back to Canoni, she's like, I'm not, you know, ultimately she capitulated and changed one thing. She's like, you know, I changed some wording, but the point being the instructions have to be as clear as possible when you're sending them back for the jury, because once you send the jury back, if you're a trial observer, you watch trials, you know that in terms of the way that the judge typically will answer the questions is very, very generic. They're not sitting there trying to give a civics lesson. They're not
I'm
going
not
to
going to tell you how to deliberate.
exactly. So they're
You have
basically
the instructions already. Review
that's
them.
it. That's the number one response, you know. So sending them back as clear as possible at the forefront is of the utmost importance. And that all happens during this thing that we're going to be streaming tomorrow, which is the jury instruction conference. That's when they bicker. That's when they try to land on an instruction. So that's why it's important. So hopefully you guys will come and hang with us.
You've got a final. I've got a final one. You've got a final one. For Dread, thanks for being a member 1 month. Thank you. And thank you for
Love
all
you,
your
Dread.
insights on voting.
Dread's awesome.
Says, I'm sick of Laura Adams acting like the judge. Maybe that's her goal. Maybe she'll be on the bench one day.
Oh, I guarantee that's her perspective path. And boy, I don't want her on the bench. Because I mean, the demeanor's not going to change. It's going to be the same thing. She'll be a hanging judge. Yeah,
It'll be worse.
Exactly. Thanks, Shred. And then Iceman says, member for 10 months. Woohoo! 10 months. Yes. Thank you, Iceman. We love you so much. Bob, you're sure. All right. Yeah. Rage.
You know, you've got something to do tomorrow when we do the instructions. Let's do the what do you think the jury will do instructions. I mean, the poll tomorrow.
Yes.
I think that'll be once we get to hear what they're going to hear as their instructions. I think we'll do that poll tomorrow since you've got to get out of here anyway.
Cool.
My final poll number breakdowns over here were 72% for no full acquittal. The longer we talk, the more they wanted to convict. No, I'm just kidding. And then
mine
yes
went
on
up a
one
little
count
bit
or lessers.
too. Slightly.
Yeah.
Yeah. We ended at 83 at nope. Yes on both came in at 8%. And
we were
yes
19. Oh wait, no, we were 9 on that one.
And we were yes on one count or lessers 9%. So yeah.
We had 19 on that in my chat. So I think we are we've watched several cases.
I think you're
like,
more your people are more pragmatic. Like I think they are. I think they're more inclined to reality. I think
and Andrea's asking if you heard the rebuttal.
I did. I was listening. I wasn't watching. I had it on the car. You know, whatever I could hear above the girls screaming.
Well, I think they want your thoughts.
I was outraged. I was as outraged as Allison and Kat were. I mean, there was absolutely, that was a rebuttal to nothing. It was literally.
When do you think that was the plan?
Do I think that was the plan?
No. When do you think the idea arose that we're going to do this as rebuttal?
Oh, I think that probably arose as soon as they found out definitively that George wasn't going to be testifying. Like that, I think they always kind of had it back there as like, I want to get one last bite at the apple. I want to try to fit a way in to get these two final witnesses just to, like that thing I'm always talking about, wring the pathos out of the jury, get all the emotions going. And that's going to be the last thing they heard. And then when she knew, and she, you know, she's been doing it long enough. She knew that there was a high likelihood that George was not going to be testifying. So, you know, like, and she took the shot and the judge bid on it, which was bullshit, you know, because like the rationale that she gave as to what it was rebutting was absurd. There, you know, because I mean, I'm sure Allison explained, I mean, rebuttal is exactly that. It's not the time to bring in evidence that you would have liked to have brought in your case in chief. It's directly rebutting something the defense put into evidence during its case in chief. And those two people did none of that. So yeah, it was outrageous. It was absolutely outrageous. And, you know, probably impactful.
I think so.
You know, so, all right, you guys, we love you. Thank you so much, mods, for taking care of us when we were putting the chat back up. We love you guys so much. And your guys, like all of our mods have basically been on call, you know, it's like, oh, we're going live, you know, we're going to start the chat. So you guys hop in. We love you so much. Thank you guys for all your generosity today for both channels, all the Venmos, all the supers. It means the world to us.
Thank you.
All the memberships. Sheriff Chuck, you're amazing. Keep giving until it hurts. Because we need Cat's channel growing and growing and growing because she's awesome. And we love you guys so much. If you have the time, come check us out tonight in probably, 40 minutes. So I'm going to try to recharge for 40 minutes and then we'll see you back in a few minutes.
See you guys then.
Love you guys.